Hear ye, hear ye, hear ye. I'm sorry, Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and shall be heard.
Thank you. Please be seated. Good morning. The first case for argument is number 377, People versus Dozier. 377. Good morning.
Good morning, Your Honors. May it please the court, Carrie Connor on behalf of the appellant Plush Dozier. Today, I will be focusing on the total closure of the courtroom during Mr. Dozier's trial in violation of his right to a public trial. The purpose of the right to a public trial is to allow the public to observe proceedings and ensure that the accused is dealt with fairly. In order to close the courtroom over the accused's objection, there must be an overriding interest, the closure must be no broader than necessary, and the court must consider reasonable alternatives even if they are not offered by the parties.
Well, Mr. Zickel argues that it was COVID at the time and the judge had live audio and visual screening going on in the adjacent courtroom so everybody could see what was happening. Is that not a reasonable accommodation given the COVID conditions at the time?
Yes, so given the COVID virus, that is absolutely an overriding interest protecting the public from COVID. The court did attempt to live stream the trial, but unfortunately there were issues with the streaming, with the video feed, with the audio. So it was very inconsistent. When this was brought to the court's attention, there was no attempt to fix the streaming issues. But the court continued with trial and said, the viewing room was sufficient, even if people could not hear or see at times.
So if there were no audiovisual problems, this would have been okay.
Yes, the case law.
It's not the court's order, it was how it was executed, carried out by the technology staff.
Correct. Yes, it was how the reasonable accommodation was executed, given the purpose of the right, which is to allow the public to observe proceedings. And had individuals been able to see and hear consistently, this may not have been an issue, but without the live stream, this was in effect a total closure. Very similar to the United States versus Allen, in which they just had an audio stream, and that court found that it was in effect a total closure when the public could not fully know what was communicated through people's body language. This is very similar, although we have inconsistent audio and video. So even more so, individuals could not hear what was going on in the courtroom at times.
Did the court in Allen order audio only and no video?
That's correct. So the court in Allen, it was just an audio stream.
That was ordered. Here we have both visual and audio. It just sporadically cut out.
Yes, it was reported to the court multiple times that people were having trouble hearing and seeing proceedings, and that was not remedied at any point in time.
But there was an attempt by the court to remedy it as best it could, as I understand it. Didn't the court ask all the witnesses to speak up? And in fact, after the court did that once or twice, it looked to me, based on the record, there weren't any complaints after that. And the witnesses, presumably, then spoke up. So it's not as though the court ignored the complaints or didn't try to remedy the situation. So doesn't that have to be a factor in our analysis?
It does. The issue is that this was not, it was brought up to the court multiple times. Although they did tell witnesses to speak up, people continued to have problems observing proceedings. And that really comes down to the core of the right.
So should the court, in your view, have said, okay, the audio visual is not working out, everybody just come piling into the courtroom?
No, Your Honor.
So what was the reasonable alternative here?
Well, there was no attempt to actually fix the streaming because it was having visual and audio issues. It came down to the technology issue. Other courts have tried to screen people and allow a very limited number of individuals into the courtroom. Whether or not that was available to the court, But it was really Mr. Dozier's family that was having a hard time with this, as one could expect. And even just that limited number of people screening them, there are other remedies that other courts have
So maybe, I
offered.
guess, in your view, the family member should have been allowed to intersperse themselves in the courtroom. Others relegated to the spotty audio visual in the next room. That's one proposal you may.
That is one option that courts have pursued, rather than live streaming
The
trials.
defense counsel asked for any specific remedy.
Defense counsel did not, but defense counsel objected specifically, asserted Mr. Dozier's right to a public trial, and the court just said, well, we did our best, kind of, and we will proceed.
And there's nothing on the record to contradict the court that it did the best that it could to make it a public trial.
Well, what the court is saying, when I say that the court said they did the best they could, they said the viewing room is sufficient to satisfy Mr. Dozier's right to a public trial, even if people cannot hear and see at times. That's what the court said.
I think my point was that in the absence of any suggestion from defense counsel or anyone else as to how to do it better, I'm not sure that the court could be contradicted to say it did the best it could.
I understand, Your Honor. It is the court's ultimate responsibility to ensure that they consider all of the reasonable alternatives to a total closure, which in effect, this was a total closure under Allen.
Was an adjournment of the entire trial an alternative? Your client was out of custody, I assume, at this point, or was he in custody?
He was in custody.
Okay, so that augurs against adjourning it. Right, so, all right, well, we'll take a look at it. We understand it's an issue, and some good arguments being made on both sides in the briefs.
Thank you, Your Honors.
Thank you.
Good morning, Will Zickel for the people. I certainly, as I indicated in my brief, would argue this morning that the accommodation made by the court in the face of what clearly was an overriding interest was sufficient. And in fact, it's hard to imagine the court having done anything more than it did. Now, there may have been technological issues. I don't recall in the record ever seeing a statement that the audio was cutting out or the video was cutting out. There was an indication that some of the viewers in the adjacent courtroom were having trouble hearing. And I submit that was more an effect of a witness's tone of voice and volume of voice, as the court has observed. When witnesses were told to keep their voices up, the problem seemed to be ameliorated.
Excuse me.
So I guess I take issue with any indication that there was a tremendous technological issue with the live stream that was going from the courtroom to the adjacent courtroom. And I also take issue with any indication that the court didn't attempt to fix the problem. It certainly did. Every day the technology that was being applied was checked. As again, the court has indicated, it did what it could during the course of the trial to, keep the volume of the testimony at a level where it could be picked up and could be transmitted to the next courtroom. And as Judge Zampito indicated, he said, sometimes when people are sitting in the courtroom, they can't hear necessarily exactly what's going on from the bench or from the witness stand. So that is an issue which is at least occasionally present, even if there is a full courtroom presence. As opposed to the live streaming of the events.
Is it fair to say that based on this record, we don't know what percentage of testimony was heard by what percentage of people in the other room and what video was or was not seen, what portions of the trial it was? Would you agree with that?
Yes. Yeah, I don't think
Does that matter? I mean, are all parts of the trial equally relevant?
Well, certainly, I think the right to a public trial is very, very important vis-a-vis the testimony, the actual testimony that is that's coming out. So I think that is probably the most important or the most salient aspect of that Sixth Amendment right. Certainly there are sidebars and other communications that go on within the courtroom that are necessarily not audible even to people who are in that very courtroom. So I guess I would agree that there is some gradation as far as that right goes. But in terms of
Mr. Ziegler, did the defendant seek a mistrial or an adjournment to the justice presiding's question earlier? I mean, I'm sort of stuck with the idea that no one had a better idea of how to do it better. Is that
yes,
a fair statement or no?
I think that is a fair statement. Defense counsel was the conduit between the individuals who were viewing from the next courtroom and the court. There's nothing in this record that I saw that indicated that a mistrial was requested based upon whatever difficulties were being experienced by those people. And I don't recall any alternative either that was suggested. And frankly, I don't know what alternative could have been.
Yeah, I don't want my question
applied.
to be perceived as the court has no burden here. The court clearly has
Certainly
a burden to ensure that there's a public trial. That's where it starts. But I'm just curious in terms of once the court takes a position, I've done the best I can, whether anyone had a better idea or anyone had a cure, such as a mistrial, adjournment, et cetera. And I don't see that in this record either.
And that's what goes to the concept of reasonable accommodation. The court does have that duty to make a reasonable accommodation based upon the circumstances in which it finds itself. And of course, those were the COVID protocols. And this was such a reasonable accommodation. That is, the court did abide by the defendant's constitutional right by allowing viewing and audio transmission of the trial to the next court.
Was it equal access to the actual courtroom? In other words, is there any indication that members of the victim's family were allowed in, but not the defendants, or vice versa? Police officer, prosecutors, was it a straight ban on everybody who's not a lawyer or witness? Is that what it was?
Yeah, there was no lottery system or anything like that. Okay, we have 10 seats, and first come, first serve or anything. No, I think any member of the public who was not a necessary either party or other necessary element to the trial itself was not allowed in the courtroom.
So the defendant's family was in no different position than the victim's family?
No, none at all.
All right, thank you very much.
Thank you.
Case number 379 is Jesus Hernandez. 379. Good morning, Counsel.
Good morning. May it please the court, Sabrina Bremer for Mr. Jesus Hernandez. Today, I'd like to focus on two issues in my brief: the suppression of Mr. Hernandez's statements and the Erlinger issue. Beginning with suppression, if this court agrees that the handcuffing of Mr. Hernandez at the outset of the inventory search was unlawful, all of his statements must be suppressed without consideration for whether they were attenuated from his illegal seizure. Attenuation was waived by the people below by their failure to argue it. And even if they had argued it, that was not the legal theory that the trial court relied on in issuing its decision. So this.
Would you agree that the theory attenuation has merit? We have a unlawful handcuffing of your client on a traffic violation when he's a passenger. And you make the argument that that's not lawful, and it's hard to argue with you on that point. He's placed in handcuffs. Let's assume that that's unlawful. Then that's for a brief period of time, correct? Matter of seconds or minutes, but until the gun is found in the car. The driver says to the police, we have a gun in the car. And at that point, I don't think you would dispute there's probable cause to arrest your client for constructive possession of the weapon in the car, right?
Sure, but police conduct must be justified at the outset. And looking at the ideals that the Fourth Amendment serves in limiting unlawful searches and seizures, this is the perfect opportunity for this court to note that the routine policy of handcuffing drivers and passengers in certain areas of the city, simply based on the area in which they're driving, is a violation of their Fourth Amendment rights.
If something flows from that, and that's really the question here, because your client was unlawfully handcuffed while they investigated for no good reason. Minutes later, if not seconds later, they see the gun in the car, so that's probable cause. And they take him to the police station or to the state barracks. You would agree with me, when they took him to the barracks, they had probable cause to arrest him for possession of the weapon, right?
I think so, yes.
So this is not exactly done away.
It is not exactly done away, but looking at the people's burden, once Mr. Hernandez's counsel alleged in the motion papers and at the hearing that these statements were the fruit of his illegal seizure, they were made while he was handcuffed, after he'd been transported, but he was handcuffed the entire time. It became the people's burden to argue attenuation there and show that there was sufficient attenuation. That was not done so below. And as a result, there can not be a decision from this court that attenuation existed, because that was not the legal theory presented below, and it's not what the trial court
So essentially, the
decided.
position, if I understand it correctly, following up on the Justice Presiding's questions, is even though it appears that the unlawful detention lasted for about 30 seconds, I think the cross-examination by co-counsel's lawyer brought out that 30-second timeline. Even though the unlawful detention, which lasted about 30 seconds, was so brief, and even though there was then probable cause to arrest your client for constructive possession, no matter what, that 30 seconds of unlawful detention taints everything else for no matter how long, including for any spontaneous statements. That's got to be your argument, right?
Yes, it is, because that police conduct has to be justified at its inception, and because the use of handcuffs wasn't justified, and because counsel made the argument these statements are the fruit of his illegal seizure, they were made less than 2 hours after his arrest, that put the people on notice that they had to argue attenuation. And because they didn't, Mr. Hernandez was also deprived of the opportunity to fully litigate the attenuation claim below.
Counsel, can I ask you a question? Was the gun in plain sight in the car, or was it in her purse and she admitted that the gun was there?
She admitted that the gun was there. It was found in a black bag on a floorboard, and she was the one. Sorry, Justice Selcock.
I didn't mean to interrupt you.
Oh, yes.
I was sighing here, but because I think what the people are going to say is, you may be right. We didn't specifically argue attenuation, but the court nevertheless decided those facts in our favor below, and therefore it's before this court.
I don't think finding those facts is sufficient for this court to then make a finding of attenuation. Those, looking at how issues are preserved, it would have to be, the facts alone are not enough. It has to be the legal theory that was argued below that the trial court ruled upon.
Right. That's your response to
Yes.
that.
Yeah, this case,
It's a bit of a flip-flop here. You're arguing that their argument isn't preserved here. And
Yeah,
therefore, I mean, because on one hand, they have a fairly strong argument on the merits if they had presented that below.
perhaps, but it wasn't fully litigated. So perhaps trial counsel would have approached cross-examination differently and would have made different closing arguments had attenuation been raised below.
Or by the co-defendant, as it relates to the co-defendant too, who was joined for the suppression hearing.
Right.
yeah, I think you would agree, this argument, the suppression issues were not thoroughly argued on either side below, right? There were two lawyers, one for the driver, one for your client. The driver's lawyer made no lawyers. He just said whatever he said, right? Your client's lawyer said the closest he came to preserving this, like he never mentioned Dunaway. He never said the statement should be suppressed even if voluntary because they're the product of an unlawful arrest, which is the Dunaway theory. He doesn't mention any of that, but he does say, there's a line in there about my client was handcuffed for an hour and a half. I guess that you think that's enough to raise this Dunaway issue and then shift the burden to the people to argue attenuation, or because it's really not attenuation. And Dunaway, Justice Brennan talked about some intervening act. And we have that here. A new crime. Dunaway, there was no intervening act. So again, I think Justice Kern brought out the point, I think you didn't disagree with him, that if the people made the right arguments, they win. You're hoping to win based on the people's failure below to make the right arguments. As a matter of fact, they made no arguments. The lawyer who argued this case had absolutely nothing to say for the people at the end of this hearing, in writing or at the immediately following the hearing orally. And so that's really what you're hanging your hat on, if I'm not mistaken.
Sure, but I will say that in the motion papers, Mr. Hernandez counsel noted that the custodial detention of Mr. Hernandez was not based on probable cause, and therefore any statements were fruit of the poisonous tree and must be suppressed. And he does also make the comment at the conclusion of the hearing, although he does not cite Dunaway in particular, it is clear that the seizure is unreasonable, and therefore the statement should also be considered the result of an illegal search and seizure.
He didn't say anything about the CPL provision where the police have to tell you why you're being arrested.
No.
That's, you raised that for the first time on appeal?
No, in terms of whether or not there was a lawful basis, none was presented. So in my opening brief, I go through, there's no probable cause for arrest here. There's no reasonable suspicion, no articulable facts to justify the handcuffing at its inception.
Right.
No. Unless there are any further questions, I'll move on to Erlinger.
Yeah, Erlinger is unpreserved. We see this all the time. The Court of Appeals saw it in Hernandez and said it needs to be preserved. They can't reach an interest of justice. We can. So really, that's what it comes down to, is should we reach an interest of justice? And you want us to do that?
Yes, I think that the interest of justice is warranted here because not only is Mr. Hernandez being sentenced to 18 to life based on this persistent violent felony offender sentencing scheme, defendants across New York State are being sentenced differently depending on how trial courts are reading Erlinger, interpreting how it impacts these sentencing schemes. And so I think that the interest of justice is warranted here because this court does have the unique power to review the issue in these circumstances. And here, Mr. Hernandez attempted to contest the tolling calculation and only abandoned that request upon the court bolstering the benefit of keeping that same attorney. And so I don't think that his waiver here was knowing, intelligent, and voluntary.
If you're right, and we reach in the interest of justice, do we send it back for a jury trial on that issue, or is it too late and he just gets first-time felony offender status sentencing?
I think that he could get right now, because there is no procedure under New York law to hold a jury trial on the issue, it would have to be remitted for a first felony offender sentence.
All right, we understand. Thank you very much.
Thank you.
Good morning, Your Honors. Heinrich for the people. I would just submit that this case is kind of tailor-made for the attenuation doctrine. That was clearly at play here. Unless court has any questions.
Well, you come up with some better arguments than your colleague below. No disrespect to that attorney, but you would agree none of this attenuation, intervening cause was argued by the people, right?
Sure, but I think based on what the judge clearly, what the trial court based its opinion on, based on the statements that he made in his findings of fact, that effectively that was before the trial court. Based on the facts of the case as relayed by a trial court and the decision that he made, that was effective.
Yeah, I read Judge Dowlinger's decision to say that the first statement in the barracks, I think he said in his decision it was on the way to the barracks. I think the record reflects it was actually at the barracks. Agree with that factual? Not that it matters much.
Sure.
That was spontaneous.
Correct.
That's different than, because it can be spontaneous and still suppressible under Dunaway, right? Correct? Like if you're unlawfully arrested, it doesn't matter if it's spontaneous or not. You shouldn't have been there, right? That's the whole idea.
Well, I just, first of all, the people aren't obviously appealing. And I think the facts of the case and the law based on what the court stated. I just think that it's,
Well, counsel, let me ask it this way. How do we read the decision below as to know at what point the judge said there was a break in the chain?
Mhm.
What untainted, for lack of a better word, what untainted the unlawful detention? Because the judge doesn't say what happened. I mean, you make the argument it could have been her statement, it could have been finding the gun, it could have been a couple of other things. But I don't see that in the decision. Do you?
Mhm.
And if that's not there, how can we reach it?
Well, Your Honor, I would. In my opinion, it's just plain from the record here that there was attenuation.
Well, I agree. I mean, you make a good argument.
Sure.
But it has to have been before the court below. That's where we're struggling, or at least I'm struggling
Right.
with this issue.
Obviously, unfortunately, it would have been much easier for all of us if you know, that would have been, was argued and,
Would be easier for the defendant, but in any event, the Dunaway argument presupposes that the defendant is in police custody here at the barracks unlawfully. Your argument, is it not, that because there's probable cause to believe at the scene of the traffic stop that he committed a felony, he was not at the station unlawfully?
correct,
And that's why this is different than Dunaway.
sure,
The brief illegality here was the detaining him in cuffs, which was absurd on a traffic violation of this nature.
Mhm.
So there's definitely Fourth Amendment violation there, but your argument is that when we're looking at the statements, is was he in custody lawfully at the time he made the statements? And your answer would be yes.
yes, correct.
This case is just, getting back to the Justice Poseidon's question and the others, but none of this seems to have been teed up on either side below. I mean, now we have an argument, okay, unlawful detention, you need attenuation. You then counter to say you do need attenuation in your brief. You say that, as I understand it.
Correct.
But if it's based on the probable cause arrest for the constructive possession of the weapon, the spontaneity in itself probably is enough.
Correct. I would agree, Your Honor.
But we don't have a decision that says that, because the decision was based on the arguments you presented, which didn't make that argument.
Right. I would agree.
To be fair to the trial judge here, the motion court, he decided what was on his plate, and neither lawyer gave him very much to eat.
Mhm.
And these arguments are all entirely, it's easier for us. We have the benefit of a transcript and we can sit back and, oh, you should have done this, shouldn't have done that. But he was presented with certain arguments that he decided, and he didn't, it's arguably whether he even got to these, but we have to take a look at that. That seems to be what it is that if the right arguments were made, the people win. If they weren't, the people lose. And so it's an unusual case there. It's really not about the merits. It's about the procedure and what was preserved and what was argued.
Correct, Your Honor. I would just submit that it would be beneficial if below, and I guess that everybody would have been more thorough, but that's not what happened here. But I think that based on what the court decided in terms of the facts and the decision that the court made, that I believe that it's preserved. And I suppose the merits speak for themselves.
Last thing, would you concede that it was unlawful for the police to handcuff, or the troopers to handcuff the defendant before the gun was found on a mere traffic? So he wasn't even the driver.
Yeah, again, it's odd that essentially the testimony is that we do this in Rochester all the time. As
We violate the Fourth Amendment. I mean, I was a little surprised.
Right.
Our policy is to violate the Fourth Amendment on a regular basis. That's
Yeah.
interesting testimony.
That was unusual. I can see that. But I just think that after that, the attenuation speaks for itself.
All right. Thank you very much.
Thank you.
Case number 380 is People versus Ricardo Casiano, number 380. Morning, Ms. Weiss.
Good morning, Your Honors. Clea Weiss for Ricardo Casiano. I'd like to address the suppression, the trial errors, and the sentencing. And I'd actually like to begin at the end and begin with the sentencing. Talk about what happened that night. It was rather a tragic night for the whole neighborhood. The neighbor is in an argument with Mr. Casiano's older son, and he comes to their house, their family home, and he stabs his younger son in the neck. And he punches Mr. Casiano's wife in the face so hard that her jaw is broken. And when Mr. Casiano arrives home a few minutes after this has all happened and there's blood everywhere, his son is bleeding, and he undertakes to defend his family. And I think that that impulse is common to all of us when we come and see that our family has been attacked in our home by our neighbor. And we want to do something to make sure that the neighbor is not coming back to continue his attack. And I think just those circumstances alone make me think about what is the appropriate sentence for somebody responding to their family being attacked in that manner. Mr. Casiano had no criminal justice system involvement for 24 years. He's been with his wife for 22 years. They have 3 sons. They've been living here humbly in Rochester, building a life in the community at the schools their sons go to and at church. The record has letters from his neighbors who notes that he helps out in the community. And for 5 years prior to his arrest, he's been a machine operator at Klein Reinforcing. The vice president of that company submitted a letter that's in the record saying, we can't wait to offer him his job back.
He got 7 years determinate on CPW's second 2 counts. What was the sentencing range? Could you remind me again? What was the minimum that he could have got?
The minimum was 3.5 years determinate, and that was the plea offer made by the judge in this case prior to trial. So after trial, he ends up with a double of what that sentence is. And I think, Mr. Casiano has suffered tremendously from this alone. He's 48 years old. He's got serious injuries from that night. He's got nails and a plate in his leg, and he's going to be struggling with walking for the rest of his life. And when Mr. Casiano is released, he's not being released into a vacuum. He's not somebody who doesn't have somewhere to go and no community. His family showed up for every court date. His family is here in the courtroom today. They are waiting for him to come home so that they can take care of him and so that he can resume his life as a productive member of this community, working and taking care of his family. So this is not your average CPW2 case. And I think that the sentence of 7 years is excessive from a retribution standpoint. And I think it's wholly unnecessary from a deterrence or rehabilitation standpoint. Mr. Casiano should be back in this community, taking care of his family again. And doing so, he'll be on PRS, of course. There'll be 5 years mandatory or not 5 years, sorry, that was a mistake, but there is PRS as part of this sentence. There's no questions about the sentencing. I'd like to talk about the suppression. And again, starting with what happened that night, where the police first encounter Mr. Casiano in the backyard of his home. And I want to talk about the custody analysis in the backyard, because that goes to the statements that he made in the backyard, but it's also important to the later statements for 2 reasons. One is because the statements made in the backyard are important under a cat out of the bag analysis for the statements later made in the hospital. And it's also important because if he's in custody in the backyard, that shapes what a reasonable innocent person later in the hospital will feel as to whether they're in custody in the hospital. Because if somebody knew they were in custody before, they're probably thinking they're still in custody. And I think looking at whether he's in custody in the backyard, the place I go to is the first thing the cops say to him, which is don't move, don't effing move. Get on the ground.
Cops see him, don't they, on the roof? They see flash, right?
That's correct.
And so they know that this is a shooting that's in process. I mean, they have to kind of secure the scene. Would you agree with me on that?
So I think, and the people use the term active scene, and I think that's accurate. They are coming into that backyard, they are taking control. And I'm not arguing, to your honor, that that's unjustified. Sure, if there's gun violence, the police do come in and they secure the scene and they make it safe. But he's in custody when that happens. When they secure the scene, the main part of what they're doing, they believe Mr. Casiano is the main suspect who had been on the roof. They're taking him and he's not free to leave. They have secured the scene.
Doesn't the fact that there's significant evidence against them at that point support your argument that he's in custody?
Yes, and the police, when they come into that.
There was no, I watched the video, as we all have.
I mean, when they come into that backyard.
There's no mystery that in the police's mind that he was the guy on the roof shooting. That the only issue was where did he throw the gun?
100%.
They're sitting there for, I don't know how long in the backyard while he has a broken leg, your client, and they're searching and the backyard. I wouldn't describe it as a model of neatness. And so it took, they just couldn't find it for a long time. And I guess your argument is your client has a broken leg, he's complaining, and the police are basically saying, if you tell us where the gun is, we'll get you to the hospital sooner. And that leads to some involuntary statements.
I think that's correct, right? They say the ambulance is going to get here a whole lot quicker if you tell us where the gun is. And I think that delaying of medical aid goes to the involuntariness of the statements, quite apart from whether he should have been read his Miranda rights.
Go ahead, please.
The other way of looking at that statement is, we're not bringing an ambulance to disturb this area here until we find this weapon. I mean, it's clear in looking at that video that the police are occupied with trying to find the weapon. Having that weapon lying around somewhere in that backyard or who knows where close to it is not what they're supposed to do. They're supposed to find the weapon. So I understood in your brief why you put that in there, but then listening to the video and showing these officers running back into an unknown dark backyard with someone firing a gun, and then they need to find the gun. The idea that they're going to bring an ambulance in who can, mess around the area so they can't find the weapon. I'm not so sure that was a deprivation of medical care in order to get them to talk. I think it was a common sense approach to say, we're not bringing this ambulance back here. It's going to just, destroy what potentially evidence. So I'm not sure that gets you there.
Well, I think in terms of involuntariness, I understand what Your Honor is saying, that there may be protocol. You don't allow an ambulance or you don't allow somebody to exit a backyard until you have secured the scene. But I think that unquestionably that goes to that he's in custody, that no one's allowed to come in, no one's allowed to go out. They won't allow him to communicate with his wife at that point. They're threatening to shoot the dog repeatedly and gleefully. And I think that makes, because he's being interrogated. Where's the gun? Ricardo, tell us where the gun is. Come on, buddy. We can make this a hell of a lot worse for you. There's interrogation. He's in custody and he makes statements which the officers are sympathetic to. Well, my son just got stabbed. What would you have done? The officers kind of nod their head to that.
It seems like the argument, which is a good argument, that, hey, before we allow people, medical personnel, we want to make sure this gun isn't there. Now, the gun's not a bomb. Okay. Somebody has to actually fire it. And it would seem like the police, there were so many police officers there. Your client was standing for a long time. It's not like you just help him off like he's a football player off the field and bring him to the front yard and take him to the hospital. And then you search for the gun. Like the medical personnel didn't have to go rummage around in the backyard.
I think it's important to note for Your Honors that the gun is actually not found until Mr. Casiano leaves. They do eventually, the officers turn their body cameras off, which is a little troubling, but they do allow him to leave. And then after he has left the scene is when they bring a dog who can sniff explosives in, and then they can find the gun.
Let's say the panel were to agree with you on the fact that your client's in custody, and let's assume that some of these questions, he was being interrogated. The main statement in the backyard, correct me if I'm wrong, from your client, comes at 1640 of the video or so. Your client says, he stabbed my son. What would you have done? Right?
Mm-hmm.
Your client says that. This is the person your client allegedly was on his garage roof shooting at the neighbor who stabbed his son. That, as I watched that video a few times, that statement did not seem to be in response to any questioning from the police officer. The most immediate question the most immediate statement from the police officer at that time was, I don't hold anything against you. Meaning, he's clearly upset that Ricardo wasn't going to tell him where the gun was. But then the officer says in a calm voice, I don't hold anything against you for not telling us. Then your client follows that up with a non sequitur of, he stabbed my son. What would you want me to do? So how do you respond to the argument that is a spontaneous statement, not even responsive to police question or interrogation?
So I think that goes to the fact that it's not about express questioning. It is statements designed to elicit incriminating information. That's the standard under Miranda. And police frequently are sympathetic towards defendants and express, concern with them, because it does elicit conversation. So the police is they're being sympathetic to Mr. Casiano, and then he makes this statement. So I don't think, is it like an express interrogation like some of the other questions that they're asking him? No, but it's part of a conversation that the officers are facilitating with Mr. Casiano to get him to provide information.
And And I agree with you. When then we get to some straight up interrogation, actually it was earlier at 11:48. Before that, a flurry, a bevy of questions from the officers. Where's the gun? Where is it? The guy said they saw you on the roof. Where'd you toss it? You're saying that the defendant's response to that should be suppressed.
Yes, and I think
But that response was, I didn't toss SHIT, right? That was your client's response. And that's what you want suppressed.
so. My main concern is actually the suppression of the hospital statements. And I think that it's really important to look at the situation in the backyard, the interrogation in the backyard, because all of that shapes what happens about 2 hours later in
I
the hospital.
agree. I just wanted to try to narrow it down because we have backyard statements and then we have hospital statements. The backyard, I think we've limited it to, he stabbed my son, what would you have done at 1640? In the prior statement, I didn't toss anything, if you will, to clean it up. That's not inculpatory, that I didn't toss anything. That's exculpatory.
Right.
So that's all we got in the backyard, right?
Yes, I think
And then we get to
Yes.
the hospital, where you have a much better argument that he's being, well, you have a strong argument he's in custody. And the questioning is accusatory. Thus, there should have been Miranda.
so.
But what did he say at the hospital? He repeats the same statement. He stabbed my son. What would you have done? Right? That's one of the things that the statement at the hospital he wants to press.
So the hospital is more of a full confession where he talks about purchasing the gun and keeping it in his home to defend his family and how he never used it for 8 years, but finally this was the night he had to defend his family.
Those were post Miranda statements.
No, he is never Mirandized in this case. There's no Miranda at the
There was
hospital.
a written statement, and then there was this. He stabbed my son again at the hospital, right?
So you've got the backyard statements. They take him to the hospital and then the interrogator shows up at the hospital and records
Right.
a whole interview with him.
Repeats almost verbatim this, he stabbed my son, what would you have done?
Yes, and he provides more information.
So if the statement from the backyard's admissible, then there's no harm in that evidence coming in again, right?
And that would go to my cat out of the bag argument, so that now he's already made this statement in the backyard, they stabbed my son, what would you have done? Which essentially is an admission to being the man on top of the roof, shooting the gun, which is enough to satisfy the elements of the 2 crimes that he's charged with. That cat is out of the bag, and now he's being interrogated again at the hospital, and he's thinking, well, I've already said that, they already know that, so I'm gonna keep saying it and keep talking it. And I think that while I do think he is in custody at the hospital, and I would address that, even if your honors determined that he was not in custody at the hospital, the statements made in the hospital are a fruit of the earlier interrogation that happened in the backyard. So if you would suppress the backyard statements, I think that the hospital statements are a fruit of those statements because the cat is out of the bag.
What's the remedy if we hold, just assuming arguendo, what's the remedy if we say that the backyard statements were spontaneous, even if he was in custody and not responsive to any sort of question? So that would still be allowed. But if we found he was in custody in the hospital and there's a male voice that comes on the tape at one point that has a pretty straightforward accusatory question, as I recall it. Let's assume we find it's accusatory, no Miranda, therefore that's suppressed. What's the remedy that you're seeking in that event, if that's the choice we made?
So if that was the choice you made, then the hospital interrogation should be suppressed, the contents of the hospital interrogation. And that is admitted. The full interrogation is played to the jury. They ask to hear it again during deliberation, so it's played twice to them. And I think our law we have so much case law about confessions because the nature of a confession before the jury is that they give it so much weight. You're hearing the defendant's own voice, his own words, admitting to something. And that is not harmless in this case. I know there's probably some cases where a confession can be considered harmless, but in this case, you've got his direct confession in the hospital, and all the other evidence in this case is circumstantial. It may not be the weakest circumstantial case, but it is circumstantial evidence, and versus the confession, which is really the direct evidence where he says, yeah, I had bought a gun and I kept it in my house for 8 years.
Could we parse it slightly different, more favorable to the people, and say the defendant's first statement in the hospital about he stabbed my son, what would you have done, is harmless because he already made that statement in the backyard, not in response to any question. I know you disagree on that, but let's say we go that way. But the police did not stop at that point. The investigators, and these were investigators.
That's correct.
Who say that they were asking general investigatory questions to find out. In the video, everybody knew what happened.
Correct.
There's no need for investigatory questions at that point to find out, okay, who's what happened here. They were asking they were trying to elicit incriminating information, and they did so, but could we parse it out and say, he was asked a lot of questions, where'd you get the gun? How much did you pay? I mean, suppress all that, but not this, he stabbed my son, what would you have done? Which he may want in anyways, at the trial. It's something that kind of explains
But I think
behavior.
the remedy is still that there has to be a new trial, because that whole audio tape of the hospital interrogation is admitted. And even if your honor said the part we're not suppressing is the same statement he made in the backyard, even leaving that, I think the portion of it that did come in and was played twice to the jury is still not a harmless error.
Gotcha. Anything further?
I would briefly address point 3. In New York State, you get 2 bites at the apple when you're the defendant. You can litigate your suppression issue, and if you lose, then you get to litigate it again in front of the jury. And there's clear case law from the Court of Appeals that says that's not just to voluntariness, it's also as to Miranda. Unfortunately, the trial judge was unaware of People versus Graham, and interrupts the cross-examination to stop Mr. Casiano's defense counsel from relitigating Miranda. The people see that this claim is unpreserved, and I want to push back on that because counsel is asking questions in cross-examination. He is eliciting questions. He's pursuing a course of conduct to get this information. And then Supreme Court comes in sua sponte, it's not the people's objection, and makes a ruling. And that's what you need for preservation, is the court making an express ruling on the issue. And I think the people are, by claiming that it's not preserved, they're trying to sort of import the old requirement that you must take an exception to every court's ruling. But that's not the rule for preservation. Just because this was a sua sponte ruling by Supreme Court doesn't mean it's unpreserved. Defense counsel was prevented from doing the cross-examination about Miranda that he was attempting to do. So that was one of the trial errors. And then again, as to the involuntariness, defense counsel had pursued a strategy of showing that during the hospital interrogation, Mr. Casiano was on a bunch of painkillers, which is on the video. He says, or on the audio tape, he says, I'm drugged up. I'm in a lot of pain. He's got a bone sticking out of his leg. He's really stressed out. His first concern is worried about his son, who's in the pediatric emergency department getting stitches from being stabbed. And the people are arguing on appeal that the mental and physical condition of the defendant is only the mental and physical condition as caused by the police. But if you just read the CJI, or you read this court's decision in Knapp, which held that statements are not voluntary in light of a defendant's intellectual disability, and clearly the police have nothing to do with a defendant's intellectual disability. And the Supreme Court's decision in Mincy versus Arizona, which is more similar to this case, it's about somebody who's on painkillers and in the hospital after an accident. The people are arguing that this instruction on involuntariness was correctly denied because the police didn't cause Mr. Casiano's injury, or the fact that he's on painkillers. But defense counsel was pursuing a strategy of showing that Mr. Casiano was out of it in the hospital, and therefore, because of his physical and mental condition, his statement should have been considered involuntary. And the CPL uses the word must. When this is put into issue, the trial court must give that instruction. It was denied in this case, and that denial was error. So in 2 different ways, Mr. Casiano was denied the ability to litigate Miranda and to litigate the voluntariness of his statements at trial.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. Ron Ash for the people. You have a specific question about this case?
Yeah, there's a lot there. Where do we start? Let's start in the backyard, where the case kind of starts.
Okay.
Briefly, when the police say, let's talk about custody.
Okay.
The police arrive, shots fired, guy in a garage. They see the client here. They order him to freeze at gunpoint. I think, don't move. I hear over police radio, somebody says, when the cop says, we have the suspect in custody. You would agree he's not free to leave at that point. If he's like, hey, I want to head out of here. See you guys later. That's not happening, right? A reasonable person would not think that that's going to happen.
A reasonable person wouldn't think that Mr. Casiano would be able to leave, because the leg injury, I think, is a huge complicating factor here. that we do not have in many other cases that we are relying on, or otherwise they're being, decided at the trial level, that gives us this experience that we get to draw on. Though this is an immensely complicated case, and it is not one where you can take a small soundbite and try and describe what's going on. I'm not going to try to describe this case in one sentence, and I don't think that any one sentence was going to be able to describe it, because they show up to an active scene. There's a question about whether or not this shooting was justified in the inception. There's a question about what exactly happened. Is this is the guy who was on the roof. Is he the guy who was on the roof? Not everybody who was present saw who was on the roof. Certain officers saw gun muzzle flashes, some didn't. Then there was a question about how he got down. There was a question about, did he throw the gun? Did he hide the gun? And they were trying to get a dog in. They were trying to get an ambulance in. The police officers had to jump the fence. And there was a question about whether they would need to take the fence down to get him out on a stretcher, I believe. And so I think that the word custody going out over a bulletin or a radio call, that might be thrown around more loosely than what I would probably throw around. I think that it's also important to remember that a seizure for purposes of a traffic stop, or this is not what happened here, traffic stop or a DUI investigation, those often involve questions about what's going on.
So could this be viewed, instead of he was in custody for where they need a probable cause, he was being detained for investigatory purposes, which would have level 3 of Hicks detention?
That's essentially at its core our argument, because the scene is so complicated, it is still an investigatory process.
Right.
He's not.
Would you agree with me, once we get to the Strong Memorial Hospital in the trauma bay, it's not, they're not detaining him. They have probable cause. He's admitted in the backyard, essentially. What would you have done? He stabbed my son, and the police knew that he was, they weren't trying to sort out what happened. It's clear just watching these videos. They knew exactly what happened. The only thing they didn't know was where he threw the gun or hid the gun at that point. Well, and there was no Miranda at that point. And that's the issue here is, was it just investigatory then?
Your Honor, I would point that although the police as a whole are, an entity, but these, at the facts specific here, are that these are not they're, like you pointed out, they're investigators. And although they are trying to solve this crime in a sense, they are not the responding police officers who were the witnesses. And I believe her name is Investigator Bauer. She testified, and her testimony was credited by the court. We don't have the benefit of seeing her in person. She testified that she didn't exactly know the nature of his injury. She knew a little bit about what was going on, that there was an active shooting, but that's essentially what she said, go investigate this. And this is a little bit of a backwards reasoning, and I understand that this argument can't hold in every single case, or otherwise it would be perfect. But she does say the reason we didn't tell him about the recording device was that because we didn't think he was in custody. We didn't do anything to detain him. He was in the bed and he was confined to the bed.
They didn't really need to do anything to detain him.
Well, right, and that's what I mean. It's like he was confined to the bed, but not by anything of the police is doing. It wouldn't have mattered to these investigators whether or not he was confined to the bed. They could have approached him and had this same conversation with him with a discrete recording device if he was up and walking around. And they did nothing to cause his detention here. And I don't think, Your Honor.
Yeah, I mean, Investigator Bauer kind of asked questions, it seems like she's trying to figure out what happened, but the other investigator clearly was asking questions. You got a gun, where did you get it from? How long have you had it? I mean, those aren't really investigative, trying to figure out what happened earlier that night.
I do think they did know, they knew that a shooting occurred, yes. But I believe that it's still important to remember that, and I would obviously defer to the record, but I believe it comes out that they didn't know that whether this was who was involved in the altercation in the first instance, because there was for lack of a better term, off the top of my head, a home invasion of sorts. And then there was a shooting in retaliation by someone who lived there.
Sure, and they went to go investigate the son, I think, or talk to the son before they talked to Mr. Casiano, I believe.
Right. And I think the important thing to remember is that at this point, I'm personally not sure at what point he was involved in that original altercation. Had it completely dispersed, or was he involved in the initial one and this is a chase situation? And I think that the investigators are still investigating that
Right, but
when
that
they
would-
talk to him.
That would go to the count. There's two counts of TPW. One is for intent to use unlawfully. The other is for simple possession outside the home, which is a different issue we haven't gotten into yet.
Right.
But a lot of questions from the male investigator, as Justice Kane has indicated, were geared toward the simple possession. Where'd you get the gun? How much did you pay for it? What caliber is it? A lot of follow-up questions on the simple possession offense that weren't really necessary to what you're talking about. We're trying to find out if it's self-defense or not.
Yeah, there could be another issue about licensing. There could be these issues where the investigator could be like, where did you get the gun? And that sort of thing. And the answer could very well have been, I bought it legally and I have a license for it. And they
never got around to that one, but I agree with you. It's a fine line between investigatory questions and pointed accusatory questioning, and that's relevant to whether somebody's in custody.
It is, yes. It's relevant to whether it's in custody. At times there's separate determinations, at times they're interlinked. And here, once again, I want to stress that, and you have obviously listened to the recording, and I have as well. And my view of the recording seems to be a little different than yours in some way, because I didn't view it as accusatory. It was more investigative. And I think it's important that the trial court was allowed to view and observe the witnesses firsthand. The trial court made a determination. And I think that, if reasonable minds can disagree, that's something that trial court's there for.
Yeah, I get that, but the trial court, we watched the same exact videos and listened to the audio, at the Shrine Memorial, there wasn't video, just audio. We watched and listened to everything that Judge Moran did.
Right.
And I don't know as though that puts him or us in a worse position to make these calls or not. It's not really credibility so much.
I think it does for the state of mind of the investigators. I think that's also something that's a factor that we need to take into account too. Right. Is there another question on this point?
There's some close issues here.
Yeah, I agree. As for the jury instruction issue, I would say that once again, this is, the broader context of the court's intervention, there are multiple questions asked about whether or not he was in custody. And I don't think that the idea that the defendant specifically asked for the expanded charge should be ignored. There are multiple other charges available when we have an issue like this, and the expanded charge is directed specifically at improper conduct and undue pressure. And here, that wasn't the trial question. The trial question, the issue was about, was he under sedatives? The question was about whether he was in custody. And then the requested instruction didn't match up to the evidence.
I do agree that the defendant gets to challenge the statements, admissibility statements on Miranda grounds at the suppression hearing, Huntley hearing, and then again at trial. Right, you get two bites at the apple, as counsel
says. Yes, that's
And did the defendant get that? We know he got the first bite. Did he get the second bite?
I think so, because when you expand and you go back even to not just cross-examination, we read the direct examination, and there's multiple questions about, was he handcuffed, and that sort of things, and all the testimony is no, we just approached him. And the no, we just approached him is, I think, in my opinion, categorically does not put into issue the question of improper conduct. And if Your Honors do not have any further questions, I'll address them later.
Yeah, can you just briefly talk about the harsh and severe? I want to hear your opinion on that.
So here, once again, we do have a defendant who it is it's not disputed that he was defending his home. But what the people would focus on is that there was a plea offer, but very early in this case. And the three, I believe the offer was for the minimum. And I believe it was before pretrial hearings, which can take into account that, evidence is not coming out against you. There's a appeal waiver, which is included in that offer. And I don't believe there's a trial tax here. That's not the situation at all. I don't think that's even the,
one thing you said at the outset of this is he was defending his home. We didn't get to it, but it is in the briefs, whether on the simple possession, it says possession of the firearm. It's not a felony if you possess it in your house and you don't have a prior record. Our defendant had a prior record. I don't know why they didn't charge him under that provision. And then he's getting this whole home,
Right.
which is gone. It was not charged in that way, but be that as it may, they charged him. So they had to prove he did not possess the weapon in his home. He's on the roof of his garage. The question is that his home? You just said he was protecting his home, which kind of undermines your argument.
well, no, I think there's a difference between protecting your home and being inside your home. Like you can be in your brain, you can be on protecting your home, and you could leave and go into the street. That's totally, so I don't want to make it seem like I'm trying to concede the weight of the evidence argument.
If he was inside his garage with his gun, is that inside?
Well, that's a different circumstance because there is another case that has a detached garage holding. I believe it is under the Fourth Amendment issue, and I make clear in my brief that this is a Second Amendment issue. This is about the state's policy to enact strict and narrow regulations. And
so home does it matter if it's a detached garage or an attached garage?
I think it's a factor for sure. It does matter.
And this is a detached, that factor militates in your favor. But what about if he's on the roof of his own house? He climbs out a window, gets on a roof of his own house with a gun. Is that he's not technically in the house, but it's better for the defendant, right?
Well, right. I think let's think about the idea of in the house. Like, why would the in the house exception apply? Because you're not shooting presumably into the neighborhood. You're not shooting presumably I think there was an alleyway behind the house and there was a car that was struck maybe, or a house. I think there's 2 shots that were found over there. And that I think sort of begets why the home exception needs to be construed narrowly here, because the reason we have the home exception is because it's for things that take place in the home.
For self-defense, somebody's breaking in, you can possess a gun.
This wouldn't have been a justified shooting if he had in fact made contact with the person he was shooting at.
Right. But overall, you think this is a fair sentence for, when was the last time he had a felony conviction?
I'm not aware off the top of my head.
Sounds like a pretty long time. He had a job.
I think the complicating factors of this case are borne out in the sentence. He didn't receive the maximum.
Right. The victim, you don't dispute the victim stabbed the defendant's son?
I think it's not disputable. Yeah,
that's kind of what he's just out there robbing people,
right.
The defendant, and trying to, somebody stabs his son, kind of an emotional, understandable. And he didn't actually shoot anybody, right? He didn't hit him.
He didn't successfully shoot someone, but I think the evidence is that he was shooting at someone.
Right,
he knew where the person was going, and he did shoot other people's property. And so I think there's also questions about the attenuation, for lack of a better word again, between the original altercation and defendant's conduct.
Right. How much did the guy get? Not that it's dispositive, but what did he get for stabbing the defendant's son?
I'm not sure, Your Honor.
Okay, thank you very much.
Yeah, thank you.
Case 382 is People versus Eddie Williams. I'm sorry. Case 381. 381 is People versus Timothy Smith. Porter, good morning to you.
Good morning. May it please the court, Scott Porter for Mr. Smith. I want to address suppression. The police officer testifying as an expert, variance, and the motion for speedy trial because failure to file a valid certificate of compliance. Suppression. The issue is two parts to it. First, we maintain that police did not have reliable information by which to stop Mr. Smith as he walked down Jasper Street. And the second part is that if the information was reliable, it did not amount to a founded suspicion that would have justified the police officer to ask Mr. Smith if he could frisk, as well as to pursue Mr. Smith after originally consenting to the frisk, changed his mind and ran away.
Would you agree, just on a legal level, if the police had common or level 2 suspicion, founded suspicion of criminal activity for a common law inquiry, the police, if they have that degree of suspicion, level 2, they can inquire, and then they can also request to pat frisk the suspect. Would you agree with, there's law that says that under a level 2?
Yes.
Right. If you just stop at frisk, you need level 3, reasonable suspicion.
Correct.
But I think you and I are in agreement that all they needed for their intrusion here, that first intrusion, hey, we heard you kind of look like a guy, match the description of shots fired nearby, can we pat you down? All they needed was level 2 there, right?
That's correct.
So then we have immediate, well, not immediate flight, but we have some flight before the frisk can take place. Does level 2, founded suspicion, plus flight equal level 3?
I would say no, Your Honor, because the standard is other specific circumstances. And my understanding of the law is that an individual has the right to refuse police action at the level 2 encounter. And so if that person exercises that right, how then does that constitute a factor that would indicate criminality on the part of the individual? Which is why I consider these to be two separate issues. If the court finds that there was a founded suspicion to justify the request to frisk, it still has to find some other specific circumstance that would have justified the pursuit.
What about the proximity to the shooting, counsel?
That goes to the founded suspicion. And that along.
That wouldn't otherwise support the reasonable suspicion or the proximity and time and location.
Your Honor, my interpretation of this encounter is that although the suppression court found reasonable suspicion to begin with, the people in their brief are not arguing that. We are focusing on founded suspicion. And I submit that if there is founded suspicion, the proximity factor, while very germane to that, doesn't factor into the other specific circumstance once Mr. Smith ran away.
Your position, I guess, then is they would have had to seen a bulge or something else along those lines that they would have needed new facts as of that moment. That's what you're pointing.
Yes, something along the lines of what Mr. Smith was manifesting at the time of the encounter, and the record is clear that he manifested innocuous behavior. No bulge. He was not out of breath. He was not acting in a furtive manner. Nothing changed except for the fact that he changed his mind and ran away.
Do we know, I know it's in the record, but if you could just direct me to it. The shots come in from the victim and then a neighbor to 911. I know there's a dispute in whether the initial call described the race, but clearly it described black clothing. There's another call from a woman that said black male. But when your client, how many minutes was it from the call of the shooting of Mr. Clark, I believe his name was, and the approach of your client on Jasper Street? Do we know the minutes?
Yes, between 7 and 8 minutes.
7 and 8. And Jasper Street is a continuation of the street that the defendant was allegedly seen going eastbound on. It kind of curves and turns into Jasper, right?
Judge, I have to interrupt you there because no one saw my client eastbound on Silver Street. They saw him northbound.
Northbound.
Yes.
Okay. But Seward Street turns into Jasper, right?
Yes.
But you're saying the report would have had him going the other way.
We don't know where this person would have gone. That's my point, because, and I want to back up a little bit. In fact, I want to start from scratch in terms of the identifying suspect information. The initial 911 call told police that he saw a male wearing a black hoodie turn the corner onto Seward from South Albert, where the shooter was, and head northbound.
Yeah, and this witness was the one where the bullet had whizzed by.
Yes,
Flew out the
Mr.
side.
Clark,
Right.
Mr. Clark. But he was not identified at the suppression
Right,
hearing.
but the person who was within range of the firing then calls 911 immediately and says it's someone in a black hoodie.
Correct.
He gives a general location and direction.
Northbound on Seward. That's what Mr. Clark said.
Northbound on Seward.
Yes,
According to the map in the record, I didn't go do independent Google Maps or anything, according to the map in the record, northbound on Seward. The only way you can go, it curves right, and then it goes east on Jasper, right?
Judge, there's two streets. I think Graves is on the right, Schneider's on the left. The
Yes,
suspect could have gone down one of those streets.
okay. But
Okay,
he was on Jasper, assuming he didn't turn, he was heading in the right direction of the suspect. Even though it was east on Jasper, the description was north on Seward. They're not mutually exclusive. There's other places he could have gone into an
Yes.
alley, he could have gone into a
Correct.
house, he could have done anything, but it's not, it is a factor to consider.
correct. But to go back to the original 911 call, the officer who executed this encounter testified that it was his understanding that all the relevant information as it relates to this issue, gender, race, clothing description, and where the suspect was heading, was provided by the original 911 call. The judge, in his decision, focused on the second 911 call, which was made 5 minutes later, gave no information about the suspect because she's an ear witness. She didn't see anything. She heard 2 shots. That's all she said. But the court attributed her as supplying police with all the information I just described.
Right, but that dispatch, you may be right, but the dispatch that came out said M/B, which I think is male black, right?
That came from a police officer, unidentified. We don't know who
We
this
don't know where they came
officer
from,
is.
but the officers who made the approach, they heard that dispatch of male black, all black clothing heading in this
Eastbound.
direction. The cops are
Eastbound.
coming the other way on Jasper. They approach him with level 2 suspicion, not level 3 in your view. They approach him, say, hey, you match the description. Can we pat you down? He says yes. And then when they're about to do it, he takes off. They chase him. He abandons a gun allegedly, and that's where we are now.
Correct.
Yeah, there's one way I read the transcript of the hearing, maybe you look at it differently, is that the police officer, not the trainee, but the guy who was in charge, testifies that he saw your client toss the gun into the air while he's running before the officer and trainee gave chase. I find that extremely hard to believe, okay? But that's what he testified to. Are we stuck with that?
No, Your Honor, because I focused on that as well. I was concerned about that fact, and the suppression transcript had the officers chasing Mr. Smith before he discarded the
At
weapon,
one point they do, and then another couple of points they don't.
which is why I looked at it a second time, and I'm comfortable with the facts being what I just said they are.
And then at trial, it's pretty clear they were chasing before the toss.
Right.
I don't know if we can look at that though, right? Because,
No, you
But-
can't look at that.
okay,
And no, and I'm not gonna mix and match the facts for
Right.
purposes of the suppression. But I just want to stress again is that I asked the court to look first at the reliability of this information. And then if the court is satisfied with that, then move on to the substantive issues.
Counsel, if I could, as I understand the record, there's the initial 911 call. And the information from that call is black hoodie, just black hoodie,
Yeah.
male. And then there's an officer who responds to the 911 caller, who then apparently gathered that unidentified, then gathers some additional information about the suspect's race.
Yep.
And then that's relayed to Sicily.
Yep. Yes.
So that,
We don't know where that information came from.
but it was on the heels of the contact with the 911 caller. Within all of this is happening within a few minutes.
Correct.
Shots fired, officers on scene, officers are fanning out in that area looking for someone wearing a black hoodie, and then the additional information is being delivered to the officers who are on the lookout for the suspect.
There were two new facts. One is race, and the second fact, which I submit is more important, last seen eastbound on Seward. No one saw him eastbound on Seward.
And the Justice Lindler's question, you would agree that Seward and Jasper is a continuation of Seward.
Correct.
There really are one continuous street, at least from what we can see in the record on the map, after it makes a bend,
Correct.
an elbow.
But we have other streets where the suspect could have gone down. An assumption was made that he was eastbound on Seward. And that's the bottom line.
So your view here, the proper under the board, what should have happened is the police had the right to approach and inquire.
What are you doing
Hey,
here?
where are you coming from?
Yeah.
Where are you going? And they just couldn't go straight to, hey, can we pat frisk you? They needed to ask those preliminary questions. As a corollary, I think your position would be, your client could have said, all due respect, officer, I don't want to answer your questions, and I'm leaving now, so have a good night. And the police officer is supposed to just let him go, right? That's what the law requires. Whether that's a good idea or not, the Court of Appeals and the board that's what it says. And that's what your argument here is what the proper, what's the limits of the lawful conduct were that by the police. Now, maybe the guy says something in response to the inquiry that heightens the degree of suspicion, but he didn't.
This court in Smith made the observation that a description of a black male in dark clothing does not justify a stop within a half-mile radius where the crime occurred.
A stop for level 3?
I don't remember if it was a 2 or a 3 in Smith, but I would submit it wouldn't make a difference because it would not be a found of suspicion. The situation in Smith was different in this case in that the defendant was in a place other than where he was supposed to be, which is more egregious than this case. But here we have somebody who materialized into a certain place within that,
a few blocks within a few minutes. The fact that there were no other people observable on the street, is that it's not irrelevant, is it?
We don't know who was on the street. That was something that did not come out.
Okay, that wasn't at the hearing?
No.
So for all we know, there could have been people right and left.
It's as if Mr. Smith is the only black male in the neighborhood, the only person of any race in the neighborhood.
Well, right, that's what I'm saying. He's the only person that they see. It's not conclusive, but it tends to show, well, he might have been the shooter. There's nobody else. No other possible suspects.
Level 1.
Yeah. All right. Well, no, you raise a lot of good arguments in their brief, and it's a close one, and we'll get to the bottom of it best we can.
Okay, moving on to the police officer testifying as an expert. A material fact in this case was how many gunshots were fired. Because the gun that was recovered had 2 spent casings in it, the people, of course, maintained that 2 shots were fired. In fact, the second 911 caller told police that she heard 2 shots. But the 2 civilian witnesses who testified in this case, Mr. Clark and his brother, both testified that they heard 3 or 4 shots, which undercut the 2-shot theory. Rather than call the second 911 caller, the people had one of their police officers who was involved in this case testify as an expert witness as to civilians exaggerating the number of shots they heard that compared to what was actually fired. There was no attempt to qualify this witness as an expert. There's an objection made, and this testimony came in. And I submit that this situation is similar to this court's decision in Shattleman, where in that case, the police officer experience with sexual abuse victims frequently delayed disclosure of their details.
constituted an improper opinion and encroached upon the jury. The people in the brief say that this police officer was analogous to an officer who's has ample experience in drug trafficking, and as such, they're allowed to testify to the ins and outs of that trade. This case is nothing like that, because for this officer to render that opinion, he would have had to know the actual number of shots fired in all these other cases that he had responded to as a police officer in shots fired incidents. And I submit that that's not capable of setting a foundation to allow this testimony to come in. Variance. The theory of the indictment is that Mr. Smith committed both offenses at the same time. It happened at 204 South Albert Street at 7:43 on October 18th. And the two offenses being using a gun, loaded firearm unlawfully against another, and simple possession happened at the same time on South Albert. Yet, when Mr. Smith faced sentencing, the judge told him that he faced consecutive time because he considered these events to be separate events. And it begs the question, well, why would the judge think that in light of the Bureau of the Bill of Particulars? Maybe the judge didn't read the Bill of Particulars. But the people did argue at trial that the possession was open and shut because the police had seen Mr. Smith throw away the gun on Jasper Street. And in the jury charge, the court told the jury that the unlawful use count was based on using it unlawfully against Mr. Clark, which happened at South Albert, but didn't say anything about where the simple possession offense took place. And when he said what he said at sentencing, neither party corrected the judge as it related to his belief that these were separate events. And not only is the simple possession conviction at variance with what's in the Bill of Particulars, it served to change Mr. Smith's sentencing range from 7 to 15 years. I'm sorry, 7 to 14 years to 15 to 30 years. And while he received, while the judge did not impose consecutive sentencing, he did impose the maximum sentence as if these were concurrent terms, but I submit Mr. Smith should be resentenced so that his true sentence would reflect the correct sentencing range, as opposed to this double-fold increase.
Thank you, Mr. Porter.
Okay, thanks.
Morning, Your Honors. David Bassett for the people. Turning to the initial inquiry on Jasper Street, I just want to clear up a few things. The radio dispatch shows that the police officers learned initially from the 911 caller, Harold Clark, that he'd been shot at and he saw a male with a black hoodie going northbound, I think, on Seward. Then the radio dispatch shows that, of course, a unit is responding to talk to Mr. Clark, Unit 441C. This is page 323 of the record. 441C arrives a couple of minutes later. 441C's next entry says, 441C, we'll be getting a better description and will advise. A minute later, 441C, black male, BM, black clothing, eastbound on Seward from South Albert. This is not a piece of information drawn out of thin air or an assumption made by a police officer. This is additional information learned by the responding officers.
This is the race you're talking about of the suspect.
Yes.
And let's say that race was not communicated. Tougher case for the people, just a man in a black hoodie rather than a black man in a black hoodie, right? We don't know what so this is an important issue. Did the race get communicated to the officers who approached him, right?
Right. Officer Sisley testified that the description that he was provided was black male, black clothing, heading east on Seward. I believe that in the suppression hearing, he simply conflated where he was getting that information, all attributed to the 911 caller and the initial call versus 911 call, and then the officers talking to the 911 caller.
Right, which is understandable. They're in pursuit, they got the radios going, and he can't be blamed for not knowing, okay, did Mr. Clark, the initial caller, relate the race, or did that come in a few minutes later, or what have you? But in his view, he was looking for a male black in a black hoodie.
Correct.
And that's what he saw on Jasper Street within a short period of time, which is consistent with the direction of where the suspect was allegedly heading. That's enough. In your view, is that reasonable suspicion level 3, or is that level 2 founded suspicion?
Our position is that is enough for level 2.
True.
What the court said was that this was enough for level 2 founded suspicion, if not reasonable suspicion, level 3.
And then can you, level 2 suspicion, immediate flight, does that justify pursuit?
Under the circumstances here, you have the matching description, temporal and physical proximity within 8 minutes, within a few blocks, consistent direction of travel. And then you have the additional kind of odd fact that defendant initially agrees to be checked for weapons. Police officers approach and ask him, and he says, sure. And then he changes his mind and bolts. That sudden change in behavior and flight is what, with the additional circumstances I noted before, supports reasonable suspicion to pursue.
Did the officer see the gun being tossed before or after they started chasing? In your view, based on the testimony to hearing?
My view of the hearing was that the officers pursued, then saw him discard the firearm.
It makes more sense.
Yes, I think that's a reasonable interpretation of the evidence at the hearing.
Okay.
And that when they saw him do so, of course, that provided probable cause. That was CPW. And so the officer's conduct was justified at every stage of this encounter. The defendant, as you said, Justice Lilly, could have walked away. When you are approached in the level 2, the person has the right to be let alone. They can walk away and the police cannot pursue. That's not what the defendant did here. He ran, and the officers were justified, had reasonable suspicion to chase, saw the weapon, recovered it, etc.
So are you saying that he had that based solely on his running, whether he had the right to walk away versus the right to run away?
Your Honor, I think that's an important distinction here. If he had walked away, the officers don't have an additional factor that raises their suspicion. If he didn't initially consent to the search and then change his mind, the officers don't have an additional factor that increases their suspicion. Those two changes are, I think, what provide the additional circumstances to justify reasonable suspicion in this case.
What about if he jogs away? Light jog.
Well, I think the testimony here was that he ran. But
Right,
to your
but
point,
I think,
if he does,
I think Justice Oxen's question is a really good one that I hadn't contemplated. We all agree, and you just conceded, if the defendant on a level 2, he has the right to walk away. I think People versus Howard is the case in the Court of Appeals, that you have a right to be left alone and you can decline any police intervention and go on your way. So you agree that the defendant at that point, based on black male, black hoodie in that area, could have walked away and the police couldn't have done anything to him, right? He could have just walked away and said, gentlemen, I'm out of here. Have a good night. And the police have to just watch him go. So Justice Ogden's question is, if he runs, how is that any different? Good question.
Well, I think what the flight does is it shows maybe a consciousness of guilt that they have engaged in criminal activity, therefore justifying an increase in the officer's suspicion that they've engaged in criminal activity.
The consciousness of guilt comes from saying yes first. Forgive my interruption, but without that yes first, I don't think you can get to consciousness of guilt, correct?
Arguably, flight alone might not be enough for consciousness of guilt, but they ask him the specific question, can we check you for weapons? And he says yes. And then he bolts. The natural, I think, conclusion is that he's got a weapon to hide. And of course he did.
Isn't that the natural conclusion you get if he walks away? Like, why would an innocent person say, sure, I'll pass first, we go ahead? A guy who says, nah, I'm not down with it, I'm leaving, walking, I guess there's that same consciousness of guilt. But it's an interesting point. We're going to have to look at it and see what the case law says.
If I may, as I understood it, they didn't have an opportunity to do any further inquiry or investigation. Because that's part of the problem here. If he had simply walked away, maybe they would have followed up with something else, something other than a chase. But they had no other option here.
Right.
And the chase was what instigated the pursuit, or the bolting was what instigated the pursuit.
Yes.
And so they were, it was the instantaneous bolting that rose to the level. If he had walked away, that would have been a different analysis.
Correct. He bolts after agreeing to the search. As the officers are approaching to perform the search, he bolts.
Right.
Which, you know, our position is
their attempt to do the inquiry was interrupted.
Now, indicating again an increasing their suspicion that he was involved in this shooting, which had just occurred a few blocks away, 8 minutes earlier. And he's exactly where he should be if he was the shooter alleged to have fled east on Seward.
Right. To me, this case is different if they approach someone in a hoodie on West Genesee Street. That's not what happened here. This was within minutes. This was a rapid response. The call came in from the individual who had almost been hit by a stray bullet, apparently here, with a description, and there's an immediate targeted area. And someone wearing that black hoodie is identified, and the officers approach them, and then the immediate bolting. All of those factors together is what we have to analyze the totality of the story.
That's right, Your Honor. You have to look at all the facts, all the circumstances. And if you add them all up here, I think there's more than enough for founded suspicion to approach and inquire. And then you take his odd behavior, change his mind, and fleeing rapidly. That's enough for reasonable suspicion to pursue. Now, turning to Officer Pastorello's testimony, the court properly exercised its discretion in allowing the testimony based on Officer Pastorello's extensive experience, having responded to what he said were hundreds of similar shots fired calls. And he did not offer an expert opinion, such as only 2 shots were fired here. What he said was that civilians very frequently report more shots than were actually fired. And this was not, it was not specifically offered as an expert witness, and the court didn't specifically say so. But this court has said in Barksdale from 2015 that it need not be specified as such, so long as the record shows that they are qualified as an expert. And I would submit that he was, based on his extensive experience here.
I understand the argument.
Yes, and just quickly wrapping up with the variance issue, we submit there was no variance. That defendant's conviction on both counts was supported by the evidence. As for, I think it's count 3, the CPW outside your home or business, that was charged and then specified in the bill of particulars to occur at 204 South Alvord. I think that was the only logical conclusion here, was that he possessed the weapon outside his home or business when he did so on South Alvord, when he fired at Harold Clark on South Alvord. That is where the shooting occurred. The jury found him guilty of CPW second unlawful intent for doing the shooting. And they also found him necessarily guilty of CPW second, outside your home or business, because they put the gun in his hand at 204 South Albert. And his possession on Jasper Street was simply a continuous possession and extension of that possession on 204 South Albert.
Thank you, counsel.
Thank you, Your Honor.
Case number 382 is People versus Eddie Williams. Morning, Mr. Hobbs.
Good morning. May it please the court. James Hobbs on behalf of Eddie Williams, appellant. Our position on this appeal is this was a case that was built on an unconstitutional interrogation.
I've looked at that, and let's assume you're ahead of the game on that.
All right.
Then we get to the waiver.
The question is it shielded from review by this court by the waiver of appeal? While I contend that all waivers are confusing for the ordinary defendant, I mean, here we have a more specific problem. The waiver in this case failed to make it clear that the appellate rights that are being waived would ordinarily survive a guilty. Certainly the court distinguished.
We just try to streamline this a little bit, and yeah, I'm not concerned on the merits. The Marrero case seems on all fours.
Yeah.
This case turns, in my opinion, I don't speak for everybody here, but it turns on, can you get around this waiver?
Right.
Because if you do, it's a reversal in my view.
Okay.
The model colloquy waiver of the right to appeal, Judge Moran did not read it verbatim. If he did, your client's out of luck.
Right.
Okay. Fortunately for your client, he didn't read it verbatim. Also, fortunately for your client, the written waiver wasn't even referred to during the plea colloquy. The written waiver is better than the oral waiver, but that's out.
Right.
So that being said, I have the written waiver here. I'm sure you know it almost by heart. The judge didn't read it verbatim, but what key concepts in this written waiver were omitted from the transcript that was read, the oral colloquy read to your client?
So it's in the opening paragraphs. I want to get it right, but the opening paragraphs explain how the appellate rights are separate from the trial rights, and the language makes it clear that they ordinarily survive a guilty plea. So it's not just that we have two different kinds of rights. If that were the case, if it was just sufficient to say we have two different kinds of rights that you're waiving today, then the judge could say, your right against self-incrimination is a separate and different right from your right to a trial by jury, but you're waiving both of them, right? What needs to be conveyed is that the appellate rights are not just separate rights, but they're the ones that you wouldn't necessarily give up just by pleading guilty. And that it's an additional waiver.
Right. So on page 6 of the waiver, I don't know if you have in front of you, this may be unfair, but
I don't know.
The court says, so we'll move on to a second set of rights.
Right.
They are separate and distinct from the rights we just talked about. Those are the rights you forfeit upon plea in every case. And they have to do with your right to appeal. So far, so good, right? You don't have a problem there. I'm just trying to get to the language. Well, it might be easier. What language in the standard colloquy doesn't appear in Judge Moran's oral colloquy?
So the model colloquy that I quote from says, next, a defendant ordinarily retains the right to appeal even after pleading guilty. Thus, a waiver of the right to appeal is separate and distinct from the waiver of the trial and other rights by a plea of guilty.
Okay,
in this case,
the first paragraph of the model colloquy, right?
That's right.
Okay.
In this case, however, as a condition of the plea agreement, you are asked to waive your right to appeal. That language does not appear in I don't think that's clear at all from
okay,
the oral colloquy.
That's helpful, unless we're narrowing it down.
Yeah.
Go ahead. Anything else then?
There's a second omission, and I think the case law has not found that this is adequate on its own, but the model colloquy recommends that judges specify the issues that are waived if there's a clear issue in the case, like a suppression ruling, I think is the example used there. And that was not done here. And that clearly could have been done here since it was the one litigated issue and the critical issue in the case.
Is it necessary though? I guess is the
That's-
question. That is,
The
I
case
guess-
law that I've seen does not suggest that that's sufficient on its own to invalidate a waiver.
I mean, in perfect world, the judge
Right.
would have stated,
Yes.
this is what you're
So,
also giving up.
I think that's an added factor here, but I think the main factor is whether it's clear that the appellate waiver is separate and not inherently part of a guilty plea.
Okay, so that's two defects so far. That you've identified two defects.
Yes.
Is there, there's more, I believe you have in store for us?
Those were the two that I relied on.
Okay.
I mean, the fact that the written waiver can't cure it, but it's mainly just the fact that the appellate rights are, whether just saying that they're separate rights is sufficient to convey that they are not ordinarily forfeited.
Mr. Hobbs, I think this has been said from our various panels, because we have a lot of these, as you know.
Yes.
Types of cases, especially after Thomas, and then we have Bassano and Apia. And if there's confusion, it has to be corrected. But one of the things we tend to do is we look at the name of the judge and the date of the plea colloquy. And we have found that sometimes, while something back in 2020, shortly after Thomas, would be invalid, a year and a half later, the same judge, it'll be valid. And we
Sometimes 3 or 4 years later.
understood just writing. But hopefully I'm getting the point. We sort of keep track of, at least try to as best we can.
Yeah.
The name of the judge, the time of the plea colloquy, the waiver, the exact transcript. So we compare transcript to transcript. And I think if you were to do that in this case, to a case that Mr. Ash was on back in October of 24, called Detroit Kelly, People versus Detroit Kelly. And then more recently, we have a case called Reynolds. And if you were to, and sometimes the record's available, sometimes they're not. But, you know, so we have an easier time of that at our level, perhaps. But of course, at your offices, you might be able to keep track of it too. So we actually dig into the records of those previous appeals and match it word for word. And if we previously found it in Kelly and in Reynolds that this plea colloquy with respect to the waiver of appeal by this particular judge at this particular time is valid, then we're likely to find it valid again. Don't you think that's what we should do for consistency?
Well, I guess I would say,
Mr. Hobbs, but I know you can handle it.
No, I would hope that, you know, we go beyond just looking at the judge and the date, but actually look at the transcripts and make sure the transcripts match up.
Well, we
Because
do.
some judges ad-lib, some judges use the verbatim transcript that they use every time, but sometimes there's some ad-libbing and there's some different explanations.
Of course, the Court of Appeals has said, as you know, Mr. Hobbs, we're not supposed to require an exact script.
Yeah.
And of course, then.
Obviously,
what
we
you
also
do.
have to look at what's argued and what's, you know, you decide arguments as they're presented. And if someone before me didn't make this particular argument, I don't think you're going to go out searching the record to see if this is an actual defect or not. So I would want to know what was argued in those cases. And then also, I think, you know, the court has said that there are factors to consider that relate to the particular defendant in a case. The defendant has a great deal of past experience. They might understand a colloquy more quickly than someone who does not. And I don't think the record in this case shows that that would be a helpful factor for the people here.
Your client got 20 years on a plea.
Yeah.
There's been arguments made, I don't know, in this case, I don't think you make it here, but a waiver, even if it's word for word with a model colloquy and it's voluntary, it's not enforceable for lack of consideration. In other words, this is a contract. The defendant is giving up something, a right to appeal, a very valuable right. In return, the consideration needs to be some benefit that wouldn't otherwise exist. He gets 20 years here on a plea. But is there consideration, and is that even a factor we can consider in this particular case?
It's hard to know whether there's considerations. It's not specified that this is consideration for this appeal waiver, rather than this is what the deal he was going to get on any plea, you know, for not litigating the case. So
could he have gotten more?
Oh, he could have gotten more. I think he was.
Is that consideration?
He got a charge. I mean, there's consideration. I guess the question is whether or not there's consideration for the appeal waiver in particular, or it's consideration just for pleading guilty.
Because you always get a consideration for pleading guilty. Why nobody would ever plead guilty otherwise almost.
Right.
So it's trying to distinguish, and maybe this impossible standard, this whole consideration, how do you differentiate what you're getting for pleading and saving them going to trial and creating certainty, and what you get for insulating
Yes.
the people in the court from legal errors.
I've thought about this issue, and I've wanted to raise it, but I've been waiting for a record where it makes clear, where someone objects and says, we tried to negotiate a plea without a waiver. They won't give it to us, or, and like here was what was offered with the waiver, and here was offered without the waiver, those kinds of things.
So maybe on a future case, you'll be forced with the lack of consideration case, but this is that, right?
That's right.
Okay.
I just want to be heard briefly. I know that this waiver is the critical issue, and I know it sounds like at least you, Justice Lindley, are with me on the Marrero point, which is the second Miranda violation, but there also is a first Miranda violation. I don't think the statements that come even before that confession should come in because of the quid pro quo at the start of the Miranda waiver. And I just wanted to be heard on that and address it briefly. I think that the deal was particularly coercive in these circumstances. It's clear from Mr. Williams' answer that he's waiving because he says it's the only way I'm going to find out what's going on, right? He's asking, why am I here? Can someone tell me what's going on? And while he's been arrested at 447 by a SWAT team, pulled from a home, brought to a locked interrogation room and handcuffed to a table, I think that's a pretty valid concern and something that's pretty coercive to say, for the police to say, sure, we'll tell you what's going on after we read you these rights and you agree to speak to us.
But all you really need is Marrero, and presiding Justice Lindley and I were on that case.
Okay.
Thank you, Counselor. Mr. Ash again.
Good morning again, Your Honors.
Mr. Ash, by not even citing to Marrero in your brief, you essentially concede the point, don't you think?
Well, I think that, Your Honor, I don't want to concede any point.
You know what?
I don't want to concede the Marrero point.
But if you don't want to concede it, wouldn't you at least address Marrero?
Your Honor, I admit that mistake. I
thought maybe that's intentional.
No, sorry, Your Honor. You're welcome to beat me up as much as you want.
It's not what we're here for.
I think that the issue here about the protection that Miranda rights provide is first and foremost false confessions. And I don't think that a speech here about leniency, this is the only opportunity to gain leniency here, is a situation that is going to invoke the risk of a false confession, because the defendant's will here was not overborne in a way where he reaches a breakdown. This is a long, after the rights are given, it's very clear why he's being interrogated. It's very clear that the subject matter is the shooting and they know he's involved, and the interrogation is long. And so it's long and voluntary, not as in long as in this 20-hour interrogation where they come back and come back and come back and never give him his Miranda rights again, but it's a conversation nonetheless. And I don't think that we have a substantial risk, or really any risk at all here, that the confession was obtained and doesn't have a factual basis.
But you're relying primarily on the waiver of the right to appeal. You think it's close enough to the waiver, even if we ignore the written waiver, hits all the salient points, and therefore we don't even get to the Marrero issue.
Yes, Your Honor. And not to divulge too much about how the court operates, but the idea is that the courts are learning from Thomas. And I don't think that here the idea is, Thomas has these categories of violations. One we can call scope, and which means, improperly saying there's an absolute bar, and that didn't happen here. But also the nature of the appeal and them being distinct from a trial. And I don't think that the very minor diversions here from the model colloquy are enough to overcome the statements that this was a knowing and voluntary waiver.
Thank you very much. Case number 383 is Heinrich versus Sarens.
Yes, thank you.
Good morning, Your Honor. Good morning. Sidney Kaminsky. Good morning. Your Honors, there are so many errors that I believe occurred in this case. Firstly, the tenor of the case from the beginning was just so unusual. Tammy Heinrich was going to be excluded from the trial if she didn't testify first. The defendants asked that she be sequestered, and even though she knew nothing about the incident, the court said, we're going to sequester her unless she testifies first. Then we had a ruling on the economist and the Dr. Wolf that was a complete misconstruction of the law under damages and wrongful death. And it was a change in what the court had originally ruled. And it was a misinterpretation, as I said, of a case called O'Buckley versus Chemung County, which I had represented the plaintiffs in. And then we went from that mistake to the denial of subpoenas from the hospital. We had asked for various materials, and the court, without even examining what was going on or obtaining any sort of foundation, had denied these subpoenas. And we were denied the opportunity to prove things like the night guide for interns, which spoke of gastrointestinal bleeds, which is what this young man passed away from. We were then told that testimony that was cumulative would be excluded. And we know as plaintiffs, as litigants, that cumulative testimony is discretionary. In this particular case, given the nature of the case, that is an emergency room admission, then we went to the medical floor. There's a time in between the ER at 3 o'clock and 6 o'clock where we're sort of in a limbo. We then go to a rapid response where this young man is given drugs inappropriately, and it is necessary for us to address the changing situation.
Right, so you have basically three sets of defendants, the ED defendants, the first two.
Correct.
You have 6 floor defendants.
Correct.
And then you have the rapid response team defendants. At the end, you have 7 total. I mean, I know that you started out with a lot more, but we're
right.
And do you want to? You got a lot of issues here, and we want to give you an opportunity to expand on those. Do you want to? Which issue do you want to start with?
Well, I guess with the cumulative issues, first of all, we had described, there was a summary judgment motion made by each one of the defendants. We submitted affidavits from expert witnesses, one of which was an emergency room physician who said in his affidavit that after confirming the bleeding, blood product could have been ordered to replace the blood being lost if needed. And that would have stabilized David and given the hospital personnel long enough to formulate a plan to treat the ulcer. That is a transfusion. That's how you give blood or blood product.
You had 2 experts who said that. Matter of fact, I lost count. I have those affidavits. They were from each other. I have them from. I lost count of the number of times where the experts said there should have been a blood transfusion.
That's so right.
I'm with you on that.
Okay. And so the circumstances in the ER, when we go into the ER, we don't know anything yet, other than the young fellow's passed out. You need an emergency room physician to say, well, in order to make this differential diagnosis, which is basically we start broadly and narrow it down, we have to do some testing. And only an emergency room physician can talk about the need for serial blood work of both complete blood counts and metabolic panels at that time and what we're going to do. And the ER expert was prohibited from getting into that because of a Dr. Lenhard, which was an endocrinologist. This young man had what's called panhypopituitarianism. And it was necessary for us to explain to a jury that though he suffered from this disease was sort of like diabetes. It was a hormonal deficiency. And you had to understand that, and the jury had to understand that. The emergency room physician then had to testify to what needed to be done to diagnose and determine a treatment plan. And it was necessary to do serial CBCs. Those were not done. And so,
well, there was a second one done, but not till 7:30. You say it was too late. Should have been a lot.
Right.
They didn't get the response from the 7:30 one they didn't do it stat, and it took too long and so forth. We understand all that.
Okay.
So
wasn't there were CBCs done when he was in the ER?
There was an initial one done, and I'm sorry, I don't know which way to face. There was an initial one done that showed a 10% loss, which in and of itself, as Dr. Cleary said, wouldn't mean much, which is why you do serial blood work. But a 10%, it was just, he was just seen 3 days before by an endocrinologist, and his hemoglobin and hematocrit had dropped 10%. That meant nothing in and of itself. But we then know that the blood work continues to drop, and you've got to monitor it. You've got to find out, as Dr. Cleary had admitted, that something is going on. One test isn't enough. And so we knew he walked in, there's been a change in his blood work. He's passed out. It's called a syncopal episode. What's going on? His metabolic panels also show things are going on. His sodium levels, all sorts of things. His
bun levels doubled, his creatine went down.
Correct.
Which is indicative of not dehydration, but the opposite.
That's correct. And so all the signs are now going towards a bleed. And the only way you can know whether or not there's a bleed going on is to continue the test, because it's no different than taking a temperature. Did the temperature just spike for 2 minutes, or is it now going up or down? That's the ability they have with the metabolic panels and the complete blood counts, but they don't get the results of the complete blood counts until he's out of the ER, basically. There's also that period of time where he's in like purgatory between 3:15 and 6 o'clock, where there's a first year resident who's not being supervised. Dr. Cleary only speaks to her afterwards. So now we go into all of this, and the judge has decided I'm not allowed to get into any of this. And it's impossible for me to prove this case without proving significance and without bringing in qualified people.
So did the judge, my understanding with the judge said you can call them, but not cumulative. You can't have them testify to the same things.
Well,
and so you did call a number of witnesses, experts. You had a long list of them, and I guess the ruling was they tailored them so that we weren't going to have cumulative testimony in the court's view. You say that wasn't cumulative?
It has to be cumulative, because this isn't a discrete event. I have to have my ER doc saying kid passes out, then comes in.
So nothing wrong with cumulative. We're not talking about missing witness. We're gonna get to that later. That when we have cumulative, that's relevant there, but you're saying to preclude experts, the fact that they may overlap a little bit, there's no evidentiary rule, you say you got to preclude them.
And you can't, none of these doctors could diagnose and treat without accumulating information. And so it was necessary for the experts to come in and say, well, given the fact that the hemoglobin hematocrit dropped an additional, or he's passing out like at 2:45, he passes out when he goes to the bathroom. That's another syncopal episode. That happens to occur within the ER. So later on, when Dr. Ashcraft is testifying, who's a hospitalist, he has to say, well, I now know that at 2:45 he's passed out. I now know at 5:30 that, as Dr. Lenhart had pointed out earlier, that there's a change in his chemistries. And then you go on and you've accumulated symptoms and findings, and that's how medicine works. It's not all of a sudden you cut off.
People aren't in separate total boxes. Do you want to move on? Two of the issues that I think are troubling to me are the blood transfusion preclusion of that theory, and then the failure to give the missing witness
absolutely, Your Honor.
for the three residents. Why don't you address them in that order? I guess the blood transfusion really turns on, would it have been a surprise to the defendants at trial?
Absolutely not, which is what I obviously didn't emphasize this. During the summary judgment, we submitted the affidavits of all of these experts, many of whom spoke about transfusion. When we submitted our expert disclosures to these defendants' attorneys, we said in each one that we incorporated by reference the affidavits from summary judgment. And in fact, and I'm not sure of this, I think early on we had actually attached those. So undoubtedly, as I quoted from the emergency room physician, amongst others, he said, give blood product. And so there was no surprise. The defendants never said there was surprise.
They addressed that in the reply to the summary judgment.
That's right. They had Dr. Cohn who spoke about that. So now our loss of chance, which was both liability and causation, we're precluded from proving something that they don't even allege is prejudicial. And we have repeatedly stated the same thing. In fact, the judge kept saying to us, well, you keep saying the same thing pre-trial. And we did. We made the same over and over and over again. So we did do that.
Mr. Kaminsky, let me slow it down for
Sure.
a second to follow up on what the justice presiding is asking. I'm looking now, because we have, everybody has access to this, not just us, but I'm looking at your brief on the summary judgment motions, and this is one of the things, and all I did was to run the word transfusion through your brief, and I haven't gotten to the record. There's tons of references to it. But one in particular caught my attention. It says in summary judgment, as explained in plaintiff's expert affidavits, the administration of level-fed.
It's either level-fed or level-fed. I'm not sure.
The administration of level-fed by defendant Chan without a transfusion was absolutely inappropriate and negligent, et cetera, et cetera. Yeah. That contention was there, and then before trial, you served your expert disclosures. I think it was a third one, which notified everybody months before the trial. Correct?
Correct.
Now let me just slow this down. In terms of this blood transfusion, who did your experts allege on the summary judgment motion? Which doctors were purportedly negligent for not doing the blood transfusion? I know Chan's one.
Clearly supervising. First of all, in the ER, had we known that the blood count had dropped again, it may very well have been appropriate to have started the transfusion process then.
So that's Sarins and
I'm sorry.
That would be Pippus and Sarins.
Right, Pippus, and Sarins. Because as the emergency room expert said, transfusions would allow time for a plan of treatment. And the transfusion would, if you're bleeding, you can be transfused for hours and hours and hours. So initially, the expert witness says that in the emergency room, had the results of the complete blood count been ordered stat as it should have been, consideration of a transfusion should have been done then. We then go to the medicine floor.
Okay, is that the RR team? Or is that?
No.
SPD?
Our rapid response team is after the emergency room.
Okay,
That's
so
it.
you were just addressing the emergency room.
Correct.
Okay, thank you.
Now, but at each stage, transfusion is life. I can't emphasize it enough. This is part of the problem. The same mistake was made
Right. So this
continually.
implicates Patel, who was ED and sixth floor, kind of like a.
That's right. And Cleary, because
She was supervised.
Cleary's supposed to supervise, never came and sees the patient, doesn't order stat. And at the RRT, which Cleary also is supposed to be supervising, we have a Dr. Chan, who's a second-year resident, who has testified in deposition that she never used Levophed before. And Levophed is a constrictor, which will decrease blood flow.
All right, so far you got the 6 to 7. How about Costers?
Fosters, now we get to, we've gone through the RRT, and what's crucial here in the RRT is that the defendants admit that David is in worse condition after the RRT. Now, Costers is a fellow. He's supposed to be supervising Alexander, and he's supposed to be watching over. And what happens in both instances, that is with Cleary and Costers, is that they speak to their, I guess, juniors. I don't really know how else to put it. After, which is too late. And Cleary says, I can't go into the ICU. And Costers says, I'm at home. And Costers' testimony is contrary. He says in depositions that he spoke to Alexander once, then pops up in trial and says twice. And when I want to cross-examine him as to the contents of what he's talking about, Judge Lamondola says, I'm not allowed to get into that.
All right, but can we just get an answer to Judge Kerwin's question? It sounds like all 7, you think, if we agree with you, it's a big if. If we agree with blood transfusion, everybody's in.
Absolutely.
Missing witness, though.
Oh, missing witness is all
3, and then their supervisors, not the 2 EDs?
The missing witness charge has nothing to do with Pipus or Sarens and Cleary. Okay.
Cleary, well, in your brief, you say it does because she's a supervisor.
No. What I'm saying is it has something. I was getting there. In other words, Cleary did testify.
Right. There's just only 3 who didn't.
Right.
What we're looking for is if we agree with you, who gets a new trial on it?
Well, everybody gets a new trial because transfusion wasn't allowed. And loss of
just on missing witness. I'm sorry.
on just missing witness. It's Cleary, it's Alexander, it's Chan, and it's Patel.
Okay.
Now, on this issue of a missing witness, and there's been a reference already in the oral argument to supervisors, et cetera. One of the key issues, as I read it in the summary judgment motion, was the argument by the defense that the residents did not exercise any independent medical judgment. And if they didn't, then they are protected by the actions of their supervisors, so to speak. I think Cleary as the attending a hospitalist, Costers is the resident fellow for whatever the specialty was. But as I understand it, Mr. Kaminsky, please correct me if I'm wrong, because for me it's important to know this, but I see no argument being made at trial that somehow that issue should be presented to the jury. That is, when I look at it, I see nothing in the charge that identifies this independent medical judgment issue. That is, they're insulated if they didn't exercise independent medical judgment. There's nothing in charge to that effect. As I see the verdict sheet, each individual defendant is presented to the jury with a negligence question, irrespective of their status. You see where I'm going is, does the status vis-a-vis what happened at this trial matter at all?
No. No,
In other words, counsel, they're a full party defendant in this case.
absolutely.
No doubt about it.
Absolutely, because on top of everything else, if you just go back a little bit, we had put in vicarious liability and the like, and we were told, no, there's no vicarious liability here. And no one testified to independent care, treatment, or judgment. And I'm sorry, Your Honor.
That's okay.
Because of the numbers.
That's okay.
So they don't get off that hook. We had intentionally started out with a very broad base of potential defendants. And we realized that all of these people were acting on their own. Patel did not, each one of these people are responsible for what happened. And each one had an opportunity.
There was a reference, and this I know it's not relevant to our appeal terribly much, but I'm curious. There was mention of a collateral proceeding against Upstate in the Court of Corrections in a companion case. That is still going?
It's still existing, but as we see, we believe, we're not 100% sure. We believe that all of the issues that have been decided in this particular case would have been those issues that would have been in the court.
So they're
of
waiting
claims.
for us.
Correct.
And if I could turn back the clock just a little bit on the blood transfusions. Your argument is that the trial judge precluded your expert from getting into, that was a deviation, not to give a blood transfusion early, right?
That's correct. And he did that with not only our ER expert, he did that with the surgical expert who was prepared to testify that, boy, do it then. And Dr. Lapointe, the medical examiner. And so it was impossible to talk about loss of chance.
And the issue there really is, was that deviation, was there adequate notice of that? Was it a surprise and so forth? Am I correct that the blood transfusion theory of deviation and causation flows from the theory that was presented? One of the many theories of deviation was that failure to diagnose the GI bleed, internal bleeding, right? That was the whole theory. It should have been dehydration. The focus should have been, he has a GI bleed or some type of internal bleeding that is causing low blood pressure, and failure to diagnose that. That was an issue presented to the jury, right? Am I right on that? Your experts got to testify about that alleged deviation, right?
They were very constrained in what they could do.
Okay, but that was a theory because you gave notice of that. They should have diagnosed the GI bleed. They diagnosed dehydration. There was no differential diagnosis. That was a huge mistake. With the blood transfusion, would not the course of action for a blood transfusion turn on whether they diagnosed internal bleeding? Or is the theory from the expert, even if you don't diagnose internal bleeding, just give them a blood transfusion anyways? And if it's the former, well, then you're already lost on the jury didn't buy this failure to diagnose GI bleeding. And then, so why would they conclude you got to do a blood transfusion if one necessarily follows from the other? You follow me?
If the physicians had recognized that there was blood loss, whether or not it was GI or not, the testimony would have been that the transfusion would give time would stabilize the patient and allow them to do whatever was necessary. Dr. Kaufman said that there wasn't enough time. One of the arguments that was made by Ms. McPherson and was proposed by Dr. Kaufman was that there was not enough time to save this young man. And the transfusion would give the doctors basically unlimited time.
I guess what I'm saying is that they argue, I think, almost causation of blood transfusion. If the jury concluded that there was no reason, no deviation for failure to diagnose, not just GI bleeding, but any internal bleeding, then they would have never found a deviation on blood transfusion. You don't give a blood transfusion unless there's internal bleeding. Or did your experts have a theory that even without that diagnosis that they should have had, because we all know he had internal bleeding in the GI tract. It's a little unusual. It didn't migrate to his stomach or other areas. It was contained within the GI tract, which I guess is a little unusual, but that's what he had. But if you only give a blood transfusion if you have that diagnosis.
No,
You
have to have the sign of blood loss. That's the whole thing.
Okay.
In other words, you have something causing blood loss. And
what could it be if you're not externally bleeding? Like, what are the other options here?
well, he could have had a cancer. He could have had some kind of a dyscrasia. There's all sorts of things. And to tell you the truth, I can't even begin to imagine. He could have had a brain bleed. He could have had anything. He's got a blood loss.
Counselor, if I can follow up
Sure.
with Justice Lane's question here, is there not a distinction between a failure to diagnose and a failure to treat?
Of course.
And is the failure to give the transfusion failure to diagnose or detect the GI bleed, or failure to treat?
Failure to treat.
It's a failure to treat.
And it's a little more complicated. It's never so simple.
But
there's a diagnosis.
Just give me a second here then. But if the jury says that there wasn't a deviation in not detecting or not diagnosing, how is there then a failure to treat?
We don't know if there's first of all, remember, the court's charge and comments about my closing argument about how it's the duty of the defendant to make evidentiary rulings and saying things like, I know what I said was wrong, was beyond damaging. It made everything change. What happened that last day wiped out any credibility, which is why it only took a half an hour for a jury to come back with a no cause. The second story, the second issue which you bring up, which is diagnosis, is there's two different things that you're talking about. One is you got a problem, blood loss. That's part of the diagnosis. Then diagnosis number two, so to speak, is what's causing the blood loss. And so the first thing, and that's why explaining in this, and it's not cumulative, and the court's constant changing of rulings and not allowing Freed to testify about transfusion is so devastating, because it does get complicated. But there's two diagnoses. One is blood loss, treatment, transfusion. Then the next is what's causing the blood loss? Well, that could have taken a lot more time. If it's, first of all, as Your Honor says, there's no blood maybe in the stomach because of the location, it's in the intestine. It would have taken a long time to maybe diagnose where it was.
So your point generally, because I know we're running short on time here, is give the treatment, the blood transfusion. Let's figure out the diagnosis later, but we know he's got low blood pressure. We know there's a problem. Let's deal with that and we'll figure out why later. On the missing witness, which I know is a significant issue for you, we understand that the burden issue, People versus Smith, it's a case that some of us were on. We understand the burden there is a criminal case, but it seems to apply. Do you want to touch on this issue of what the judge's instruction was? He gave you permission,
Yes.
You can comment on it, and then he seemed to say disregard all your comments.
That's right.
Even if, because some of your comments may have been a little over the line, but some weren't. The jury's instruction was disregard everything. You want to be heard on that?
Oh, yes.
Okay,
I've been waiting 2 years to be heard on this.
Okay, so take, why don't you hit that and we can move on.
I don't want to use the word hit, but I definitely want to talk about that. First of all, it's 175.1. It's a party. The judge went back and forth. He initially made the wrong ruling. Then he went back into chambers, came back downstairs and gave us the right ruling. And I believe that was on Friday. And please don't hold me to the day. And he said, oh, yes, it's a party. It's a different thing. Then he came back the next day and said, no, I'm not going to give the missing witness charge. But Mr. Kaminsky, I'm going to allow you to discuss this. So I did. The judge then says that plaintiff's counsel is aware, well aware, that such suggestions are inappropriate and an inaccurate statement of rules of evidence. That's a quote. In other words, I'm out now lying to the jury. That's what he's telling them. I'm aware of this.
He tells the jury to disregard all your comments.
That's right.
All.
Then he goes in and says, he can't, I had mentioned the fact that there were no local witnesses called. And, you know, and I don't remember exactly how I put it, but he then instructs the jury that the defendants could not call local witnesses to vouch for them, which, first of all, it was not for vouching. It was for standard of care and diagnosis and damages and all the rest of it. There's not one case I could find anywhere which says you can't call a local physician in support of another local physician. So he's telling the jury that what I'm doing is I'm lying to him, and he's giving him exactly the wrong instruction. He then tells the jury, and this is all during this period of time with the quote unquote curative instruction followed by jury instruction. He then says that the defendant, as well as the court, let me go back. It was the defendant's as well as the court's obligation to make evidentiary rulings. So that now these folks are sitting up there on the bench with you. And I'm in the cellar, so to speak. It is so wrong what was said. It was reversible error right then and there. He's saying basically I'm a liar. He's saying that the law, which is absolutely correct about missing witness and local witnesses, is as I said, it was correct. He's telling the jury I'm intentionally misleading them. And then he goes through in his decisions, he then has to go dehors the record to say how bad I'm behaving. And the jury is now absolutely convinced that I am not worth listening to, and my clients, who we all know are their credibility is dependent on my credibility. And he has completely destroyed me. There's a time where I say something to Dr. Hayes, and I say, the judge says something to me, and I say, fine. And the judge says, I told you about gratuitous comments. Throughout the trial, no matter what I said, Judge Lemondola was angry with me, not correcting me. He was angry with me over it. And the jury knew this. It was obvious to everyone. There's quote after quote. And in the jury instructions and the curative instruction, he might have just as well have said, I'm dismissing the case now. The jury was no doubt being told, throw him out of the courtroom because this guy is he's trying to pull a fast one on you. And I was right about the law, Your Honor.
Right. Now, I know you got a lot of other issues, but time, I wanted to let you be heard on that because I know that's very important to your
Oh, it's absolutely crucial.
So we gave you a little extra time on that. I think we can You want to rely on your brief for the remaining points with the understanding that we reviewed them all very carefully.
And I'm sure you have. Yes, absolutely. Yeah. Thank you.
You, Mr. Bruckner? And which defendant do you have?
Yes, the court, Dustin Blocker, on behalf of Doctors Patel, Chan, Alexander, and Costers. Those are 3 residents and 1 fellow. They were not the attending physicians, were the ones with ultimate supervisory authority. I'd like to start with weight of the evidence and then turn towards the missing witness charge. Supreme Court properly refused to disturb the jury verdict that following a nearly 3-week trial found in favor of defendants. The verdict was not against the weight of the evidence. Plaintiff argues that defendants should have recognized that the decedent had an acute GI bleed, but ample evidence refuted that claim. Decedent had a complex medical history, and although he proved to have an ulcer, it presented in a highly unusual and atypical way. Decedent had been complaining about chest pains for several weeks. He had never reported any abdominal issues. And as numerous witnesses testified, a person with an ulcer will have some GI symptoms. They will have pain, or if they have an acute bleed, as in this case, they'd be vomiting blood. Decedent, however, had no such symptoms.
Well, you know, counsel's relying on the fact that the bun numbers went up, creatine numbers went down drastically. That's an indication it was not what they diagnosed, which was dehydration, right? He also raised the issue of 10% drop in the hemoglobin, hemocratic levels. And he said there's no that is totally inconsistent with the diagnosis that was derived. Your response to that?
Yes, that was his theory to the jury.
Yeah.
And we had expert testimony to refute that the jury could reasonably correct. There was testimony that decedent was a medically complex person. He was very volume sensitive. He had diabetes insipidus, meaning his body had trouble maintaining fluid balance, and that those numbers alone, just looking at those numbers, do not show an internal bleed. And he wasn't diagnosed with dehydration. They're trying to figure out what the possible causes of his symptoms are. They're very non-specific symptoms.
One symptom was low blood pressure.
What was that?
One symptom was low blood pressure.
No, Your Honor, and we're gonna
as it developed.
Yeah, as it developed. So I'd like to start maybe. What I was just referring to was actually for Dr. Patel when he's under the care of the medical service from 3:15 to 7 to 6 or so. So that's one thing. Then his blood pressure does drop, and at that point, and this is the expert testimony, defendants responded appropriately by working to stabilize the decedent so imaging can be performed or further testing to figure out what the potential cause was.
How about CBCs? If they had done serially, not just once and then wait another hour and then order them stat, does your expert disagree that could have shown the problem much more readily?
Yes, Your Honor, these are all things that was amply fleshed out at trial. This was his, there was front and center to the jury. This was the crux of his case. And I think, Your Honor.
But was that the answer? And I get like weight is really hard to overcome. He's got a heavy burden on weight. That's why we have jury trials, right?
So
we're not, but was there some good explanation for these?
Yes.
Okay.
Yes, Your Honor. Okay. First, I want to bifurcate it before 7 p.m., which is just Dr. Patel, and after 7 p.m., because 7 p.m. is when his blood pressure unexpectedly drops. Before 7 p.m., he's hemodynamically stable through the morning into the afternoon. Multiple witnesses testified. He's also eating a sandwich. He's stabilized. He doesn't faint. That's contrary to what plaintiff said. He feels a little dizzy at some point, sits back down, and recovers. At that point, our expert said he's been hemodynamically stable. His blood levels are close to normal, a little below, but nothing out of the ordinary. And the appropriate thing is to order follow-up testing, which will be done early the next morning. That there's no indication, this is Dr. Kaufman, no indication has to be done any sooner. Then, 7 p.m., his blood pressure unexpectedly drops. And from that point, and this is what our expert testifies, They do everything appropriate. They don't know what's going on with him and they need
What do they do
imaging.
at that point?
What was that?
They do another CBC
One is drawn at 7:30 PM.
without the stat request. So there's just lingering down there, like they did this later and they came back almost immediately.
No, it's not lingering, Your Honor. And this is what our expert, Dr. Kaufman testified. This is 1726. They're doing everything appropriate, which is they actually start to think maybe there is an internal bleed. That could be an issue, could be a pulmonary embolism, it could be an aortic dissection. There's a lot of different possibilities. So what we need is a roadmap. We need to do imaging. And that's the appropriate thing. And his numbers never get low enough. Even at 8.6, which is what the blood results showed from the CBC, even our experts said, even if they have that information, what they need to be doing is exactly what they're doing, is figuring out where there's a bleed. And if so, how to do it. You can't, and then in this case, it presented in a highly unusual way in that there was no physical manifestation of it, that there was usually a person's body tells you where it is. So as our expert said, this was excellent care, doing everything you need to do, which is imaging. You need the roadmap. You can't just start putting in.
Ask you a question? Can I ask you a question? First of all, his blood pressure dropped from the time he got into the ER at 11 o'clock. He had a blood pressure of 125/82. At 1 o'clock, it was down to 105/73. And then at 2:39, it was 95/45. So it was constantly dropping, and that's even before he got there. That's still in the ED. And then his H&H, it went from the 13 down to what you said, 8. That's a significant drop. Wouldn't that indicate that you should have ordered a CBC stat?
I mean, Your Honor, there's a lot baked in there. I think you looked at a handful of blood pressure readings. I don't have medical records in front of me. It did not continuously drop. At one point, the only time it did, drop significantly was at 7 p.m. and that's a different phase of it. And the testimony on the blood levels, again, this is all before the jury, and we have an expert explaining that these numbers, you're coming to a conclusion about them, and we have a jury, we have an expert, we have multiple experts explaining the numbers aren't what what plaintiff's experts say they are, that's not the same significance. You have to look at this person in context, someone who's very volume sensitive, their numbers go up and down, and that you have to look at the whole patient, and that he is hemodynamically stable until 7 p.m. And at that point, they think, we need to stabilize him. There could be a bigger issue here, but you figure that out through imaging. That's what our expert said. You figure that out through imaging, because if he does need surgery, you need a roadmap. You can't just cut someone open and start looking around when you have no GI issues being reported up until that point.
Right, and look, I don't want to spend too much time on weight because there's some legal issues, but
yeah,
you would agree that there was I don't call it misdiagnosis, but failure to properly diagnose his condition at the outset. I'm not saying it was their fault. I'm not saying it's your client's fault, but they did not properly. He had a GI bleed that was in the process of killing him and did kill him. And it was not diagnosed when he got in there, and he sat there for hours and hours and hours. I think he saw one actual non-resident physician the whole time. And so the question really is, it was misdiagnosed, but was it negligence to do that? And we can take a look at that.
Yes, Your Honor. I think the key word there was proper, and that this was the whole dispute of the trial, that ample expert evidence where we had our story, and as Supreme Court found, that this couldn't credit our version of events, that it is true that he had an ulcer, but it presented in a highly atypical way. He had no accompanying symptoms.
Sometimes people die and it's not necessarily negligence or malpractice.
Yes,
do you want to get to
missing witness?
Let's do the blood transfusion first. That affects, according to counsel, all the defendants.
Yeah, that's actually, I feel quite strong. That is incorrect. If you look at his brief, the blood transfusion is
ER defendants.
Is only about and can I just say ED, emergency department, ED defendants. That's only about them. And why is that only about them? Because he got to introduce testimony to say that resident defendants we represent, should have considered a blood transfusion. And our expert, Dr. Kaufman, responds directly to that because he gets to put in proof to argue that the residents should have been considering a blood transfusion.
So if we agree with you, we just limit it to the ED defendants.
Yes, Your Honor, but it would be, that's true. And as framed in his brief, it's just about the ED defendant.
I was surprised to hear he wanted to, I mean,
Yeah, and
I get why he wants to get all 7 in on that, but if he loses on the missing witness, but.
And so just briefly, because
am I right that the issue on this is the preclusion of this theory was based on unfair surprise? Your experts like, oh my goodness, I had no idea they were going to say there's a deviation on failure to do a blood transfusion, right? That was that was the basis of the motion and the ruling.
That's right, and if
lack of notice.
That's my, and can if I defer to my the counsel for ED defendants to address that, because that is, yes, that's my understanding of what.
Okay, that's not your ballywick here this morning.
Exactly.
Your clients are the missing witnesses, so you want to hop into that.
Yes, please. Thank you, Your Honor. And the court properly exercised its discretion to reject that missing witness charge. The defendant's testimony, the residents, would have been cumulative. There was extensive trial record.
Cumulative to the notes.
Cumulative to multiple sources of evidence. Yes, yeah.
Mainly notes that you can't cross-examine.
Incorrect. No, Your Honor. I mean, that's one. There's voluminous medical records, the contemporary.
You agree, you can't put notes on the stand and start asking the notes some questions, right?
Yeah, yes, Your Honor. That is correct, but there's no dispute about what the residents did. There's no dispute. The claim here is what they didn't do, and they should have ordered this test. They should have ordered that test.
So it's more of a harmless. Let's say that you should have given, the court should have given a harmless. A missing witness charge, and they were parties. So maybe there's a heightened burden there. You're saying that it's essentially harmless because there's no dispute what these residents did and didn't do. It's really for the jury was. Based on the expert testimony, was there a deviation? Should they have done something different? And so it really, their testimony, this is not a who did what.
Exactly, Your Honor.
Case.
This is a battle of the experts. This is not a battle of the fact witnesses. There is no dispute. His claim is crystal clear. They should have ordered this test. They should have ordered that test. And there's no dispute that those tests were in order. The sole question is whether that complied with the standard of care. And that was a battle of the experts. And I just want to talk about the cumulativeness point. It's not just the medical records. We'll go there. There's also the experts who testified, explain these records in detail. There's fact witnesses. Dr. Cleary talked about working with Dr. Patel to devise assessment and plan. She's the attending physician. She also talked about talking to Dr. Chan, and Dr. Costers likewise talked about working with Dr. Alexander. And just briefly, Supreme Court didn't preclude him from asking about the contents of that conversation. Supreme Court rather precluded him from going beyond the scope of direct. And then also there's deposition transcripts that counsel read from the resident defendants. And again, there's no dispute about what they did. It's solely whether it comply with the standard of care.
Counselor, just what I'm focusing on is the fact that these folks are full parties. They're on the verdict sheet and they sit there through trial and they never take the stand. There's probably a reason why the PJI has a separate charge for parties directly specific for them, and why the language in that charge is different and stronger. Because the presumption is that a party will get on the stand and deny or otherwise explain. Here, that didn't happen. So you say it's cumulative. Well, to the Justice Presiding's point, you can't cross-examine the records. And sometimes, even though doctors will say, right, that if it didn't happen, if it's not in the record, it didn't happen. Well, a lot of times they also say, well, it did happen, but it's not in the record for this reason. So, the fact that they're parties and the language of that charge is so strong, that makes it awfully difficult, at least from my perspective, to say that, you don't have to testify, but then you take the chance of a missing witness. That's the way it goes.
Correct, Your Honor. I mean, you're correct about that. There's a separate charge, a few things. That's not what preliminarily, you look at the charge he requested.
Where is that in the record?
It's in our brief, Your Honor. It's
that's why I asked where is it in the record?
I'm sorry, I could do a letter. We quote it, we do a block quote in our brief. I don't have the exact.
I think it's not in the record is what my point.
No, I'm sorry, it is, and if you
Okay,
get,
then they'll find it.
it is,
Fine.
we block quote it because it's a very unwieldy, confusing charge where he asks the court, where he asks the
But
jury.
that wasn't the substance of your objection. You didn't object and say that this particular charge is bad. You said it was cumulative. So no charge should be given. So I'm not sure that that's going to pin the plaintiff down.
It is, Your Honor, because
Go ahead.
we objected to both because we said if when he proposes the charge, we could look at it and make a decision about whether to have them testify on the discrete issues that are supposed to be subject to the charge. And instead, he comes back with this unwieldy, confusing 12 overlapping issues that just say standard of care, just lists the entire case. That's not what a missing witness charge isn't drawn adverse inference against the party and just find against them. It's on discrete issues on which they're expected to give non-cumulative material testimony.
Would you agree that your client has the burden of proof on cumulative?
Yes, Your Honor, we agree, at least the initial, I think the ultimate burden is always on plaintiff, but when we come back and say it's cumulative, yeah, and that's
because they're not in a position to know. It's your clients who know their testimony.
Right, but but that's it's irrelevant because we did show and we made that showing that it would be cumulative. And what
the court said no missing witness charge, but Mr. Kaminsky can make use of this in a summation, and he did. No, he went pretty hard on it, but maybe there were some statements that went over the line. There were a lot that were not over the line. And again, he had permission from Judge Lamondola to do that. And then all of his comments on this subject matter get stricken, all of them. Is that a problem for us?
No, Your Honor, because this is abuse of discretion standard, and here Supreme Court sitting there appropriately issued an instruction because counsel's remarks, he was given license to make fair comment. And instead he made false and prejudicial remarks. And let's just go through them. There's 3 different kinds.
What was false?
False. He told the jury, the residents, would not testify. They refused to testify, but they didn't refuse. Refuse means you were asked and you declined.
And so if he said did not testify, that's fine. Just refuse. I mean, they could have refused. He didn't know.
Well, no, he didn't know because he could have called them and he didn't. And defense counsel never called them and they didn't refuse. They didn't refuse to testify.
They were never asked to testify.
Exactly. They were on plaintiff's list. He could have called them.
Okay.
They were on, and defendant was clear that we're not.
We've seen a lot of misrepresentations.
Okay. And then,
I mean, that's kind of low on the scale.
And then more, he used inflammatory remarks. He's repeatedly saying they don't have the guts to testify, and that's highly inflammatory.
Yeah, it's
and then
a little stronger. Okay.
And then counsel urged the jury to affirm this. I'm quoting, affirm punishment. And then he connects it to a quote, people who won't get on the stand. He's tying, even though punitive damages are not available, and and it's well aware, he ties the idea of punishment to quote, people who won't get on the stand.
Right, but I guess my question was, there were some legitimate questions on their failure to testify. There were some legitimate comments that he made in the summation, right? There were some, in your view, illegitimate comments. The court struck them all. Couldn't have been, I asked you to disregard this particular comment that they refused. I regard that they, these, you kind of separated them out. He just lumped them all together and the jury rejected everything he said.
No, Your Honor, plaintiff's counsel never requested that fine tuning
because he didn't want any.
Exactly, Your Honor. And in this case, when he makes so many inflammatory remarks, to go back and individually bring them again to the jury's attention, that the Supreme Court could rightfully think that would do more harm than good and only exacerbate and have the jury focus on those inflammatory false remarks. And again, tying the idea you should punish them, quote, people who don't get on the stand. And if I may just briefly to Justice Curran's focus on summary judgment papers, there was a different theory at trial pursued by plaintiff. I mean, you talk about leave of fed for Dr. Chan and that somehow she should have given leave of blood along with leave of fed. He completely abandoned that claim at trial. He didn't pursue that theory at all. You won't see that. So I just think don't look to what he said at summary judgment because that's not the case he actually litigated at trial.
Look, I looked very carefully at the experts' affidavits on summary judgment from the plaintiff on this blood transfusion. And level spread is one theory. If you give it, you give that, you should, there's a lot of standalone blood transfusions too.
And as to the resident defendants, she got to make that point and make that argument to the jury, and they rejected it because they heard from our expert, Dr. Kaufman. Again, the blood transfusion, he got to have his experts talk about from Dr. Ashcroft and
With respect to your client.
yes, exactly,
Not-
exactly. And we had our expert
Okay.
respond, no, even with his blood levels, even with the 8.6 hematocrit, a blood transfusion wasn't required by the standard of care. They instead should have been doing, which is exactly what they were doing, which is get the imaging, figure out if and where he's bleeding, and then can address the cause that way. You don't just start pumping someone full of blood, you know, where just because you're not sure what's going on. And his experts never said anything to the contrary. And unless the court has any questions, we ask you affirm.
Thank you very
And
much.
then
Mr. Hunt is next.
Yes, Your Honor. I'm Kevin Hunt. I represent Dr. Clary. I would just like to address a very few issues. Starting first with that transfusion issue. The plaintiff very definitely was allowed to try to prove a failure against my client, a failure to give a transfusion, to order a transfusion. There was never any preclusion by Judge Lamondola of such a theory from the plaintiff's expert, Dr. Ashcraft, directed at my client. As my colleague just pointed out, that there's an issue of fact there. There was a battle of the experts. My expert, Dr. Hayes, also opposed, disagreed with that criticism, and therefore created this battle of the experts, classic issue. You know, should the patient have been given a transfusion or not when Dr. Clary became involved? So that issue doesn't touch my client.
Okay.
Your Honor, Justice, I don't believe the missing witness issue should touch my client either. I rested my case before the case began, essentially against the residents.
Your client testified?
Yes, Your Honor, she did testify.
I guess the theory Mr. Kaminsky is making is that your client was the attending physician supervising, was it Chan?
Yes, sir.
And therefore, if Chan goes down, your client goes down. And so there's some bleed over into your client. You want to address that one?
I understand the point. I think it would be terribly unfair to my client, however, if she were to be dragged down by this decision made by a different counsel on behalf of their attorneys, which I do not criticize. I don't want to be mistaken there. At a minimum, Judge, I think I should have been given notice from counsel before I rested my case, because obviously I didn't call Dr. Chan, I didn't call Dr. Patel. I think I would have been entitled at least to some kind of notice from counsel that he might be thinking about missing witness charge against my client in case I don't call those physicians. Obviously I was never afforded that opportunity. And as I said, the decision not to call those physicians was made by their attorney, and therefore for my client to be caught awash in that would be an injustice. So.
It remind me, the record goes like 23 volumes, and we have so many big cases on today's. I forget, I should know this, but the deposition, the three missing witnesses here for the question, their deposition testimony was read into the record at some points in the trial, right?
That's correct.
So are they truly missing witnesses if their side of the story was told and there were the deposition? I assume Mr. Kaminsky was the one asking questions, right?
Yes, Your Honor, he was.
And so that gets to the jury on all three of them?
Again, I
struggle with counsel there.
I struggle with the record. It is a massive one. I do believe that's correct. I wanted to add, and again, this forgive me, but on the idea that it would have been cumulative against these residents, the residents had a physician, an expert witness who was called on their behalf, who explained his opinion about what they did or what they didn't do and how that.
We get there, but he wasn't at the scene at the time.
Yes, sir.
So
thank you, Judge.
Yeah.
The last thing I wanted to address, and if Your Honors have questions, I'd be happy to answer it as well. I know I don't need my whole 15 minutes. Comes down to the acrimony that ended up pervading this trial
Now, my colleague attributes that to Justice Lamondola. I can't disagree more. He referred to the issue of using of the word fine. Mr. Kaminsky was criticized by the judge for his use of that word a few times. And Your Honor, it came in the context not of an attorney, and I'm sure I used the word myself, maybe I have even this morning, who in response to a comment from the court would say, fine, Your Honor, I understand your decision, or that's what it can mean. I understand your decision. I respect your decision. I will move on. Fine. That wasn't how the word was used in the trial. And I was, along with Mr. Kaminsky, trial counsel. I was there for all 3 weeks. I could not believe the Judge Lamondola showed in dealing with conduct by my colleague. And so that after a while, when Mr. Kaminsky would utter that word, fine, he was doing it defiantly with disrespect and dishonor to the system, to the judicial system. And so I just wanted to end on that note, unless Your Honors have anything else you'd like to ask.
Hearing none, thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. I'm here on behalf of the emergency department providers, nurse practitioner Kelly Sarens and Dr. Lauren Pipus. I know Your Honors are interested in the transfusion issue, and I'm happy to get that. I wanted to just make a few minor points sort of on the way. Counsel for the plaintiff mentioned that after 3 p.m., David was in a limbo, in a purgatory. Untrue. Plaintiff stipulated that as of 3:15 p.m., the care was transferred from the ED to the medicine service.
He didn't arrive on the 6th floor until 6 something, right?
Correct, Your Honor.
So that's what they're saying. He's in purgatory. I mean, he's in limbo.
He was aboard.
He's done in ED, and they're waiting for a room, I guess, on the 6th floor. So how would you describe that 3-hour period?
During that 3-hour period, he was what's called a border patient. One of Mr. Kaminsky's own witnesses testified that's what's done.
What is it? I'm sorry, I missed it.
Border, like a boarding house. He was being boarded in the emergency department, and it's stipulated and agreed that his care had been transferred, regardless of his physical location, to the medicine service, Dr. Patel, Dr. Cleary at 3:15. Plaintiffs only offered a single expert who testified to any deviation from the standard of care by the emergency department.
So your client's time period is 11 a.m. roughly to 3:15 p.m.
Correct. 4 hours and 25 minutes.
Two defendants, Sarah and the nurse, and Dr. Pipus.
Correct. Yep.
And the theory there is failure to diagnose GI bleed, failure to give a blood transfusion.
Your Honor, the only deviation that plaintiff's only expert in emergency medicine testified to was an alleged failure to repeat the CBC within 2 to 4 hours for a patient who was in the emergency department for 4 hours and 25 minutes. Earlier, there was reference by Mr. Kaminsky to an alleged failure to do a CBC stat. That was not the deviation that Dr. Bird alleged. He made a lot of vague, generalized comments during his testimony that the only thing he could think of was that it was a GI bleed. That's the only thing he could think of. But when he was asked to identify any deviation by the ED providers to a reasonable degree of medical certainty, there was only one, and it was the failure to repeat the CBC within 2 to 4 hours.
I thought it was also failure to diagnose GI bleed based on the blood level that dropped from 3 days, the 10%, the bun levels. That's not part of the failure to diagnose. If he had those tests had been correctly interpreted, then they would have realized that there was internal bleeding. I thought that was the theory against your two clients.
Dr. Bird made general allegations in response to questions by Mr. Kaminsky that there was a failure to diagnose. Yes, but when he was asked to identify a deviation, that was the only one, was the failure to repeat the CBC.
In his expert affidavit, I see, well, it's unnamed on summary judgment. but this is the board certified internal medicine physician.
Mhm.
The longer one, there's two of them in there.
Mhm.
And page
Well,
9.
counsel, you didn't repeat the CBC within the 2 hours, did you?
There was only one CBC done while he was in the emergency department, Judge, and our expert, Dr. Bartfield, testified that that was well within the standard of care, setting up a prototypical battle of the experts, which defeats Mr. Kaminsky's weight of the evidence argument.
I see a lot of allegations here in the expert on summary judgment
Mhm.
that were not allowed at trial against your clients. Page 9, paragraph 38, David should have immediately been transfused with blood products. If he had been transfused, he would have survived. I believe those are against your clients, right? I see on page, the next page, paragraph 44, the failure to give blood products, the decision instead to give Levelpred also caused his death. If David had been getting continual blood transfusion products in an amount greater than he was bleeding out, he would have had a different result. I mean, I could go on for about 20 minutes with all these blood trans. I know all of them not are against your client, but some are. And so his argument is at trial, there's no surprise. There should have been no surprise to your experts and your clients and you that this was failure to give a blood transfusion was going to be a theory of deviation. That's their argument based on summary judgment is just one reason why. What do you say to that?
It's sort of a multi-step process, Your Honor. First, the issue is not, are we surprised? The issue is, did the plaintiff plead this as a deviation? It wasn't in his complaint. It wasn't in his amended complaint. It wasn't in any of his
It was in his expert's affidavit.
It wasn't in any of his pre-note of issue bills or particulars. Your Honor's focusing on the internal medicine affidavit and the general surgery affidavit that were attached to his opposition to our motion for summary judgment, and then also attached to his expert witness disclosure. I went through and I counted the references in my brief. Those affidavits reference transfusion on 13 different pages. I mean, there's a lot of references, but this is the critical point. They all relate to the time period after David left the care of the ED, the time the plaintiff has stipulated that he left the care of the ED. And Justice Curran, you asked a very incisive question. Which doctors? There's a ton of allegations that he was not given a transfusion in conjunction with the Levophed. That was Dr. Chan. That was hours after he left the care of the emergency room. So no.
We just heard from your client, little point fingers with suspenders, that all this blood transfusion goes on your two clients. You don't agree with esteemed counsel on that, I guess.
I don't disagree or agree. I think that the point is this. Plaintiff was allowed to put in substantial evidence regarding his blood transfusion theory with respect to Dr. Cleary and with respect to the resident defendants, both through his general surgeon, Dr. Freed, and through his hospitalist, Dr. Ashcraft. They all testified that after David left the emergency department, he could have been transfused. And then plaintiff extensively cross-examined the resident defendant expert in critical care, Dr. Kaufman, on the transfusion issue. And the reason that this is important is because the jury resoundingly rejected the transfusion theory. So even if there was error, and I submit that there was not, because this was an unpled theory, it's harmless because the jury rejected a transfusion theory for care that happened hours after David left the emergency room, where he had severely decompensated and his situation had dramatically changed.
Would it be harmless on the ground that I indicated earlier that the theory was failure to diagnose internal bleeding, transfusion only is a treatment for that, and the jury found no failure to diagnose internal bleeding, so there'd be no need to give a blood transfusion if there's no internal bleeding.
And that's correct, Your Honor. That's the second reason it's harmless error. The third reason it's harmless error is because I believe Your Honor said something to the effect of, why not give it to him and figure it out later? That's a causation theory. That's a loss of chance theory. And that is harmless as a matter of law because the jury never got past deviation. So we respectfully submit that this was an unpled theory. It was properly precluded. And even if it wasn't, for those three reasons, it was completely harmless and certainly doesn't warrant a new trial. Just
Can I just ask you one thing? Because he did plead in his bill of particulars and his complaints, he alleged that they failed, that the ED personnel failed to blood type and cross match the blood, even though they were aware of the substantial drop in his H&H levels. And that was pled from the beginning. So I don't see how you're saying it was unpled.
Your Honor, and that was something that Judge Lamondola discussed in his decision in order, is there are two separate allegations. Did you type and cross-match his blood in order to prepare for a possible transfusion later in the day, or did you actually transfuse him? And the allegation of type and cross-matching has its own flaws. First, it was in the early pleadings, but it was never in any iteration of his expert disclosure. Second, it was preparatory and a back door into this unpled transfusion theory. And also, if the jury didn't buy a transfusion theory, it certainly wasn't going to buy a theory that the ED hours before failed to prepare his blood for a transfusion the jury never thought he should have been given.
Counsel,
Well,
real
they
quick.
wouldn't have known, but had he done the testing, had he done a full CBC within a quicker period of time, then maybe they would have been able to tie that together.
Well, Your Honor, at some point, we reached sort of the area of speculation. And for purposes of the CBC, that was just a prototypical battle of the experts. And it's pure speculation beyond that to conclude what his hemoglobin level would have been at any point when he was in the emergency department. Because I'd remind the court that even the plaintiff's own expert on page, I think it's 373 of the record, conceded that David was stable the entire time he was in the emergency room.
Counsel, just real quick, I'm going to say this out and then see if you disagree with this. I don't know of any case law that says that all of the deviations alleged by the plaintiff must be in the complaint or the bill of particulars. And in fact, I'm aware of case law that says that a plaintiff, it does not require in a med mal case to hire an expert to prepare a bill of particulars and set forth all the deviations. So the whole unpled thing with respect to particular deviations, that's really not the case. Do you agree?
Respectfully, I don't agree. I think that as a matter of fundamental principles, a defendant in a med mal case is entitled to notice of the allegations. Also,
allegations is one thing. I'm talking about the particular deviations. Every deviation that the plaintiff might allege, I don't think that has to go in the complaint. And I know it doesn't have to go in the bill of particulars because we have case law from this court that says you don't have to hire an expert to prepare a bill and you don't need to set forth all the deviations.
I would draw this sort of distinction for Your Honor. A plaintiff can allege a failure to test. A plaintiff doesn't have to specify a failure to do a CBC. It's facts. A plaintiff in a med mal case doesn't have to drill down on all of those expert facts. But plaintiff made this a failure to diagnose case. That's what this case was about. That is what was tried. Here today, he's trying to argue a failure to treat, and that was not what was alleged. Just a few very minor points, Your Honor. The cumulative issue, Dr. Bird was the only expert who offered any testimony about the standard of care for the ED. Not a single word of his testimony was precluded as cumulative. And in any event, as we argue at length in our brief, the plaintiff's cumulative argument is harmless because it goes to loss of chance, which is a causation theory, which the jury never reached. The missing witness, I think Mr. Kaminsky appropriately conceded that it has nothing to do with the emergency department physicians. The most he could say in his brief was that Dr. Patel could potentially have clarified the time of the transfer. Mr. Kaminsky clarified that for himself at trial when he stipulated to the time of transfer. So if the court is going to reverse on the missing witness issue, only I would respectfully request that Dr. Pipus and nurse practitioner Sharon's be severed out and that the judgment against him be affirmed.
Thank you, counsel. Case 386, Warren versus Zoning Board of Appeals. 386, Justice Curran is recused on this case. Good afternoon.
Good afternoon, Your Honors.
Mr. Warren is the appellant. He has submitted.
Yes,
You are welcome to be heard. I will say we have reviewed your very comprehensive brief, and you're welcome to add a few points if you wish to do so at this time. Nobody would vigorously object if you didn't.
having been up here enough times over my 43 years, I know when to sit down and shut up. But if you have a feeling of deja vu, this is the case because it has been here since 2009.
You're quite familiar with the Casiano
Yes.
recreational facility that's been challenged numerous times, has been upheld every single time.
You understand perfectly, Your Honor. And with that, unless there are any questions.
We appreciate you coming in. Sorry
Thank you.
for the wait.
No, not a problem.
Mr. Cosgrove?
Judge, I can't say any more than what's been written and what's been
He didn't
said.
say much, so
And I don't need to say much. Just know that Canisius High School, the use of these fields have been done for athletic purposes for high school students. There's been no change. The only change that you can say went from football to baseball, and that's it. And I would just ask the court that as we progress forward, Mr. Warren likes to have my client, Canisius High School, and I have Mr. Trapp's client, the town of West Seneca. We've had to do a lot of work in defending these cases against Mr. Warren, and we hope that it ends at some point soon.
All right, thank you so much.
Thank you.
Justice Curran is coming back in for the next two cases, which are going to be 387, and we'll call 392 at the same time. 387 and 392 are both virtual, as they are related. It's been a while. Hopefully they haven't left us for lunch. No, there's Mr. Marriott.
Hi, good afternoon, Your Honor.
And we have opposing counsel. Thank you for your patience this afternoon. You may proceed.
Thank you, and may it please the court. My name is Stuart Mermelstein. I represent the plaintiffs in these appeals, Monique H. and IH. I would first like to address the motion to vacate that was denied by the lower court. This is the motion to vacate an order that was entered back in 2002 in a case that was originally brought when the two plaintiffs in this case were young children. The court has inherent discretionary power to vacate a prior order. And the circumstances of this case are very unique and warrant the exercise of this authority. And let me explain why that's the case. An action was brought in 1991 by the biological mother of these plaintiffs when they were approximately 10 and 11 years old. They had been at that point for years in foster care. They weren't in the custody of the biological mother. So the action was prosecuted by a non-custodial parent and has submitted an affidavit form. The plaintiffs were unaware of this lawsuit and what it was about. The lawsuit, of course, alleged that there was sexual abuse that occurred in a foster care placement, the same sexual abuse that is being alleged in the current suit. But the individual plaintiffs were not aware of the case. They
themselves, counselors, didn't they bring their own motion in like 2002? Didn't they substitute themselves when they became of age? Didn't they substitute themselves and get counsel?
They were named plaintiffs. Whether or not they authorized that change or not, the plaintiffs have no recollection of doing it. There's nothing in the record to show a retainer in which they retain, once they reach the age of majority, that they retain the attorneys who were representing the mother as their guardian while they were
All right, well, I think, Counsel, this is a res judicata argument, really, and I think your point is that res judicata was not raised in the answer. Estoppel was different concepts, and therefore they waived the defense. And you should be able to go proceed, even though the prior action had been dismissed a long time ago. They get to start all over again. Is that an accurate summary of where we are now?
That's correct. That's one of the issues that's being raised. I wanted to begin with really the equities of this matter. But in terms of the res judicata point, the defendant pled in their answer defense of laches, waiver, and estoppel, very general reference to equitable defenses. They did not mention res judicata. What they are really asserting now is a defense of res judicata. They are saying that there's this 2002 order granting summary judgment, which was an adjudication between the same parties, and that these plaintiffs are now bound by that order and judgment. But the pleading of very vaguely laches, waiver, and estoppel did not provide these plaintiffs with notice that res judicata was an issue in this case. There's certainly no reference to that defense of res judicata until substantially later, when the defendant moved for summary judgment on the basis of this 1991 action. So because the defense of res judicata was not raised in the pleadings under 3211A5 and 3211E of the CPLR, that defense is waived.
But if it had been asserted in the answer, you're in a pretty tough spot here. Would you agree with that one?
I would argue that if it had been asserted, I would argue that the 2002 order is not res judicata because a prior judgment has to be on the merits. And
you don't think res judicata is on the, what about if it were dismissed on standing ground, statute of limitations ground? That's not on the merits. You can then sue later again on that.
I can understand, but this is different from, say, statute of limitations, because this is an immunity offense. This is the question of, does the plaintiff have the right to sue? That's not the merits.
Gotcha.
This is the question of the merits was the elements of the negligence cause of action, whether there was notice. None of that is dealt with in the motion that was brought by the defendant here. And so the question is whether that original decision dealt with the merits. It did not. It dealt with the question of whether the plaintiff could sue the defendant. And now the particular objection to the suit based on res judicata is now overcome, or based on the prior judgment, now overcome by the law as it stands, which makes it clear, the law is clear now that plaintiff has his cause of action, can sue for negligent supervision or foster care.
What if the plaintiffs won a money judgment before? I know the other one got dismissed. What if they won a money judgment and then they sue again? It's like, yeah, we want some more money. Res judicata there.
Well, if the plaintiff before received a judgment, that's a good question. I imagine.
Well, Counselor, wouldn't that'd be on the merits?
But that's not what happened.
Counselor, that would have been on the merits if
That's true.
If they had obtained a judgment.
Correct.
Right.
Yeah. And this is
this one.
They would have received
unless it was a default judgment or
prosecuted their
something
claim
along those lines.
pollution.
But in any event, I think we understand your point, and then we got the other side says, well, if it's, well, yeah, we have to look at that, whether this merit issue and so forth. Pretty interesting issue.
One question, I'm sorry.
Please go ahead.
Counselor, does Weisbrod-Moore have any impact to our analysis?
Well, Weisbrod-Moore is the principal case that establishes now that there is no immunity. Again, the 2002 judgment is based on immunity decision, based on a kind of a misguided reading of the Mosher-Simons case, which was a Fourth Department decision that was after this decision was rendered in 2002
Right,
was modified by the Court of Appeals and addressed to a completely different issue, which was judicial immunity, which does not appear here. But
Okay.
the Weiss-Broad-Moore decision makes it clear that there is no immunity. The plaintiff has this cause of action, and bringing it now, if there was res judicata does not apply, then the plaintiff has a cause of action.
And what about the alternative argument that the county makes with respect to, well, even if you find that I didn't raise the proper defense, the court had the authority to grant an amendment to allow res judicata to be added to the answer. I
think that was a theoretical proposition. I don't think there was a motion to amend. I think they're saying that they could move to amend, but I think it's speculation as to how that motion.
If we were to reverse, they sounds like that's where they're headed. If we were to reverse, may want to start drawing up papers and
right. And then in terms of the test is the interest of justice. I think the interest of justice favors my client here in being able to pursue this claim.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you so much. Mr. Marriott?
Good afternoon, and may it please the court. Eric Marriott for Erie County in both of these cases. I will address, I think, all of the questions that were raised because there were some excellent questions that were just raised now. So I would like to go through a couple of the issues. First, I think Justice Ogden raised a good point when she mentioned that these individual plaintiffs, IH and Monique Henley, were substituted in the 1991 action without a guardian. And for appellant's counsel to be saying, well, they didn't have any notice of it, they weren't aware that these lawsuits were going on, and they've submitted affidavits to that effect. There's no other evidence in the record that would support that. It doesn't seem to make a whole lot of sense that these actions went on for 12 years from 1991 to 2003 when their time to appeal ran on the earlier action, and to say that neither of them had notice of it. I did mention at oral argument at the trial court level that they did testify in this previous action as well. I was in the process of getting the paperwork from the previous action, so the transcript didn't make it into the record, but I did have it at the time. And to say that they didn't have any knowledge, it's not that they were too young to understand what was going on. By the time these cases were completed in 2003, both of these plaintiffs were in their early 20s. So it's not that they would be too young to appreciate what was happening. They had a chance to appeal this 2002 order, and they didn't do so. I think getting back maybe to the res judicata point, I did mention that in my papers that we did plead estoppel, and case law shows that estoppel is one part of the broader doctrine of res judicata. The question was raised if the lower court could simply grant leave to amend to include res judicata as an affirmative defense in our answer. And not only could the lower court do that, they would also have the ability to sua sponte raise the issue of res judicata, because that's what these cases are. It's the crux of this motion, why we're here, and that's what these cases are about, is there was already an action in each of these cases more than 20 years ago that was decided on the merits. And now these plaintiffs are asking for a second bite at the apple to relitigate the same exact claim that was already dismissed on the merits with case law that is still good. And I want to mention that point as well, because the question came up, I think it was Justice Lindley mentioned about Weiss-Broad-Moore, and that case deals with the governmental function, or that case deals with statutory immunity, the statutory special duty. The governmental function immunity defense is what these cases that were here today were decided on. That's what the Mosher-Simons case deals with. And so in the Weiss-Broad-Moore decision, in the very last paragraph of that decision, Judge Troutman said we can't reach the issue of the governmental function immunity defense that Cayuga County raised in that case because it's inappropriate to discuss that at this motion to dismiss stage. And the reason being for that is because it is not a procedural defense. It is a substantive defense. In order to assess whether or not the government is entitled to the governmental function immunity defense, it's necessary to look at the facts of the case, review it on the merits, and see if it was in fact the government following a court order, engaging in discretionary action. So unless there are any questions, I think I've pretty well outlined everything else in my papers.
Thank you, Mr. Mayor.
Yeah, absolutely.
Case 388 is Scott versus Melis. Donald Scott versus Teresa Melis, PA.
Good afternoon. May it please the court, Amanda Rossi on behalf of Teresa Melis and MASH Urgent Care. As far as med-mal cases go, this one is pretty simple. We're talking about one day at an urgent care on March 1st, 2018. Now, in the days before that, the plaintiff, Mr. Scott, hadn't been feeling well. He missed some work. And his boss told him, hey, if you get a doctor's note, I won't have to dock you any more vacation. And I think we can agree that that's really the only reason why he went to the urgent care that day, because he hadn't been to a doctor for 20 years before.
Fatigued, he said, wasn't he? He was fatigued and he had having trouble going to work, and his supervisor said, if you want to get some paid, paid sick time, you got to go get checked out, right? It was more than, he was feeling ill.
Correct. Yes.
Okay, I'm sorry.
But the point being that he hadn't been to the doctor for 20 years before that, which I think is some important context here. So the records show that Mr. Scott complained of fatigue, body aches, a sore throat. He had no appetite, and he said he was drinking a lot of milk. Now, I deposed Mr. Scott.
Can I just, because I know where you're going, because your brief is very good, and you say that his affidavit creates feigned issuance of fact. In other words, he had no recollection of various things during deposition. Once his affidavit comes in, he's got suddenly miraculous, he remembers everything in detail. So the issues that you say he's feigning are about the urination, frequent urination. He says in his affidavit that he told them at the MASH, at this urgent care facility, that he was urinating frequently, and that's one feigned issue of fact. You say the other was this extreme thirst, that he never said that. But I'm looking at page 188 of the record, which is his deposition transcript, and the plaintiff was asked, what did you say to the person, to the medical provider? He said, quote, told him I was extremely thirsty, fatigued, and throwing up. So he's saying extreme thirst there at the deposition, and that seems to be consistent with what he's saying in his affidavit.
Well, 2 points on that, Judge.
Okay.
First, I agree that he said that at his deposition, but he went on to say, well, as it relates to drinking a lot of milk, that was because I was hungry. And his wife went on to explain, he couldn't keep anything down. I gave him some milk so he could get some calories. And in his affidavit.
Right before he said that, the very statement before that, he said that he says, I have no appetite. That's
Correct.
The first thing. So why is he drinking milk if he's hungry, if he has no, in other words, he kind of contradicts himself in that same sentence.
He does, Judge. But what's important is that he did say, I was drinking milk because I was hungry. Then in his affidavit, he says, I've been drinking a lot of milk because I was thirsty. So that's in conflict. But the second thing is that my expert did, taking the evidence in the light most favorable to the plaintiff, assume that he said, I was thirsty. And my expert said, that's not enough to conclude that he had diabetes.
How about extremely thirsty? Because that's a sign of diabetes, one of many.
Correct.
Extreme thirst.
I agree.
Said the word extreme thirst.
But he still said, my expert said that's not enough. The other things that he reported were non-specific. You can't just be really thirsty and be like, oh my gosh, it must be diabetes. That's not good enough.
I get you there. What about urination? Didn't he say, and I don't have it right in front of me, but he went to the bathroom a lot. He said that at the urgent care. That's not to get graphic, but I mean, that could include urination, right? Going to the bathroom a lot.
Well, he said that after he left the urgent care, that was one of the things that continued to go on for the 2 weeks where he didn't seek medical care. He did not report that
he didn't
to the providers. And that's consistent because his own testimony was, well, I was only going to the bathroom a lot because I was drinking a lot of milk. So he seemed to discount that even, 4 years after this as something that was not particularly significant and was only happening because he was drinking a lot of milk. So that fact was not something that was part of the record until this affidavit that is in conflict with the testimony.
Right.
And it should have been rejected.
Look, I think you got a lot of good fodder for cross-examination if you lose the appeal. I'm not saying you will, because you make a lot of good arguments, but these are a lot of great arguments that you can impeach him on at trial. But usually when we have feigned issues of fact from an affidavit, it directly contradicts something said. Like if he was asking his deposition, did you ever complain about a lot of urination? And he says no. Then in the affidavit, he says, I complain a lot about urination. He's got a problem. He didn't say anything about, in your view, he didn't say anything about urination at deposition. Then he said, I don't recall anything else. So is that enough to flatly contradict his later affidavit? I guess
I submit to you that it is, because he said he did not remember. I can't follow up on a non-memory, so I can't ask him any more questions. When he says I don't remember, that's kind of the end of it. And then when he comes up with this, now I am deprived from probing that memory at deposition. And so that is part of the reason why the case law says that these types of affidavits should be rejected.
Well, you could have asked, did you ever complain about your urinating a lot while you were at urgent care, right? You could have, and I'm not blaming you for not doing that, but you never asked that question.
I asked him repeatedly if he remembered anything else, and he said no. Now,
Right.
there was nothing specific in the record to make me ask that specific question at the time.
Right.
Now, of course, if I could go back in time, I would do things differently, but that's not where I was at the time. All I had was repeatedly him telling me, I don't remember. I don't remember. It was a long time ago. It was understandable. It was 4 years later.
And Ms. Rossi it seems to me the justice presiding has made the point that in order for you to prevail on this appeal, we have to agree with what you argued at page 24 of your brief. That is that the plaintiff's affidavit was offered to avoid the consequences of his deposition testimony. If we don't agree with that, then you lose. If we do agree with that, you win. Is that a fair summation of it?
I think there are other reasons to reverse, but that is a very big point in my brief. Yes, because if that affidavit is rejected, then there are no opinions by the plaintiff's expert that are valid, because he or she relied on those statements in the affidavit to say, well, you should have considered the urination and you should have considered this and you should have considered that, but it wasn't before the
thirst issue. His wife did testify. I know she didn't go into the room, but she did appear at the check-in counter, and she testifies, whether she's lying or not, I don't know, but she testifies she heard her husband complain about thirst as soon as he got there. And I mean, I guess overall, we know that he had diabetes, right? It turns out.
Yes, correct.
We know he lost his lower leg because of diabetes. We know diabetes was not diagnosed at the urgent care facility on the date that he showed up. We know he checked in, I forget the numbers, I think it was like, he was in and out of that door in 5 minutes. Like he was seen by somebody, and if they had the finger prick to check for diabetes, it was there, they didn't do it. If they had done that, maybe it would have gone another direction. So it's not outlandish that, because we know he had severe diabetes. He lost his leg somewhere after. If thirst and urination are symptoms of that, it's not out of the realm of possibility that he may have complained about those symptoms, right? Because again, he was never specifically asked about those. But I understand your point. I wouldn't want to be him in a witness chair when you come at him with these at trial, if it gets that far. But we have to decide whether his affidavit as Justice Curran gets him that far, so that you can go over him roughly with these questions.
Yes, and I think that's why it's very important to just reiterate that there was no testimony that he reported that frequent urination,
Right.
Because that's a very critical piece of this, which is why that affidavit was offered to begin with. Because
Right.
without that, there was no opposition to my expert who assumed the thirst. He assumed it. He
Right.
said it's not enough without more. Well, then we have to get more. And there wasn't anything to rely on in the record. They had to come up with this affidavit because there was nothing else to cite to.
How about the family history? That was another basis for a deviation. Your witnesses, understandably, I see a lot of people, they have no idea what they did and said with this guy, what he told them, whether they took he says they didn't take one. The expert says that's a deviation. How do we say he's not entitled to trial on that?
Well, first of all, the only time that he said that was in his affidavit, which I submit should be rejected. And so with that gone and that piece of it out, the only testimony we have is from my people who said, of course, I don't remember, but it would have been the usual practice for us to ask him a family history.
Do we
That's
know-
the only piece of evidence that we have.
If his family had a history of diabetes?
Well, I did not know until he said this in his affidavit that his aunt had diabetes. So again, it comes up in the affidavit.
Also his mom, right? I mean, that was another, I think his aunt and. they both
Yes,
had it,
his aunt and his mom.
but it's an affidavit.
Correct.
So
Yeah.
why wouldn't that, if he was asked his family history and he said his aunt and his mom, we presume he would, why would he lie about it? The medical records don't indicate that that those are not in the notes taken at the urgent care facility, that he has two relatives, close relatives with diabetes. So isn't that some circumstantial evidence he wasn't asked?
I don't agree because I think the only evidence is that he would have been asked. And
Okay.
he didn't report it. He said he did not remember what happened. How could he
Sure.
possibly remember that so specifically now? Even
Gotcha.
further removed from what happened. This
Gotcha.
affidavit was a feigned issue of fact. It needed to be rejected. And once it's rejected, my client should be awarded summary judgment. Otherwise, on the other points, I'll rest on my brief unless court has any further questions.
Thank you so much.
Thanks.
Good afternoon, Your Honors. May it please the court. Jason
Does
Keeler.
seem like your client's memory got a whole lot better over time.
Well, Your Honor, I will start out with the feigned issue of fact then. I would direct the court's attention to page 185 of the record. I believe Your Honor referenced 188 of the record. So 3 pages prior to that.
Yeah, I got it.
What brought you to Wellnow on March 1st, 2018? I felt sick. I had been out of work for over a week. I felt very fatigued, constant thirst. I was throwing up, going to the bathroom a lot, no appetite whatsoever.
Going to the bathroom a lot is urination in your view? It's not inconsistent with urination.
Exactly. And then 3 pages later, he's asked about what he told the providers after just outlining what his symptoms had been prior to going in to the MASH urgent care. And he still lists extremely thirsty, fatigued, throwing up a little bit, very similar to what he had just testified about 3 pages prior.
Well, wait, can I just, because she makes a good point. On page 185, this is what he said he felt. He doesn't say this is what he told them he felt.
Right, and then he was asked specifically, what did you tell them? And he lists basically the same things, although it's not as comprehensive as what he said.
What page does he say what he told them? 187?
188, Your Honor.
Okay, because I don't think there's anything about going to the bathroom there, right?
You're right. He omitted that part when he was testifying,
That
as
extremely-
happens from time to
That
time.
extremely thirsty.
Right.
Which is still symptom of diabetes, but doesn't get to the going to the bathroom a lot.
Right. He was fatigued, throwing up a little bit. He omits to say going to the bathroom a lot. And that's partially why the supplemental affidavit was put in, to further elaborate on what the complaints were. It's not a feigned issue of fact. It doesn't contradict anything from his testimony. It actually supports exactly what he said at page 185 about what his symptoms were. You know, he's getting asked the same question a couple different ways, and there's a little bit of variance between what his testimony is. But it can't credibly be argued that he didn't talk about at his deposition going to the bathroom a lot. And then I would reference page 302 of the record, which was from his wife, Glenda Scott's testimony. She was specifically asked, did you notice at some point that he seemed to be going to the bathroom more frequently? Yeah. And when did that start? Hard to say exactly when it started. I just noticed that he did visit the bathroom more frequently.
Right, but that's, again, it's not what his symptoms were, it's what he told the medical providers his symptoms were. That doesn't really help us much, right?
Well, in the actual MASH records, they talk about drinking a lot of milk, which, you know, when asked at when the physician assistant, Melis, was asked at her deposition, why did you ask him? What was the significance of him drinking a lot of milk? No one had any idea. It's documented in the record, but they didn't know what the significance of it was. You know, you pair that together with the plaintiff's testimony, his wife's testimony, why they were there, what their testimony was about when they checked in at the front desk, when plaintiff and his wife were together. And the testimony was that he was there, he had thirst, fatigue. His symptoms were consistent throughout his testimony, and they were just amplified.
He's stronger on thirst than he is on urination, as far as what he said at the urgent care facility. But again, it's the mere fact that he didn't say he had urination frequently at the during his deposition doesn't mean he's lying in his affidavit when he said that he did necessarily. Usually we have on these faint issues a stark contrast.
Right, they have to be flatly contradictory, saying I didn't have frequent urination, now saying I do have it, a flip-flop on the issue.
But he did say he didn't remember anything else, and then he does, so I don't know.
Well, he said he doesn't remember anything else, and I think the next question was, what about body aches? Oh yeah, I had body aches too. So clearly, his memory's not perfect. He didn't necessarily remember everything. And that's why the affidavit was put in, just to fully flesh out the issues. Backing up a big step here, this was argued in our papers below. The defendant here never actually satisfied their initial burden on summary judgment. What they offered here was an affidavit from an expert physician whose opinions were conclusory, and they completely disregarded all the deposition testimony that we just went over from Donald and Glenda Scott about excessive thirst, the urination, the fatigue, the malaise, the constant drinking of milk in the records. He asserts, just conclusory, that the hallmark symptoms of hyperglycemia associated with diabetes, such as excessive thirst and excessive urine, were absent. Well, there are references to it in the deposition, which he claims he reviewed to prepare his affidavit. And that stuff is documented in the depositions. It conflicts with what his opinion is and what the basis for his opinion was.
Right. Do you think the judge got it wrong at the front end, got it right at the back end? Either way you win.
I think he reached the correct decision ultimately by denying the motion, but I don't think the burden ever shifted here.
Right, no, we understand.
Okay. Another thing, he said they did a full and thorough medical history. Your Honor talked about that already, so I won't belabor the point, but there was a history and physicals section in the records, page 616. No notes of this type exist for this encounter. There was nothing there. They didn't document the records thoroughly. Again,
if they took his, he was in there for a matter of minutes.
I think it was 20 minutes total.
Yeah, but when he went to see the nurse, it was 5.
Correct, yeah.
Pretty sure. But anyway, we understand everything that you got to say there, I believe.
Just one other point about the differential diagnosis. Their expert says that he properly formulated a differential diagnosis. There's no differential diagnosis in the records. And when specifically asked about the differential diagnosis at her deposition, Melis testified, if I had one, it would have just been in my head. She didn't write anything down. There's no evidence that she actually formulated a differential diagnosis without speculating. And it's undisputed that they never did any testing, no finger stick tests, urine test, blood test. All of those were available. The results would have been ready in minutes. They had reason to suspect diabetes based on the presenting complaints. And even if they met their burden, we put in an expert affidavit that I think even without Donald Scott's affidavit, the expert's affidavit was sufficient to defeat summary judgment. Unless there are questions for me, I'll rely on my brief.
Thank you so much.
Thanks.
We move on to case 389, 394, and 396, the related family court cases. We have the appellants have submitted. We have the attorney for the child is appearing virtually, Hannah Webster, on 394. Ms. Webster, if you are there, she may just be waiting for 394 and submitted on the other. We'll get back to that one in a moment.
There we go.
Oh, there she is. I'm sorry. Ms. Webster, good afternoon.
Good afternoon. Thank you, Your Honors. And may it please the court. Hannah Webster of the Legal Aid Bureau on behalf of the children, Larry, Ariel, and Richard. Just briefly, our position is that the decision of the trial court to terminate the parental rights of the appellant was supported by the evidence put forth at trial, and that this court uphold the decision of the trial court. The evidence presented clearly showed that the appellant abandoned the subject children by failing to communicate or to visit with the children during the subject 6-month time frame. At disposition, it was demonstrated that at the time of the hearing and throughout the 4 years that my clients were in care, the appellant did fail to adequately address the underlying issues that brought the children into care to begin with, including but not limited to establishing sufficient housing and failing to progress in her visits with the children. As such, termination of her parental rights was determined to be in the children's best interest. Unless there are any further questions from the court, I will rest on my brief.
Thank you, Counselor.
Thank you.
We'll move on to case 390 is Tobias Shelly versus Anadaga County Legislature. Good afternoon, and thank you all of you for your patience. It's been a long wait. So my apologies to all of you. You may proceed.
Good afternoon, your honors. May it please the court. My name is Ryan Lefkowitz from Adams LeClaire on behalf of petitioner appellate Tobias Shelly, the current sheriff of Onondaga County. The court should reverse the trial court's decision granting respondents motion to dismiss because Onondaga County Law 1-2023 was unlawfully enacted without a mandatory referendum when it abolished, transferred, or curtailed Sheriff Shelly's power over the Onondaga County Penitentiary. Under Municipal Home Rule Law, Section 20, subsection 2F, a local law must be subject to mandatory referendum when it abolishes, curtails, or transfers the power of an elective officer. If a referendum is required but is not held, that local law should be held invalid. Here, local law 1-2023 transferred, abolished, or curtailed Sheriff Shelly's power because it struck from the Your Honor, it was the power to for custodial control and authority over the Onondaga County Penitentiary. The effect
Over
of
the Janesville Correctional Facility?
yes, Your Honor, Janesville's
And, okay, but over inmates, sentenced inmates at the Onondaga, not at Jamesville, but at the facility in Jamesville where they were sending sentenced inmates.
Your Honor, not just the individuals residing there and not just sentenced individuals, specifically all inmates sentenced or assigned to such facility here.
And that remains if and when Jamesville is closed, they consolidate at the Justice Center. The sheriff is still going to have control over authority over all those inmates, sentenced inmates, and inmates pending trial.
No, Your Honor.
He won't?
No, because Your Honor, respondent's argument is predicated on something that has not happened yet. Jamesville is not closed. At all points relevant to this litigation, the Onondaga County Penitentiary is located at Jamesville.
Correct. I saw that argument in the reply brief. I didn't see it raised below. Was that, I don't even think that's one is preserved. I think that's one of your better arguments, but can we just get back to the theory that does the sheriff have control over a location of the penitentiary, be it in Jamesville or wherever, or does he have authority over inmates sentenced to the penitentiary, wherever the penitentiary may be?
The language that was struck from the code by local law 1-2023, that is a language that granted the sheriff responsibility for, and I quote, the operation, maintenance, supervision, repair, custodial care, and security of the Onondaga County Penitentiary Facility.
Yes, and a penitentiary under the correctional law is the same thing as a jail, right?
No, Your Honor. Under one specific chapter of the correction law, yes, they're interchangeable. That is confined to one chapter of the correction law.
All right, so in your view, penitentiary means where you put sentenced inmates, right?
Your Honor, the code and the charter do not define penitentiary.
So what do you're saying this, the sheriff has control or authority over inmates sentenced to the penitentiary?
Sentenced or assigned to the penitentiary.
And are not inmates sentenced or assigned to the penitentiary is now going to be downtown, right?
Your Honor, there's nothing in the record that reflects that.
Not yet. That's the goal, right?
Yes, Your Honor, that's our understanding.
And I think, as I read your reply, if you're conceding a whole lot that you didn't concede before, is that if the move had already taken place, you're in a really tough position.
No, Your Honor.
No?
Because even if they were to close Jamesville, excuse me, Your Honor, under the way that the language is currently written, there is an Onondaga County Penitentiary and the sheriff's power over that penitentiary is abolished. If they passed a local law that said the Onondaga County Penitentiary is now located at the Justice Center, that would have been different.
So if they want to close a penitentiary in Jamesville and move it, let's say the penitentiary is really old or it's unneeded, they want to move it to DeWitt or downtown, wherever, they need a referendum on that? The location.
Your Honor, they could have passed a local law that closed Jamesville, and that would have been a very different issue than what we're here on today. Because if they hadn't passed local law 1-23, but they had closed the underlying penitentiary, that would have been a different situation.
Continue.
In fact, Your Honor, one of the cases that respondent relied on, Carlos versus Santos, that case contended, in that case, there was the abolishment of a police department and the town board members were statutorily vested with the power to appoint a police chief. Now, in that case, the police department had been abolished. That would be the case here if the county penitentiary had been closed, the local law 1-2023 had not been passed. Because in that case, the holding found that they still had power to appoint anyone who needed to be appointed, despite the fact that the police force was abolished. So if the penitentiary itself was closed, but the sheriff had retained the power that he had prior to 1-2023, that would fall under Carlos versus Santos. But in this case, that is not what happened. And what we can do is look at how the county passed local law 1-2017, which both the trial court and respondents admit needed to be done via mandatory referendum.
Because they say there was actual transfer of authority there from the sheriff, from the county executive to the sheriff.
Yes, Your Honor. In that case, there was a transfer, but that's not dispositive because respondents admit that to give a power to the sheriff, to convey a power, you don't need a mandatory referendum. So in that,
if you curtail or take away or limit in some way.
Exactly, Your Honor. So it was taking that power away from the county executive in 2017 that required a mandatory referendum, not giving the power to the sheriff. And in this case, the analogy here is that the same exact power that was taken from the county executive in 2017 was now taken from the sheriff by local law 1-2023. The language that I quoted earlier about operation, maintenance of the facility, receipt, housing, care, control of all sentenced or otherwise assigned individuals, that is the exact language that local law 1-2017 took from the county executive, gave to the sheriff, and has now been stripped from the sheriff. Your Honor, there's also one of the respondents' arguments that the trial court leaned into below was the idea that the sheriff following local law 1-2023 has the same custodial power over all the same detained and sentenced individuals following local law 1-2023. I'm quoting from respondent's brief there on page 25. That is incorrect because as we touched on a little bit earlier, the sheriff's authority over a facility and the individuals assigned to that facility is tied to the facility's designation as either a penitentiary or a jail. So prior to 2017, the sheriff only had authority over and custodial control of inmates in the jail and the jail itself. Following local law 1-2017, he was granted that same power over the penitentiary. Following local law 1-2023, that power over the penitentiary was stripped from him.
So the power over the penitentiary or the power over the inmates located at the penitentiary? Both,
Your Honor. The language of the code is very clear. He's tasked with operation, maintenance, supervision, repair, etc.
Can't they move the county penitentiary to another location?
Absolutely, Your Honor, but that hasn't
That's what
happened.
they're saying, that they're consolidating, and that's what they say. Yeah, you still got the penitentiary, still got all these inmates that you're in control. We're just moving you from there over here.
Your Honor, they certainly can move the location of the penitentiary. The problem here is even if they designated another location as the county penitentiary, currently under the Onondaga County Code and the Onondaga County Charter, no one is tasked with responsibility for or oversight of the penitentiary. So even if tomorrow a law was passed moving the penitentiary to the Justice Center, there's still no one assigned to administer to it. Right now, the Onondaga County Penitentiary is, and at all times relevant to this litigation, located at Janesville Correctional. And the Onondaga County Code and the Onondaga County Charter have no one in charge of the penitentiary as it stands right now. Now, the Janesville exists. There are people incarcerated there. There are people incarcerated in the penitentiary. And what respondents effectively did was they removed the authority over it before they moved or closed the penitentiary. They enacted this legislation in the wrong order. I agree with you, Your Honor, that if they had closed the penitentiary but not enacted local law 1-2023, this might be a different case.
So counsel, if I may, if I'm following your position is the sheriff, by virtue of the ordering and sequence of the passage of the local laws, no longer has control over the bricks and mortar, but nevertheless has control over the individuals that are there.
Not by
You're saying the sheriff has lost that power.
Yes, Your Honor.
But if the sheriff hasn't lost that power, then has if the sheriff still has authority over the incarcerated individuals, then has there been any diminishment in the sheriff's actual authority here?
Yes, Your Honor. The sheriff has authority over individuals sentenced or assigned to the jail. Currently, following local law 1-2023, that is the limit of his authority over the incarcerated population of Onondaga County. He does not have authority over the incarcerated population of Janesville, no more than he has authority over incarcerated juveniles, which he has never had authority over.
The Janesville Correctional, I've looked at those laws carefully, that does not refer to Janesville Correctional Facility.
No, Your Honor. It refers to the penitentiary.
Penitentiary, which could be anywhere. I mean, you can't.
Yes, Your
Like,
Honor.
500 years from now, it doesn't have to be in Janesville. Let me ask you this, if the probation department, which is under the auspices and control and supervision of the executive, county executive, let's say they're in a building downtown Syracuse and it's dilapidated, they want to move them to another location down the street. We don't need a referendum for that, do they?
No, Your Honor.
Because the county executive is still in control of probation officers and people that they supervise. How is this different with the sheriff? They're just moving the location of the penitentiary, like the probation office, to another location, still in charge of everything that goes on in there. It's just moved it.
Because, Your Honor, they have not moved it.
Okay, I know. That's the argument you make in your reply paper, and I think what you say in the reply brief is if the move has already been, has already taken place, you're in a much very different legal position.
Not necessarily, Your Honor, because if they relocate Janesville Correctional, they pass a law that says the Onondaga County Penitentiary is now at X location, let's say the Justice Center, for example. Again, there's still no one currently tasked with administering to the penitentiary's population. So if there was a penitentiary population and a jail population located in the Justice Center, we still have an issue because there's no one responsible for the penitentiary's population specifically. And Your Honor, we have at all times acknowledged that the penitentiary still exists and it is still located at Janesville. There's nothing in the record that says it has been closed, it has been moved, and respondent's brief acknowledged that a year ago there was a 1-year moratorium on the closure of Janesville.
Right, I know, it's still status quo, but how do you explain on page 7 of your brief at the bottom? It says this might be different. Mr. Williams' arguments. This might be different if the populations of the Onondaga County Jail and the County Penitentiary are combined. However, respondent's argument and Supreme Court's conclusions rely on something that has not yet happened, transferring Onondaga County Penitentiary population to the jail. So in other words, if they actually do what they want to do, you seem to be conceding that their legal arguments have merit. Do I read that wrong?
Your Honor, if they had combined the population and they had not passed local law 1-2023, this would be a very different situation because the penitentiary would be located in the Justice Center and the sheriff would still have authority over the penitentiary's population in the Justice Center.
That's not going to happen without this. I mean, I was under the impression, maybe you know the case better than I do, but they're going to still, the sheriff is still going to have authority over the inmates at the penitentiary, whatever you call it, at the Justice Center, everybody at the Justice Center, the sheriff will, right?
No, Your Honor, not under the way that local law 1-2023 amends the county code and county charter.
Okay.
Because the language that's explicitly added there and the language that's struck is any mention of the county penitentiary. Then there's more language added specific to the sheriff's control over the jail.
Because the penitentiary is being combined, they're consolidated.
Your Honor, I think we need to acknowledge a difference between moving the penitentiary to the Justice Center and eliminating having an Onondaga County Penitentiary entirely and shifting that population to the jail.
Okay.
So in one situation, we're looking at a penitentiary and a jail in the Justice Center, in which case everything I've just argued about him not having authority would apply. That was my assumption in answering that question. If we're talking about eliminating a county penitentiary entirely, so there's no acknowledgement of a county penitentiary at all in the code or the charter, as this legislation seems to hint will be the case, but that population is shifted to the Justice Center, then that might be a different situation. But again, nothing has happened that closes the Onondaga County Penitentiary, and that has to be done pursuant to approval from the Department of Corrections. So there is nothing right now that makes there not be an Onondaga County Penitentiary in existence in Onondaga County. Because there is still a penitentiary in Onondaga County, and the sheriff's power over both wherever that facility is located and the individuals that reside in that facility was stripped from him, that violates municipal home rule law and needed to be done via mandatory referendum. If you have no further questions, we just ask that the lower court's decision was reversed.
Thank you, Counsel.
May it please the court. My name is Steve Williams, and I'm here on behalf of the County of Onondaga and the Onondaga County Legislature. First, as Your Honor points out, my opponent raises an argument that was never raised below, and that is that the so-called penitentiary is still open. But I'd like to address that because my opponent has presented this argument that there's now this void in the law and that there's nobody responsible for what used to be called the penitentiary or the Jamesville Correction Facility, and that is simply wrong. And to best understand that, I think we have to look a little bit at history. We know one thing is for certain, as the court has already pointed out. The terms penitentiary and jail, they're the same thing under the correction law. There is no difference between the two. Now, historically, in Onondaga County, they got into a habit of calling the jail a place for detainees and the penitentiary for a place for sentenced people. And the responsibility for those two places was split between the county executive and the sheriff. And we know that at a certain point in 2017, that authority was transferred from the county executive for one of those facilities to the sheriff. So the sheriff now was responsible for both what was commonly referred to as the penitentiary and what was commonly referred to as the jail. Then came the law that we're here to talk about today, 1-2023. And what did the county legislature do there? It's why are we using these two different terms? There's no reason for that. The corrections law says penitentiary, jail, they're one and the same thing. And by the way, the sheriff has responsibility for both of them. So let's just make a law that says the sheriff is responsible for all the housed inmates, whether sentenced or detained in the jail. So that means if somebody is being held as an inmate in the Jamesville Correctional Facility today, that is a jail, and the sheriff has authority over it. And that's why he's still there doing that job as we stand here today.
And by the way, if you're a local court judge and you give somebody a year sentence, it's a jail sentence. It's not penitentiary sentence.
Exactly, Your Honor.
But be that as it may, it sounds like the way they did it with the penitentiary on Jamesville for sentenced inmates is it's just more convenient to have the unconvicted defendants downtown where the courts are. If you're sentenced, you're way out there. We don't need to bring you back and forth. Bail reform comes in. Nobody on misdemeanor gets held by law. Not a lot of felonies. So there's just no, it sounds like the purpose here was we don't need all this space anymore. Why are we paying for two facilities? Let's consolidate.
Exactly. And as the Court of Appeals pointed out, Your Honor, managing facilities does not require a referendum. That doesn't take power. It just changes the location where the power is going to be exercised. So the sheriff has the same authority today that he did before this law was passed, and he will have it tomorrow, and he will have it even if the Jamesville Correctional Facility is closed and all those inmates are moved to the jail facility downtown Syracuse. They're both jails under the new law. There's no distinction. They got rid of that archaic and unnecessarily confusing distinction. The sheriff has the same exact authority he had before, and under the law, no referendum, therefore, was required. Once again, as the Court of Appeals pointed out, managing facilities of the county is the county's responsibility. Now, my opponent cites the cases that are actually good for us. For example, she brought up a case here, the Santos case, forgive me, where the court actually held no referendum was necessary. The other cases that we cited all held no referendum was necessary in circumstances just like this one. And we submit therefore respectfully that no referendum was necessary here and this law should stand. And that's all I have unless any of your honors have any questions.
Hearing none, thank you.
Thank you.
Case 391 is Mary Patricia Allman versus Roswell Park Cancer Institute Corporation. We have a couple of recusals on this case. Justice Kane and Justice Curran have recused, and we have Justice Hannah will be joining us momentarily. So we'll have 4, which is enough to have a quorum. Oh, Justice Greenwood is here with us. Pleasant surprise. Okay.
Told you yesterday.
Hannah was on the. Yeah, I don't know what. See this. All right, we have Justice Greenwood and we have Justice Hannah too. Yeah. So we have 5 on this. We have a full court for you, Mr. Loss.
Thank you, Judge, and welcome to the 2 new ones for this afternoon. May it please the court, I am John Loss from Connors LLP in Buffalo, and today I speak for Roswell Park Cancer Institute in this medical malpractice summary judgment appeal. Simply put, the facts in the medical records matter. The facts in the medical records govern. In addition, likewise, anatomy matters. Where is it? So when we look at this case today, it's a situation that there was a nodule in a lung. So let's trace the factual chronology, which is kind of key here. Before the patient, Mr. Allman, ever makes it to Roswell, he's treating with his primary doctor. He's treating with another thoracic surgeon,
Dr. Durante, and then so he goes to your client and there's a suspicious nodule in the lower right area of the lung.
The lower right, and this is really important, the lower right lung.
And then the cancer eventually, he doesn't do the VATS procedure, doesn't get a biopsy, recommends screening once every year, which is a little shorter than he had been in the past. And then the next month in October or a little, month and a half, he has stage 4 cancer in another area of the lung. You say it's the center part. So any negligence with respect to not to get a biopsy of the lower areas, and there's no proximate cause, even assuming that there's some negligence.
I couldn't have said it any better.
So that,
but on
that brings us up to speed on the facts.
It does. It does.
You've got some issues. I think one of the big issues is the qualifications. Let's assume your experts met their burden. The qualifications of the plaintiff's expert. He's not a surgeon. He's an oncologist. Can he opine? Because we know the judge tossed out 2 of the claims, and now we have just this, the negligence, the deviations that's left is how frequently there should be screening, right? 1 year as opposed to 3 or 6 months.
Well, Judge, I'm always loath to correct you, but there were 2 claims and he threw out one of the 2 claims.
Okay, biopsy is still left.
So the biopsy's out.
Biopsy's out.
Surveillance is in.
Right.
And so I'm in a weird situation here because of course they have a cross appeal, but under your rule, since there's no rebuttal, I have to address their appeal before they do.
Right,
But
so
I'm
the
happy to do it.
biopsy is out. The court found that their expert wasn't qualified, but was qualified to opine on the frequency of the screening because he's an oncologist and so forth. So you say he's unqualified even to give that opinion, and then we can address their cross appeal.
Well, what I say on that is here's what we have. We have my client, Roswell is Dr. Hennon, who's a cardiothoracic surgeon. He's a surgeon. Their expert is an internist medical oncologist, not a surgeon. And I can't help myself because that's just who I am. But page 37 of the respondent's brief has what I would call a big Freudian slip. And I just can't help but bring it out. Because what they say on qualifications is that when you look at the qualifications of somebody, they say this is not a situation where claimant's expert is operating outside the area of his or her expertise and using the word operating, but of course he is. He's not an operator.
Counselor, their point is he's not criticizing Dr. Hennon for not performing the VAP procedure or maybe not following up from a surgical standpoint, the question is whether or not under those circumstances, given the patient's age, history, whether or not a biopsy would have been called for diagnostic reasons.
Well,
That's it.
There's two points. The point that the judge dismissed was, should there be a biopsy, the VATS procedure. So we have the VATS, the video
Well,
assistant.
wait, that's, I think, their point. They're not trying to suggest that it had to be a VATS procedure or anything else, but that at that juncture, when you have the nodule appear in December and then it triples in size in June and then it appears to disappear, these are extraordinarily red flags that you need to go in there and try to figure out what's happening. And a biopsy is a good tool to do that.
Well, except and I would generally agree with you, except the problem is there's nothing there to biopsy. There's nothing there to VATS. There's nothing there in October of 2018. And that's why the anatomy matters, to go back to Justice Lindley's point, is this. There's a nodule that might be there in December of 2016. So then Dr. Durante says, okay, come back 6 months later and let's look at this in June of 2017. And they do a CAT scan and they say, okay, we think there might be something there. So why don't you go back to see Dr. Hennon at Roswell, because you've seen him in the past.
Wait, June of 2017?
June of 2017. Yes.
Yeah, go back to see Dr. Hennon.
Go back to see Dr. Hennon in June of 2017. So in June of 2017, and right around that same time, Dr. Durante also gets a PET scan, and a PET scan hadn't shown anything either about this nodule. So they go to see he goes to see Dr. Hennon at an office visit at Roswell in July of 2017. And Dr. Hennon says, okay, if there's something new here in the right, I'm going to do a VATS, and a VATS is even better than a biopsy.
Sure.
So a VATS is more definitive than a biopsy itself. I'm going to do a biopsy. I'm going to do a VATS, and I'm going to do the VATS on August 7, 2017.
When VATS is, they put a little camera in there and it's
And they do a wedge resection.
and they go in and take a look with the camera.
And when they remove it and send it to pathology. So it's even better than just a biopsy, this VATS procedure. So he's ready to do the VATS procedure on August 2nd, and he does another CAT scan because the standard care says you have to do a CAT scan. And the CAT scan shows, oh my goodness, this nodule actually is getting smaller. This nodule is getting smaller. I'm canceling the VATS procedure, but I'm going to have you come back really quickly in September to look at this nodule again. And they look at the nodule again in September, and it's not there. It's gone. There's nothing there.
So his opinion is it's not cancer at that point. You think it's an infection?
It was an infection. I mean, cancer, if you have true cancer in your lung, it doesn't just go away.
Right, but
So-
they're oncologists who I know that you and your client think are, or not your client, but Dr. Hennon think isn't qualified, but they're oncologists. If I read his affidavit correct, it said it is not uncommon for these nodules, even if they're related to, if it's their cancerous, to decrease in size. And so that was, your client perceived that to say, okay, I don't need to do the VATS, I don't need to do a biopsy. Their expert says that's not infrequent. I think he may have even gone to say sometimes they disappear and reappear somewhere else.
Well, I don't disagree that that's what their expert said.
Right.
And I'm not going to get in a big fight that then Dr. Hennon comes back and says with literature that it's 1 in 100,000 and that's how rare it is. Because otherwise you're going to say I have an issue of fact here and I don't want to go in front of a jury. So here's, actually in front of a judge because it's court of claims. Here's the key though, Judge. That thing that wasn't there in August and then not there in September of 2017, and this is the real key to that, was not there in October of 2018. And that's why the anatomy matters. So what they're saying is, oh, you should have done surveillance, you should have biopsied, you should have VATS this area here, and you know what? The cancer was right here. In October of 2018.
Isn't that proximate cause, or is that both negligence and proximate?
It's both negligence and proximate cause. And you and I, Judge, you know, I've looked it up in all of these cases that it's interesting. If you read the table of contents, I cite all of the cases that this court's decided on med mal. They don't. And then in their responding brief, they don't cite the cases. You and I go as far back as the second Wilk case, 2013, you and I was here, argued Wilk too. That was
very fond of Wilk.
I'm very fond of Wilk. And so Wilk says, Wilk said, hey, you can't, just because you were said you should have done a test that incidentally would have found something else, that's not, we're not going to say that that's good enough. And then what you also said, the same panel, the same case, is the Ochino case in 2017, Justice Lindley, is this. In Ochino, the plaintiffs, the defendants meet their burden, and I think there's no doubt we meet our burden here on both, both points, under both malpractice and causation. And what happens in Ochino is the plaintiff's expert says, oh yeah, on this mammogram, there was something on this mammogram here. And therefore, because there was something on the mammogram, you missed it, and there's an issue of fact. And the court said, there was nothing on the mammogram. So same thing here. There's nothing, the area that we're looking at here, the right lower lobe doesn't exist in October of 2018. It's right here. It's this area here. So they lose on both points. They lose both on negligence under Ochino and Campbell. They lose on proximate cause under my favorite case, Wilk 2. And the other case they lose under, and again, it was you and I was going to say it was Justice Curran, but he's not here. So, but I'll still state it for you because it was you and me and Justice Curran. The Siemendorf case, where the court said, even if there's negligence, hey, you lose on causation because it's a loss of chance of cure or failure to diagnose case, and you didn't show it would have mattered here. And it wouldn't have mattered here because no matter when you got a chest CT, you were never going to see anything in the right lower lobe because there was nothing there to see. Simple as that.
You couldn't do the VATS procedure, isn't that your position?
Well,
you just couldn't physically do it.
What would they VATS it on? I mean, what are you gonna? There's nothing there to VATS. There's nothing there to biopsy, and that's just as a matter of fact in terms of if you get to the substance. And I understand the question before that is even that Justice Sampson reached and said, hey, their expert isn't even qualified. He's not a surgeon. He doesn't do invasive procedures. He doesn't know.
Well, I think what their expert says is that based on this record, there's a good reason to believe that the plaintiff had treatable cancer back in June of 17. And the reabsorption is a significant problem here, and that should have been followed up with some form of a biopsy. And the other issue that Dr. Hennon has is that I think it's Dr. Krifke, who says, yeah, in September, we don't see it here, but we need to follow them in 3 months.
Well, except again, when words matter, Justice Del Conte, because the radiologist says, no, follow up in 3 months because you might have pneumonia. Not because we think there's any nodule here. It's a pneumonia related aspect of it. And Dr. Hennon says, I don't think he's got pneumonia. I don't think he has to come back in 3 months. And you know what? He didn't have pneumonia. He never developed pneumonia. He never developed anything. So Dr. Hennon was correct. So when you're talking about, with Dr. Klitsky, Klitzke, the radiologist, he's talking about coming back in 3 months in case he's sitting here with the pneumonia. But I think
he's going to come back to Roswell for pneumonia?
Well, sure, because Roswell treats all kinds of.
No, I understand that, but that's the way you're interpreting that the follow-up recommendation for screening, where the plaintiff had been screening since around 2010 for about 7 years, no less than every 6 months.
Well,
that all of a sudden that follow-up meant only for pneumonia, so there was no. Dr. Krifke wasn't making a recommendation for follow-up as it relates to the cancer screening?
Correct. And I'll say for 2 reasons. One is that's what he testified at his deposition. And 2, because I think it was you, Justice Lindley, or maybe you, Justice Greenwood, the reason that the thing went away was because it was an infection. It was a pneumonia. It was something that was related. That's why it went away in the lower thing. And the other thing I do want to say, because I have to correct this too, Justice Del Conte, and I don't blame you because it's been perpetuated throughout the case by the other side. There was a CT on January 25, 2016. Then Dr. I don't know how to say his name, Jajowski, the thoracic surgeon, said, I don't need to see you anymore. The next CT was almost a year later on December 30, 2016. And they keep perpetuating that, there was never another time when more than 6 months went by. That is categorically false. and belied by the records. The CT, January 25, 2016, next one, December 30, 2016. See, this is what we're dealing with here. The facts matter. The real facts matter here.
Can I ask you this? If we, on the qualifications of the plaintiff's expert, he's an oncologist, and we know the court found he was unqualified to opine on some of on the biopsy because he's not a surgeon. He did hold in this screening cause of action. Your client there's at least an issue of fact when he said, come back in a year. You should, if we agree with the trial court that the oncologist was qualified to render an opinion on that deviation.
Or agree?
I'm sorry, if we agree that an oncologist is qualified, this oncologist was qualified to opine on the frequency of the screening.
Gotcha.
Okay?
Gotcha.
If we agree with the trial court on that. Again, the trial court said he wasn't qualified for the other thing, but just on that narrow claim, which is the only one right now that's surviving. Does that affidavit from that oncologist raise an issue of fact? Do you need to win on qualifications?
No, absolutely not. And I'm not challenging this. I mean, I think that there's a challenge for qualifications there, but I win if you say he's not qualified at all.
Yep.
But if you say he's qualified on issue 1 or the remaining issue of surveillance, screening, whatever you want to call it, no, I still win because on either negligence or no negligence or no causation. I win either under Campbell and Ochino, or I win under Ziemendorf and even like Page. Like Page, for instance, and again, lo and behold, 2019 is again you, Justice Lindley, on the panel. Page you said they created an issue of fact on negligence malpractice, but not on causation because the plaintiff's expert said there was a brain injury. And you said there's no brain injury. So there can't be a cause, there's no causation. Same thing here.
Their causation argument is that if you've been screened every 3 months, maybe I get that it wasn't in the area from before where the VATs are going to be done, but every 3 months, maybe we would have picked it up where the cancer actually grew.
Well, see, and the problem with that is that's what Wilk 2 says. Wilk 2 says you can't do that as a plaintiff and say, hey, if you had done you, Dr. Hennon, were right to say that this thing was nothing to be worried about. Because we know there was nothing to be worried about, even as of October 2018, because there was never anything here in October 2018.
Unnecessary screening here, you might have picked up something here.
Right. And so Dr. Hennon says, I don't have to screen for a year here. And he was right, because there was nothing there. And Wilk 2 tells us that that's not good enough. The incidental finding, when a physician such as Dr. Hennon correctly says, I didn't need to screen here, you can't then, as the plaintiff, say, well, gee, if you'd done this test that you correctly said you didn't have to do, you would have incidentally found something else, potentially.
Last question for me on screening and on anything here for you, because I kept up here long enough.
I'd stay here all day, Judge. I don't mind. I truly don't. I mean, this is what we all do for a living, and you got questions, I invite them. Go ahead.
The screening, he was being screened 3 to 6 months for a number of years, right? He wasn't being screened only in the lower left area or lower right area. He was being screened throughout. He's a heavy smoker. He had some history. So it wasn't just screening in one area. I guess could an argument be made that screening every 3 months, just as a general matter, even if he had never had any suspicions of the suspicious nodule in the lower right, should have been done anyways. And that would have picked it up in the other location.
Well, there's 2 points I want to make on that. One is, notice their expert says 3 to 6 months. And I always love this because, I'm sure you know Amy Ziegler. She does all the med mal up in Buffalo at the ADR and helps us settle the cases. And so she walks in and she'll say, hey, the plaintiff in this case wants between 150 and 200. And I'll say, I'm going to pick 150. Why would I ever pay 200? If the plaintiff's going to take 150 to 200, I'm the defendant, I'm going to pay 150. So throughout this case, Judge, they said, Justice Lindley, they say 3 to 6 months. Well, if I'm the defendant, I'm saying 6 months. If they say it can be between 3 to 6 months, I'm going to say that Dr. Hennon had up to 6 months to do this, number one. Number two is, and this goes back to what Justice Del Conte's point was, and the factual error they continue to perpetuate, is as of January 2016, they washed their hands and they said, follow up PRN, follow up as needed, and the next CAT scan wasn't even for a year. And the reason it happened at that point was because the plaintiff had gone, the patient had gone in and said, hey, I'm having some kind of an issue. I'm having some kind of, upper respiratory thing, and they got a CAT scan. So once they worked that all out, so remember now, in January 2016, not even Dr. Hennon, not even Roswell, it's Dr. Durrani and Dr. Mark, I'm going to call him because I can't pronounce his last name, Dr. Mark J., who's another thoracic surgeon, has nothing to do with Roswell. They say, we don't have to do any more follow-up. You can just follow up as needed, which is presumably a year, because then they get one in a year. So the same thing here. They work up all of this situation and they get to the point where this thing in the right upper lobe, the right lower lobe was nothing. So now we're back to really where we were in 2016. Dr. Hennon says, hey, we're back to where we said in 2016. It's now like in 2017, come back in a year. And the proof of all of that, again, Judge, to summarize, is there was nothing there in October of 2018. So at the end of the day, we met our burden. It should be reversed. So I'm going to ask this court, reverse the motion court summary judgment denial, fully grant summary judgment to Roswell Park, and dismiss the claim. And unless anybody has any additional questions, I will otherwise sit down at this point.
Thank you.
Thank you for your time.
Good afternoon, and may it please the court. Timothy Hudson Brown Chiari for the claimant, respondent, appellant. Your Honors, first of all, Roswell Park did not meet its initial burden, and the burden never shifted. It's a bit of a lesser point, but Dr. Hennon put in 2 affidavits, the first of which was wholly deficient on motion. It was objected to in the Court of Claims. The court considered it, but I would still submit to the court that the burden never shifted.
How is that insufficient?
His opinions are conclusory, Judge. He doesn't set forth what the standard was or how he satisfied the standard of care or why an annual
It's not insufficient because he's a defendant in the case, right?
It's not.
You can see that all the time.
That's correct. And this court's
and it's not
makes clear.
Self-serving. We see some, I mean, every affidavit is self-serving. So that, because I see that in your brief, that we're not worried about self-serving.
Well, I would say it's conclusory, Judge, because it doesn't say why a 78-year-old PEC per day or 78 PEC per year patient with cystic changes in his lungs, with nodules, with a history of odd things going on in his lungs, who's treating at Roswell for suspicious nodes, why he believes annual screening is sufficient. Doesn't say that in the initial burden, why that's standard of care. I would submit that on that alone, they fail on their initial burden, and that's it. Assuming they met their initial burden, there certainly are questions of fact here. And I guess I'll begin with Wilk. You know, my counsel here talked about Wilk and that this is an incidental finding. On the screening part of this case, it is not an incidental finding. It's not the Wilk case. That's I come in with kidney problems and doctor, you missed the aortic dissection. There's a standard of care that calls for 3 to 6 month CT or PET scans to make sure you don't have lung cancer at the lung cancer center that you're going to treat for, and you didn't do that. It's the scan that you give that would have caught the cancer. It's exactly on point. It's not incidental. It's why you go for the test in the first place. So this is not incident. This is, you didn't do the test that you are coming in for. It's the core of it.
But what about your opponent's argument that because the nodule had decreased in size so much that it was impossible to do a VAT test?
Well, the VATS wedge was taking off the lobe, but impossible to do a biopsy, Your Honor. At the time of the VATS test, it was still there that day. It was smaller, and then it shrunk in December of 18. Klitsky says that it may have disappeared. Our expert says that's not unusual, but there were other huge red flags here, like the sunburst appearance. The texture of the lungs are, big red flags for lung cancer. And it's not that there's a misnomer and misdirection here for the anatomy. When a biopsy finally is performed, it's of the lymph tissue near the lungs. And it's by that point, it's metastasized, and that's it for this poor guy.
So is your expert position that the lower right node led to the cancer in another location, the center of the of the lung?
The expert opines that he believes that may have been the origin point, but
It might have migrated somehow.
and that it did metastasize. But the key point here on causation, Judge Lindley, is that he opines that at the time that he presented to Dr. Hennon and the time even at the VATS procedure, that this was treatable and curable. And by the time they get around a year later, and it's a departure in the 1 year interval, and he talks about, it's not just ipsa dixit. He attached the Journal of Radiology and cited to other guidelines that's part of the cross appeal here to support this interval. It's well-known standard in the lung cancer field. By that point, by the time they finally get around to actually doing the tests and the biopsy in the fall and winter of 2018, it had metastasized and it's too late for this poor guy. But at the time they scrapped the VATS procedure, and the claimant is not faulting Dr. Hennon at all for on that day scrapping the VATS
It's
wedge.
biopsy, failure to do the biopsy in light of the scrapping of the VATS.
And that combined with, and the other deviation was, well, if you're going to do that, you can't do annual testing. It's 3 to 6 months. And as Judge Delcani had observed, when he goes in for the radiology at Roswell, there's an indication to follow up every 3 months. And in fact, there's other Southtown's radiology from 2017 when the mass had grown to triplet size that said, look, this looks suspicious, consider for biopsy. So that was there. And nobody faults Dr. Hennon for scrapping the wedge resection. And Dr. Hennon missed the fact that Durrani, his outside pulmonologist, they were kind of both treating care here.
Gave him antibiotics.
So that was going on. And then
how does your expert deal with the fact that I think it was September of 2017, the CAT scan showed it completely disappeared in the lower right? Completely gone.
That nodule, our expert says that that's not unusual, that it's not unusual for nodules to grow and shrink in size.
Disappear though?
Well, I specifically, I don't know about disappearing.
He didn't say anything about
but he said that the type, when he did see the nodule, the sunburst appearance, and that the changing in the size of nodules is not unusual. In fact, it's a marker for lung cancer. And I think at that point, we got a battle of the experts.
Right. So you want your other claim reinstated, affirm what the judge did to the limited degree and bring everything back in and go to trial on both claims.
I believe that's right.
All right. Thank you so much.
Thank you.
$393. We're waiting for a couple of judges, but in the meantime, $393 is Christy M versus Mercy Hospital, Buffalo. Good afternoon.
Good afternoon. May it please the court, Jason Britt on behalf of Mercy Hospital and the Catholic Health System. I think the starting point for this appeal is the idea that the plaintiff's theory of both negligence and injury dramatically changed in response to the hospital's motion for summary judgment. Prior to the motion for summary judgment, the argument or the contention by the infant plaintiff through his parents had always been that there was this isolate incident where the isolate.
Counselor, let me jump right back if I could to the initial bill of particulars.
Yes.
And there's an allegation in there that there was a failure or an omission to have a differential diagnosis for the cause of the infant plaintiff's possible seizure spasms.
There is reference to.
Right, that's there in the initial bill of particulars, correct?
That is in reference to a neonatal spasm is included in both bills of particulars. What's also included in both.
But that just so to cut to the chase here, that's what the plaintiff says is You want to, when you made your motion for summary judgment, you told the court what we were arguing. You told the court what our theory was, but that wasn't entirely our theory. Our theory here was broader, more expansive, and your expert tried to pin this down to just whether or not the child suffered a disability due to the temperature increase in the isolate.
Well, I think we have to take it one step further back in the line of pleading for that, if we're going to go down this analysis, and we'd have to look at the complaint.
Right.
And paragraph 9 of the complaint clearly states that the operative negligent act in this case was the malfunction or misfunction of the isolate. And that is on page 20 of the record, paragraph 9 of the plaintiff's complaint.
Well, what they say in the complaint is that there was a failure to avoid the injury to the infant plaintiff by failure to timely and properly, adequately, correctly assess and diagnose and treat the infant following the placement in the isolate.
Following.
Right, right.
Following is the key word. So that's where this case cleaves.
So what do you do when the plaintiff mother says that the child started spasming after he was placed in the isolate?
There's two, the following is the cleaving point, respectfully. The plaintiff's contention through its complaint, bill of particulars, and amended bill of particulars was that the operative event was the isolate, the overheating in the isolate, and that the surplusage in the bill of particulars that includes injuries and general failures to diagnose and things like that pertained to the isolate, was following the isolate. Paragraphs 3 and 4 of both the original and the amended bills of particular speak to vicarious liability for claims arising from the isolate, that incident. So the distinction here is that there's roughly a month between the birth and the isolate.
I'm not so sure about that. Because I think the child was born on the 31st. And then on the 2nd November, the child was placed in the isolate.
30th November.
30th, and then 2 days later, 3 days later, on the 2nd of November, he's placed in the isolate.
He's placed in the isolate on the 30th of November.
I got him being placed in the isolate on the 2nd, 4/20.
The isolate treatment is an intervention to regulate the infant's body temperature due to prematurity. The operative event where it's claimed that the isolate overheated occurred on November 30th.
I understand that, but the child was in the isolate for about 30 days before that.
Correct, but there's no allegation that the isolate malfunctioned until November 30th. So that's the operative point here. This is not a day between delivery and the isolate incident. I think that the infant was delivered at approximately 30 weeks, and the gestational age, or would have been the gestational age at the time of the isolate incident, was about 34 weeks. So there's almost a month in here where prior to the isolate incident, if you read the complaint and you read the first 2 bills of particulars, there's no allegation of mismanagement. The allegations in the bills of particular and the complaint are following the isolate. What my expert argued or posited was that the injuries, cerebral palsy, that plaintiff attributed to the isolate overheating were not attributable to the isolate overheating, but were instead non-negligent injuries either predating or related to birth.
Were there neonatal spasms before the isolate?
They're not diagnosed as neonatal spasms.
Right, but they didn't happen until after the isolate, correct?
The word neonatal spasm does not come into the record until, by my recollection of it, after the discharge from Mercy Hospital. The behaviors that are attributed to, later attributed, including by plaintiff's expert, to neonatal seizure or spasm were attributed to the
back, right?
That's once that's noted after this incident, but were attributed to respiratory disease, respiratory struggling, and GERD. So that's the claim here, which is this is not an isolate causes an injury. And then, we have this result. That's what plaintiff was originally claiming, that the isolate injury was the operative factor. Now, through this new expert affirmation or affidavit, they're taking this all the way back to the time of birth, saying it was an undiagnosed birth-related injury that, oh, by the way, may have been exacerbated by the isolate. That is a manifestly different case for the following reasons. Isolate is essentially managed by the nursing staff, observed the temperature, things like that. If it's malfunctioning, if the temperature is not right, that's something that the nursing staff should observe. The diagnosis and treatment of neonatal spasms or seizures, basically the precursors or evidence of cerebral palsy, is not something that is managed by the nursing staff. So this is an entirely different case. This is, if we were to compare it to an adult situation, this is claiming that there was a fall in the hospital because the nurses mismanaged a transfer. And then in response to the motion for summary judgment saying, oh, that head injury that we thought was attributable to the fall was actually a stroke 4 months earlier that the doctors missed. So it is that stark. And that's why, with our expert affirmation, the point was, and this idea that we didn't meet our burden, the point was that the injuries and complaints were explained not by an isolate overheating, as had been alleged all along by the plaintiff, but by cerebral palsy, which, what's key missing from the bill of particulars is there's nothing in there saying the injuries were birth related.
Well, we got to look at the bill of particulars, but when the bill of particulars says that there was a failure to determine the correct cause of the infant plaintiff's jerking movements and or head spasms.
But I concede with you that that's in there.
That's there.
But that can only be read in the context of
That's what you did, though. That's clearly your position and your expert's position. You read it in the context of an overheating isolate.
How else could I don't mean to pose a rhetorical question back to the court, so forgive me, but the use of the word following placement in an isolate in both the plaintiff's complaint and in the both bills of particulars in paragraphs 3 and 4 would tend to, I think, irrefutably say that the neonatal spasm, the neonatal seizure were injuries flowing after the isolate injury. Absent the isolate injury, the plaintiff's complaint and bills of particulars read as though we would have had an otherwise healthy, happy infant. Those are two completely different cases. And what happened here is that, well, first of all, if this had truly been about a failure to diagnose infantile spasms or seizures, you wouldn't sue nursing staff at the outset. You would sue the physicians. They waited until after the statute of limitation had expired to amend their bill of particulars, and they never amended their complaint, never even attempted or moved to amend their complaint to assert these claims against the physicians. The physicians are the crux of a case involving the failure to diagnose cerebral palsy. And they're nowhere in there. They're nowhere in the bill of particulars. There's no allegation that there was a failure to diagnose cerebral palsy. There's no allegation in the bill of particulars, I think, to get to your key point here, that there was a failure to manage a birth-related injury as opposed to an injury flowing and following from the isolate incident.
And you should begin to wrap up if you could, please.
Yes, I think the only other point I need to address is the sufficiency of the expert affidavits in response to the motion for summary judgment, which is, if we assume for purposes of this portion of the argument that the birth-related injury claim was not pled or particularized, and that this was an isolate case, as it always had been, then my papers and my expert papers offered the mechanism of injury, which was birth-related, rather than opposing that and saying, no, this was an isolate-related injury, as they had complained all along, even if those injuries had included spasm. Rather than saying that, they agreed with my expert and said this is a birth-related injury, possibly possibly worsened, likely is the word they used, and no real definition there, by this isolate incident. So the entire theory of the defense, based on what had been pled, was then adopted by the plaintiff, who's now saying, oh yes, this is a birth injury, and this isolate is perhaps likely icing on the cake. It's just an entirely different case.
Thank you very much, counsel. Let's hear from Mr. Collins.
Thank you, Your Honor. Contrary to defendant's argument, they failed to address each of the claims through their affirmation or affidavit of their expert that were set forth in plaintiff's amended bill of particulars, or indeed even the initial bill of particulars, compelling the denial of their motion for summary judgment under Bubar versus Broadman and its progeny. Contrary to defendant's argument, plaintiff's complaint did not limit her claims to one involving the overfeeding isolate. Rather, as Justice Del Conte already alluded to, in their at page 20 of their record in their complaint, plaintiffs alleged that the infant was hospitalized from November 1, the day of his birth, through January 25, 2008, that at all times herein mentioned, the defendants, by their agents, staff, and personnel, were negligent and committed acts of malpractice, and that specifically the defendants, by their agents, employees, and personnel, jointly and severally failed to exercise due and reasonable care under the circumstances in rendering care and treatment to the infant so as to avoid injury, and failed to timely and adequately and correctly assess, diagnose, and treat the infant following his placement in the isolate. So it's not confined to simply what happened after the isolate incident. It covers the entire duration of the hospitalization from the day of his transfer to the NICU. And as Justice Curran pointed out earlier today in connection with the Heinrich case, necessarily complaints, particularly in medical malpractice actions, do not have to spell out in detail, based upon the consultation with a medical expert, every element that the plaintiff will eventually want to prove at trial.
Mr. Collins, I remember saying that, and listening to your opposition here, it sounds to me like what they fear you're doing is you're claiming a birth-related injury for which the hospital is not responsible. So such that birth-related injury, as alleged, is the responsibility of a private physician, where the duty would be to a different person. So it's one thing to say, okay, a new theory exists, but here it's all medical malpractice. It's all against the same defendant. And as long as that remains to be true, I don't think you have to list the deviations of both particulars. But if you're seemingly shifting defendants and a duty owned by a non-party, doesn't that change the game here? And is that what you're doing? So two questions. That is that what you're doing? And if you're doing that, doesn't that mean that we got to look at this as a new theory?
No, we're not doing that, Your Honor. The allegations are that the hospital defendants, by their agents, personnel, et cetera, caused injury to the infant plaintiff over and above anything that might have resulted from his prematurity or any other malpractice that, which certainly doesn't seem to exist relating to his, obstetrical or pre-obstetrical care. And the allegations have always related to, as spelled out in our initial bill of particulars from 2017, as is commonly the case, a number of items, but they included, as already been alluded to, failing and omitting to have a differential diagnosis for the cause of the spasms or seizures that the infant suffered, failing and omitting to determine the correct cause of the infant plaintiff's jerking movements and head spasms, and failing and omitting to ensure that the infant plaintiff received proper care. And our expert at no time took the position that the injuries that the infant plaintiff has experienced since the time of his birth, are related to defects that were in existence or problems, medical problems in existence at the time of his birth. Rather, the expert opined that the failure to do a differential diagnosis and determine the nature of those seizures and spasms was a deviation from the standard of care, and that if it had been done, the infant could have been started and should have been started on anticonvulsants.
I'm sorry to interrupt you again, but when do we know, according to the record, when those seizures occurred?
The record indicates that certainly from early on, there were reporting that the infant showed signs of apnea, which were attributable to GERD. Later on, there were these, as testified to by the mother, these jerking, spasmodic movements, arching of the back, that again were attributed by the staff to GERD. And we know that following his release from the hospital and eventual hospitalization at Children's Hospital, it was immediately determined by staff there, that's not GERD, let's do an EEG. And the EEG established that, it was highly abnormal. And he was immediately started on anticonvulsants.
You mentioned differential diagnosis in order to explore the cause or possible causes of these seizures that you referenced. Who had the obligation to make that differential diagnosis prior to November 30th?
Prior to he at all time was under the care in the NICU of physicians, neonatal specialists, nurses, nurse practitioners.
As opposed to an OBGYN that may be private that delivered the baby or whatever.
Right.
So any pediatric care or intensive care would have been responsibility of the hospital.
Right. And he was in the NICU from, moments after his birth, because he weighed about 3 pounds, up through January 25th,
So once I'm probably oversimplifying this, and so please forgive me, it's getting a little late, but it sounds to me like what happened here factually from your perspective is that once the baby's born, the care of the baby is now tendered to the hospital staff.
Exactly, yes. And, I certainly, am not conceding that the isolate excessive heating had nothing to do with this, because it's our position that it did. And our expert, stated that given that increase in the temperature in the isolate on November 30 and December 1, that was a contributing factor to the prematurely born infant's neurological problems. But let's say that the isolate never even had overheated, but he was still exhibiting signs of spasms, seizures. There is still, as alleged in our bill of particulars, independent of the isolate theory, just a failure on the part of the NICU physicians and other staff members who look at that and say, something's going on here, something that's not just attributable to, stomach acid, that this infant, should be given an EEG. And that was not done. As I said, it was not done until he eventually went to Children's Hospital earlier than following year. So it's, and that failure to, properly diagnose and obtain the appropriate consultations for the spasms and seizures was alleged from our first bill of particulars, further amplified, but in our amended bill of particulars, but it wasn't created out of thin air. It was there all along and established, or at least supported by the record all along. And that, to reiterate, our expert medical practitioner said was, in and of itself, a deviation from the standard of care and a cause of the infant's, caused or at least contributed to the infant's problems, which is all that is necessary to establish, a battle of the experts.
Thank you. I'm just about up. Any last closing thought you want to share with us before we move on to the next case?
Yes, I mean, so I just want to reiterate that the defense expert basically ignored everything to do with the spasms and seizures. And for that reason, they didn't even meet their initial burden. And on the issue of the isolate overheating, our expert addressed that and again raised an issue of fact by opining different from the defense expert that it did, constitute malpractice to not monitor it properly, and that it did cause or contributed to the infant's neurological problem. So there are questions of fact here in the trial court's order denying summary judgment to defendants should be affirmed.
Thank you so much. We now call page 397 is Strelinsky versus a Bono Company, which are a corporation. Strelinsky is 397. Thank you for your patience. The numbers do not get here for 5 hours like this, and they do wait 5 hours. Or the will be a little bit longer than usual, but I know your time's valuable, so thank you.
Thank you, Your Honor, and thank you to all of the court for your patience today and for the opportunity to speak to you today, even at this late hour. My name is Richard Montez. I'm an attorney with the law firm Morlow, and the party I represent, the defendant Ford Motor Company. This case is the reason why Parker was put in place. This case is the reason why Parker requires that courts exercise their gatekeeping function to ensure that expert opinion testimony is based on a reliable scientific foundation.
Let me interrupt you right there. I understand that's what Parker says, but I don't see that as your argument on this appeal. I see your argument on this appeal as contesting primarily the sufficiency of the evidence. That is, I don't see any point in your brief, and maybe I missed it, contesting the admissibility of any of the evidence. There were certain objections, no question about it, to many of the offense approved by the plaintiff, a lot of which were overruled. But in terms of the gatekeeper function, I think we're well beyond that, and we're now looking at sufficiency. That is, we take the evidence introduced by the plaintiff, and we evaluate to see whether or not it is sufficient evidence. It's as though you're standing here at the end of the plaintiff's proof under 4404A of the CPLR. I don't see this as being our gatekeeper function, but rather evaluating the sufficiency of the evidence. Do you agree, disagree, and why or why not?
I disagree, because sufficiency is about foundation. It's about, does the evidence that's been presented, the data that's been presented, is it capable of reaching the conclusion that they are trying to reach? So when we look at all of that data that they have now presented, we are saying, even when you look at all that data, they are incapable of reaching the conclusion that they are trying to reach.
That's a sufficiency argument. And I know maybe I'm being too semantic here. Please forgive me if I am. But I don't see any contention in your brief saying the court should have sustained our objection to exclude this evidence. Correct?
Well, we argued from the very beginning, Your Honor, that none of this evidence should have ever gotten through because on the summary judgment.
Your brief in terms of a contention, I may have missed it. And I don't want to miss it because then Parker in particular would have application. I'm looking more at Junie in terms of controlling this case one way or another.
We've argued throughout this case, Your Honor, and we put it all throughout the procedural history and everything else that we've argued from the day one, that their expert testimony was insufficient as a matter of law. We argued it on the summary judgment motion. We argued it in the motion in limine. We argued it right before Dr. Canorak testified, and we argued that
use the word insufficient. That's where I'm stuck. I'm fine with that. So again, I'm probably stuck on the wrong issue, but I think your argument here is that the evidence as received and heard by this jury is insufficient as a matter of law, and therefore we should dismiss the complaint.
yes.
Okay.
Yes, and I think it's in some respect we're parsing hairs on the issue because it's the same evidence that we're looking at. At the end of the day, it's the exact same evidence. And the question is it capable of reaching the conclusion that they're trying to reach? That's what we have to look at.
Is the evidence stronger here than Julie and Lee Smith? Have they, at the place of filled in the gaps that were not filled in there? What is different about this that puts it over the hump where those were legally insufficient? But one other question about what you're arguing. You're challenging the legal sufficiency of the evidence, and that's what the defendants won on in the Court of Appeals. You're not arguing before us weight of the evidence.
Correct.
Court of Appeals can't reverse on weight. We can.
Correct.
So these issues, there's a lot of weight issues that arguably could be made. This decedent had made his testimony about his exposure to asbestos in the brake lab, the time in the garage was much more limited than it was at trial. Trial made it seem like he spent all day in there. For sufficiency, we have to assume the truth of his trial testimony, do we not?
Yes.
No matter how questionable we may find it.
Well, I think I would like to just draw a quick distinction on that, Your Honor, because it's the experts who are then analyzing his testimony and then being able to draw a conclusion based on his testimony.
Testimony as true, though. Don't we have to assume I find it hard to believe he spent as much time in that garage as he claims. He delivered parts, he's working at the counter, he's driving all over Buffalo, and then at trial, in his deposition, he's not there that much, and then it makes it seem like at trial, he spent all day, every day there.
I don't want to get too hung up on this point, Your Honor, but I do think you make an important point, which is if you're doing a scientific analysis, right, and I'm trying to draw a conclusion whether this individual, despite his exposures to many other forms of asbestos and in many other ways, whether he got it from exposure to Ford products, right, that expert needs to take into account, needs to do a rigorous scientific analysis. So if he says at one point it was less than 20 brake jobs and another point says 1,000, does the scientist then say, well, I'm just going to accept 1,000? No, the scientist would then have to, if they're doing a rigorous scientific analysis, say, let me think about that.
And the scientific analysis was done before the trial testimony.
No, it wasn't.
It wasn't?
I'm sorry. Yes, yeah. Their scientific analysis was done way before the trial testimony.
And the trial testimony was better for the plaintiff than this any deposition testimony.
The trial testimony was different. Yes. Yes.
Much stronger for the plaintiff.
And a scientist, though, looking at that would not simply just accept it, especially when his coworkers said that he did maybe two brake jobs a week.
All right.
So we have to look at, again, can you get to each step of the process?
You want to start with general causation and then we can work to specific?
Sure. So with general causation, Parker says that it has to be product specific. It has to be product specific. Why does it have to be product specific? Because a toxin inside a product may change. A toxin inside a product is not necessarily the same as when it's in its raw form. And therefore, you cannot presume that it has the same characteristics and the same effect. And what do you need to then show that the product within the toxin has that same effect? You need epidemiology. Epidemiology is the gold standard of proving causation. As the first department said, it's indispensable. Here, there are
this is just so we're defining that term. That means a study of actual human beings and their exposure in the past and what incidents of cancer arose from those actual human beings and their exposure.
Correct. And it has to be an epidemiological study that is searching for the answer to whether or not there's causation. There are different types of epidemiological studies which can analyze how much of exposure somebody has, but exposure does not equate to causation. You have to have epidemiological studies specific to the question of causation. And there are no studies, not one, that has ever found a causal connection between friction products and mesothelioma. Not one. And if the plaintiff says, but there are, I would ask you to ask them for the specific name of the study and the location of that study in the record, because
Mr.
none of the studies say that.
I think it's Dr. Kanarick cites some studies in his affidavit. Cites a number of studies there. Those in your view, when you look under the hood on those studies, that don't support his conclusions?
Not only do if you look under the hood, and I encourage the court to read, many of them are in the 4,000s of the record. I can give you the exact citations if you need them, but none of them draw the conclusion that friction products causes mesothelioma. In fact, 2 of them specifically say we can't reach that conclusion. It's too soon in the analysis, or all we're showing you is association. And in Cornell, the Court of Appeals made it very clear that in epidemiology, association is not causation, and you cannot have an opinion that is based on simply an association. Because at the end of the day, what you have is nothing more than a mere hypothesis. It's an assumption.
It's not enough to say that crystallite asbestos causes this injury.
Correct.
It has to be crystallite asbestos exposure in this type of work, in this type of how our plaintiff was exposed. Does that create this particular type of cancer?
Yes, it has to match the exposure, which is then where I'm going to transfer now to specific causation. First of all, before I even get into the details of specific causation, at pages 47 and 48 of their brief, they make a very important concession. On those pages, what they say is the difference, what separates this case from Nemeth, is that in this case, we provided FCC years as a measure of cumulative exposure. That's the difference between this case and Nemeth. But the first time that was offered was at trial. They had already formed their opinions without the FCC years, without that cumulative exposure. And it was the same opinions that they offered, that Dr. Moline offered in Juni, that the Court of Appeals found to be based on an unreliable foundation. It was the same opinion that the Court of Appeals in Nemeth in 2022 also found was based on an unreliable foundation. It was the same opinion that the First Department in Olson found, that Dr. Moline's testimony was based on an unreliable foundation. So they basically now admitted that when they showed up and they submitted their affidavit and they submitted their report in, by the way, 2022, after Nemeth had been decided, that affidavit wasn't sufficient. It was not based on a proper scientific methodology. And you don't suddenly become scientific when an attorney or somebody else hands you a number the night before your testimony.
And that, excuse me, that number came from Kanarick.
That number came from Kanarick.
And that Kanarick testimony was not previously disclosed. There's an objection to that, and that was overruled. So that testimony about the calculations of going from 0.04 to 0.2, I hope I'm close, was then given to the Dr. Moline, whatever her name is, and then she based her testimony on that. And that was sort of the difference maker, according to the plaintiff.
According to the plaintiff. So let me then get to the 0.04 part. The 0.04 comes from a study by an individual named Postenbach. It's at page 3080 of the record. What Dr. Postenbach did was he looked at a number of different studies of exposures to career brake mechanics and said, if I take an 8-hour day, they on average do 2 to 3 brake jobs. That is the 0.04 number. Okay. The plaintiff,
and our plaintiff was not in the garage all day, every day. This wasn't even his job.
Correct.
So you feel they just shouldn't have taken that 04 number and applied it to our guy who's in a different situation. And there should have been some discount on that, because there's probably not going to be a study on, honestly, ever be a study on what's the exposure level of people who work in a parks department that's adjacent to a brake garage, right?
Right.
I mean, there's never going to be that, and that would be an impossible burden that they talked about in Lee Smith and in Parker. You don't want to make it impossible, but maybe you take that 0.0 figure for people who are working 8 hours a day, 5 days a week, and you somehow discount it for the fact that they're in there all day, every day, and our guy claims he comes and hangs out every now and then. Is there should have been some discount on that, which
Yes.
then brings them below the threshold for exposure?
That's exactly right. And Your Honor pointed out earlier, should we take his testimony as is? He testified at trial that maybe he was there for 2 hours a day, maybe.
Counselor, I'm sorry, I don't mean, but that's not really what the issue here is, because whether she got it right or she got it wrong, that's different than whether or not the evidence was there before the jury. Because I think that's the difference here is what she fills in the gaps. And you may be right that they shouldn't have bought it for all these reasons, but they did. The jury did buy it. And that's the plaintiff's point, that she does take, it's a 1-2 combination where, and you may disagree with the studies that Heinrich was relying on in formulating his opinion as to general causation, but he did provide an opinion as a general causation, which is what supported Dr. Moline's opinion as to the specific, the qualitative exposure in FCC years for our plaintiff.
So you asked a lot of different things in that question. I think what I want to address, and if I'm wrong, I'm sure you'll correct me, is this really about weight, right? Is it about the ability for Dr. Heinrich to say, here's my number, Dr. Moline to pick it up and then say, you see, but we get to specific causation. And my point is that if you take his number, and this is what the Court of Appeals said in Parker and has said throughout all of their different line of cases, that number has to be related to him. And that number, as we just discussed, is not related to him.
Wait. That's not, that goes to this, the analysis that she conducted. Your position is her analysis was flawed. Her analysis was flawed because she didn't factor in some of these other conditions that were relevant here. But that's not to say that she didn't give that analysis to the jury so that the jury could, if the jury believed Dr. Moline, the jury could get the specific causation here on this set of facts that was before that.
But that's where the legal sufficiency piece comes in, which is a law question. And that's what the Court of Appeals did in Juni. That's what they did in Nemeth, despite the fact that the jury came back and found $16.5 million of a verdict where Dr. Moline said, based on this, and this, I can reach my conclusion. The court said, no, that's insufficient. They didn't knock her out under Parker. They knocked her out under sufficiency. Olson Court did the same thing, $120 million verdict, where she offered a number of these similar opinions. And they said, no, $120 million has to be vacated because it's not sufficient evidence to support what the jury verdict did, because you have to go to each piece and say, does it get you to the final conclusion? And so if the number that's being offered, the 0.04 number, is not his number, and I was going to answer your question before, you pointed out, should we take the testimony as is? He also testified that at most he was there for 2 hours. So let's now take that 0.04 number, which was based on 8 hours. Did anybody then say, well, maybe I can do some simple math and divide it by 4? I'm not even sure that's
right. Less, because he's not the one
exactly
next to the vehicles and the brakes, and they're doing other things rather than brakes in there.
You have to assume that every time he was in there, he was literally doing the blowouts. He was doing the blowouts, or somebody was doing the blowouts.
Other work than blowouts was being done.
Right.
Because the asbestos in the brakes, as I understand it, just being in proximity and handling it, that's not going to create the friction that you need.
That's correct. If you're just handling the boxes, there's no exposure. Their experts agree that there's no evidence that just handling the boxes. If you open the box, that's different. But if you're just handling,
get the friction with this high air compression that, you blow the air in there. Is this how it works?
You need to have something that loosens up either the material so that you have the release of fibers, or you have the blowouts. Yes, you can do sanding, sweeping, or the blowouts.
And the blowouts make a lot of noise, create a lot of friction, which seems to undermine that he's going in there to hang out and talk to people. Like, it doesn't even seem feasible.
Right. And again, Your Honor, I
agree with you, but
I'm willing to live with it, because a scientist would then question exactly what you're saying. Because a scientist who's trying to draw a causal connection is going to ask those questions. But you know what? She didn't. Because at the end of the day, her opinion is there is no safe level. that even low thresholds can cause. And she says that.
Testimony that got rejected.
That's
by the
exactly.
Court of Appeals previously.
Yep. And the last piece, I'm sorry, Doc.
Yeah, thank you. I need to simplify it for myself because I'm looking at the one part of the record with Dr. Kanarek testifying and where the math is being done by the plaintiff's lawyer. And I think one thing I'll ask the other side is when Dr. Kanarek says, I don't know how about accurate, but it is an estimate. That's sort of on a billboard for me in this case. But putting it aside, is part of your argument that even at 0.2, that is the 0.4 times 5 days a week, I think that's how they get there.
Mhm.
All right, so that's the best I could do
Yes.
on the math. But is your argument that even assuming the truth of the 0.2 applied to this plaintiff, that is insufficient as a matter of law to evidence specific causation for this plaintiff with that dosage to contract this disease? And if that's your position, why so?
So yes, that is our position. And here's why. Again, number one, that number is not specific to him. But number two, then let's say it is. Let's hypothesize that it is. What then is your next step in the data process of reaching a scientific conclusion? Your next step is to then say, well, let me compare that exposure to known thresholds that cause mesothelioma. Well, where do you get those thresholds from? None of those involve friction product cases in scenarios. None of those involve brake mechanics. What they do involve are mixed fiber types. So cases where individuals were exposed to amphibole, which is accepted as a more potent form of asbestos, and chrysotile asbestos. Now, Dr. Moline was specifically asked, do you know the ratio of amphibole to chrysotile asbestos in any of those studies? The answer was no. Now, they might say in reply, but Dr. Millett did some studies, and in his air blowout studies, he found some trace tremolite, less than 1%. So if Dr. Moline came in here and had said, or went to trial and said, in every one of those studies, it was less than 1%, then maybe you can draw the comparison to those studies, but she doesn't know. It could be 1%, 10%, 20%, or 90% amphibole. She does not know. And if you don't know, you can't draw that line. The only chrysotile study that they had, that they offered, was the Jang study. That case involved raw asbestos, individuals 10 hours a day with their hands, weaving it into textiles in the manufacturing process.
Was that with asbestos? Was that crystallite or was that?
Chrysotile, yes.
Well, yeah, chrysotile. How does the frostolite issue comes in? I understand if you're using brakes, the high pressure, that reduces the exposure. What was the testimony here on that, on the brakes with respect to frostolite?
Yeah, so there was testimony that it is converted, but there also was testimony from their experts that now that time has passed, they are questioning whether or not that's the case.
So we might have to accept on a sufficiency the testimony of their expert.
So from their perspective, I would say, because some of them have testified that, yes, maybe it's different, that at least as respects to this frostolite issue on the record, right, there's a question, but it doesn't change whether or not when it's cut, because there's two alterations before I would argue it's altered a third time into frostolite, when it's first cut, baked, and then encapsulated. Those are three alterations that occur. And that's why we go back to Parker. Parker recognized that when it's put into the product, it can change. And the only way we know whether or not it actually has that same causative effect is if you have the epidemiology
So
that
it had to
shows
be
you it
product
does.
specific. Benzene and Parker isn't enough. It has to be benzene and gasoline.
Correct.
But how about this? And the last question for me on this is throughout the Court of Appeals cases, both sides, there's the issue of, is the bar set too high on causation for plaintiffs to ever meet? Plaintiffs always say this is impossible, virtually impossible. The Court of Appeals said it's really high, but it's not impossible. You can do it. Matter of fact, Judge Garcia said this is how you do it. With our type of plaintiff who works in a parks department, I think you acknowledged before, there's going to be no studies with respect to exposure levels, right? For him, so they found the closest thing. Garage mechanics, 5 days a week, 8 hours a day, and they come up with this point of figure. If we say that's not good enough, for somebody whose studies don't exist, then it does become impossible, right? I mean, the plaintiff could never prove the case here. Would that be true?
Well, I disagree with that because they could have done real mathematical modeling. right? Not mathematical modeling where you're simply taking a number for garage mechanics, rear brake mechanics, and multiplying it by 5. They could have said, well, he was exposed to X percentage or for 2 hours a day, and they could have done the math.
Do mathematical calculations for it too, right?
Right, they could have done it. They could have done that. But also, let's go back to the garage mechanics, right? There's still no epidemiology that shows. So they're the bigger subset. They're the ones who are more closely to be exposed. If that science is not there, then they can't prove, even for this individual, right? That
Wasn't there 1 out of 21 or something that showed that there might be some exposure?
It was 2 that had questions about whether there was association, but never reached the conclusion on causation. I do want to address one last point because I know everybody's waiting to try to go home. Judge Curran, you had said on a billboard, there might be that word estimate. I asked this court to look at the Tippin case, which is cited in our reply. And the reason why it's cited in our reply is because it came out after.
Which case?
Tippin, Tippin. It came out after we filed our brief in this case.
Is that a first department case?
Yes, it's First Department 233 AD 3D 635. And what you'll see is that the expert in that case also did an estimate. And the court said that's not good enough as a matter of law, because an estimate is not specific to him. And it's also not enough for us to do a comparison to other studies in which we can then conclude that the threshold is sufficient to cause mesothelioma. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Joshua McMahon for the plaintiff respondent, Joseph Skorzinski. First of all, thank you for your time. Sorry I have such a dense case had to crop up at the end of the day. I know we've all been here for a while, but do what I can to be brief. I think we've discussed a lot of these issues in our papers.
So how is this better? How is this better than Junie and Lee Smith? How are your experts? How do they get over the causation hump that was not, the Court of Appeals did not feel got over in those cases?
Sure. Judge Junie, first of all, and I think this is important, Junie expressly states that it's specific to the facts of that case. First Department went out of its way to ensure that Junie was limited to the facts of that case. Wasn't intended to have broad applicability. But let's say that it does. Junie pertained to exposures that were limited to blowouts. It was dust that was generated after the product had been used. And in fact, Robey, in talking about Junie, mentions this. Robey says that Junie talks about studies specific to a particular product not being necessary, where the dust or fibers leading to the plaintiff's exposure was created not just by the use. Now, when we say that, we're talking about the blowouts. When you blow out a wheel well, it's after the brake has been broken down. It's after the brake has been used. That debris that's blown out is after the brake has been used. As an aside, there are studies and testimony in this case that say that there are significant levels of asbestos, I think up to 15% in that debris. But that aside, Junie, and as interpreted by Robey, when you're also talking about the physical breaking down of the product, not just the use, the physical breaking down. And let's not forget, we're not just dealing with blowouts. And again, he testified to 1,000 blowouts, 2 hours a day, 1,000 blowouts. He was present for 1,000 brake jobs, excuse me. But we're not just dealing with blowouts, we're dealing with sanding. Sanding occurs before the product even goes on the car. That process creates a lot of dust. And that's dust that's created from not the use of the product, the physical breaking down of the product. There's also testimony from his time at the parts department, his time driving, that there are visual white chrysotile fibers protruding from the brakes. Not all the asbestos from brakes is encapsulated, and that these fibers can become airborne just by handling the brake. Again, our client's testimony was that he unpacked boxes of brakes and brought them to the mechanics in the parts department. He testified that the dust that this process generated, not just the dust in the garage, from the blowouts, from the sanding, which he said wafted into the parts department, where it would, so the dust from the garage would waft onto the parts department, but also the dust generated from the handling of the brakes and the boxes themselves would settle on the desk, on the counter, the parts department. He said he'd have to wipe that down twice a day with a rag he kept specifically for that purpose. He handled brakes with unencapsulated asbestos that had dust in the boxes that a study conducted at a Ford facility in 1978 determined subjected workers who unpacked boxes similar to the plaintiff over an 8-hour period were subjected to 0.14 to 0.18 fibers per cc. Those levels alone are above those that Dr. Moline testified have been shown to cause disease, the 0.07 to 0.1.
Is that chrysolite asbestos?
Yes, but let me address Your Honor's point, because there seems to be some confusion. There's no difference when it comes to causing disease between chrysotile and amphibole. Our experts were clear on that. Amphibole
is there at least a dispute? I had read some in the studies and that chrysolite is less dangerous.
Justice Lindley, no question Ford disputes that. No question other asbestos defendants dispute that. But the science is clear, and it's an opinion shared by almost every major World Health Organization. Chrysotile,
the short curly fibers are just as dangerous as those long thin ones.
Chrysotile and amphibole both cause the disease, and not only
but equally dangerous.
I'm sure we could dispute whether it's equally, Judge, but I will say that Dr. Brody testified that there's no difference, but importantly for what we're talking about, he said that chrysotile fibers are actually, when it comes to peritoneal mesothelioma or mesothelioma of the peritoneum, that chrysotile asbestos are the fibers most likely to be involved when we're talking about peritoneal mesothelioma. And that's because of their small nature and the fact that they can make their way into the lymphatic pathways and bring and travel down to the peritoneum. So,
Counselor, I'm sorry to interrupt.
No, please.
Here, but what I'm curious about is how can you help us to clarify how Dr. Moline's testimony here or the methodology in this case is different than what the Court of Appeals rejected?
Absolutely.
Give me that, will you?
Absolutely, Judge. To read Ford's papers, one would seem to think that the Parker standard is somehow different than it was 20 years ago. Causation standard in New York has remained largely unchanged. Nemeth didn't change or elevate the causation standard.
It hasn't changed since Parker. Are you talking about Parker?
The causation standard in a toxic tort case, Your Honor, has been largely the same since Parker for 20 years. It's undergone virtually no major changes. There have been disparate applications, certainly, but that goes back to what we talk in our papers about the causation standard in Parker being necessarily versatile. No one has a time machine. We can't go back in time and measure every plaintiff that was exposed that happened 40, 50 years ago. But what Nemeth
harder
did,
with causation with these latent diseases, it's a lot harder.
It's
like the Parker is a lot harder for asbestos than it is with benzene.
it's extremely difficult, Your Honor. These are diseases caused by events that happened 40, 50, 60 years ago. All we talk about estimates not being enough. All we can do is estimate because we don't have a time machine. We can't go back and have precise figures. And that's why, to answer your Honor's question, Nemeth expressly reaffirmed Parker, and as such, it remains unnecessary to quantify exposure levels precisely or to use the dose-response relationship, provided that the quantitative and qualitative methods that the experts use to establish are generally accepted in the scientific community. Nemeth gave an example because Parker says there are quantitative and qualitative methods among others. But Nemeth gave an example. They suggested plaintiff in that case could have provided evidence of plaintiff's estimated exposure level from defendant's product as compared to an asbestos level known to cause disease. The expert in Nemeth didn't do that. There's also this unique glove box test that we can talk about, but to answer your question.
That's your point is you did your very best here to try to follow that. I mean, there may be some disagreement about the methodology, but the methodology here that was testified that was presented to the jury was an attempt to satisfy that burden.
That's correct, Your Honor. And in fact, these types of requirements that it has to be cristile or that peritoneal versus, these are all attempts to create the kind of insurmountable standard that Parker and its progeny has repeatedly warned against for the last 20 years. What we did.
But there was a couple, I believe counsel cited may reply, but there was a couple for department case in asbestos where that burden has been met. I mean, it doesn't sound like it isn't possible.
And I think Your Honor is referring to 3 post-Nemeth cases out of the first department. Tippin, we believe, is distinguishable, and I can talk about that, but the 3 that we think are more applicable are Seen, Sasson, and McWilliams. In those cases, plaintiff established causation under Nemeth in the same or similar methods as we did. We arrived at an estimated quantitative figure of Mr. Skrzynski's exposure. We did that, Dr. Millett did that, and Dr. Canarak, because again, we're not just talking about Dr. Canarak's 0.2 figure. Dr. Millett conducted studies of Ford's own friction products and comparing the plaintiff's description of his work with friction products compared to studies, his own studies with Ford friction products, determined that plaintiff's estimated exposure was 0.3 to 14 fibers per cc. Those are orders of magnitude above levels that Dr. Moline testified. And I know I'm kind of long-winded answering your question, Your Honor, but what we did in accordance with Parker and Nemeth was we provided testimony from plaintiff about his regular and frequent proximity exposures, to asbestos in Ford's products. We then, step 2, said and established that the asbestos that he was exposed to is capable of causing mesothelioma, and 3, that he was exposed to quantifiable levels, quantifiable estimated levels, because again, we can't be precise, nor is precise required, but quantifiable estimated levels of asbestos exposure as compared to levels known to cause disease. And that's what Moline did. She took figures from not only Dr. Canarak, but also Dr. Millett, and showed that those figures, the 0.3 fiber per cc to 14 fiber per cc's, or Dr. Canarak's conservative number, because again, all plaintiffs' experts agree that Dr. Canarak, taking the number from defense expert Postenbach's study that made its way into a 2020 EPA report that was in part expressly addressing the mesothelioma being caused by friction products. We took that 0.04 number, which grossly or certainly very likely underestimated his exposures, and using mathematical modeling, determined that Mr. Skrzynski's time-weighted average level of exposure, estimated, was 0.2 fibers per cc. Moline compared the 0.2 fibers per cc, as well as the estimated figures of Millett, to the LaCourte study, to the Rodelsberger study, to the Offerman study, and there's a 4th one that's, of course, escaping my mind right now, but those studies all show that between 0.07 fibers per cc and 0.1 fibers per cc are known to cause disease. Now, there's been this argument, right, that Dr. Moline's actual opinion was that that any dose, there's no safe level. No question plaintiff's experts gave that opinion. There's no question that Dr. Moline and the other 3 experts agree that even low-level exposures to asbestos can cause disease. I'll add that view is also shared by every major health organization in the world.
Would you agree that opinion is not enough under Court of Appeals case law?
I would agree that the Court of Appeals case law has said that, but I will say that simply holding that opinion doesn't mean she didn't also, using plaintiff's testimony, using comparisons to studies, using comparisons to Canarak's figure, doesn't mean they're not mutually exclusive. She holds that opinion, but she also used the estimated figures for Mr. Skrzynski and compared them to figures in the studies, and through her own experience treating patients with mesothelioma are known to cause disease. We did exactly what Nemeth asked for. We did exactly what Nemeth suggested. We followed Parker, and we followed the suggestion in Nemeth. I wanted to address Justice Cron, your point, and also Justice Del Conte. This is a sufficiency question. Weight. This is actually the first time I've heard weight with relation to this case is today. It's not a weight issue. It's a sufficiency issue.
They could have raised weight.
Excuse me?
They could have raised weight, but they didn't.
They did not. It's
'Cause-
not in their papers and it's not raised. It's a sufficiency question. And because of that, the standard is, was the jury's verdict utterly irrational? Was there simply no valid line of reasoning and permissible inferences which could have possibly led rational jurors to the conclusion reached? Ford may disagree with everything the jury credited, but it was in the jury's providence to credit what it did. And as long as it wasn't utterly irrational, this court must affirm.
Right.
Happy to answer any other questions that your honors may have.
Thank you very much for coming down.
Thank you, your honor.
The last case on the calendar is 399. Justice Kane is recused on that case. That's Seabolt versus 398. I'm sorry, 398. I'm sorry, I was wishful thinking. 398, Erlenbach versus Conjo. And Justice Del Conte is recused on this case, but we still have 4. Good morning, or good afternoon, late afternoon, should say, never been so wrong in the morning. Thank you, Mr. Lamb, is virtual and, you may proceed with your argument, sir.
Good afternoon, Your Honor. May it please the court, Robert Lamb for the Jacqueline Erlenbach, the plaintiff. I'm going to be very brief today.
Hey.
Well, I think the last time I was visited, Justice Hannah was being welcomed, and I think that I announced that that was my swan song.
You did.
I did, yes. And
something changed, obviously.
Yeah, well, I ran into Justice Smith and Justice Greenwood, and they said, don't retire. So I followed their advice. But in addition, Erlenbach kind of ran into the mix here. And I'm going to be very brief, and I'm just going to address one point and say to the court, fibrotic tissue is the only and a very thin-skinned excuse for this horrendous result. I really think that this harm speaks for itself. And I should also say that, again, the harm speaks for itself. It's the one exhibit that we put in is just not, it's just not good enough, satisfactory to show the jury the awful result that this poor woman received.
You wanted to have your client take off her shirt and show directly, and we understand that the photographs you say didn't do justice to how it looks. So we'll take a close look at that.
Yes, please. And thank you. And I will depend upon my brief, and good day to all. And thank you.
Thank you. Counsel, in your view, this is a battle of the experts. The jury heard from both sides here and ruled in your favor, and it's a heavy burden to get a jury verdict set aside. You wish to be heard further than your brief?
No, I think that's the case, Your Honor. The jury heard from Dr. Congelli extensively, as well as our expert, Dr. Court, rebutted all of the claims made by their expert, Dr. Mayer. I think, as you indicated, it's a high burden for the plaintiff to overcome that.
In a nutshell, not optimal results does not always equal medical malpractice.
Right, and that's specifically read to the jury in the charge. As far as the point Mr. Lam raised, the picture versus displaying the injury to the jury, I think that was well within Judge Antonacci's discretion. And I also want to point out that the plaintiff's expert never asked to examine Mrs. Erlenbach as well. And if it was so important, I think that he would have asked to examine her as well. I can answer any questions you may have.
Thank you, and thank you for your patience.
Yeah, thank you.
All right, now our last case, 399 Seabolt versus Spoonley. Justice Kane has recused. Justice Del Conte is back, and we still have Justice Ogden, who's a trooper. She's been there all day. Mr. Jacobson is here, and counsel as well. Ms. Tillafaro.
May it please the court, Frank Jacobson from Ralph Larigo's office here on behalf of the estate of George Flattery, Kathleen Seabolt, the executor. In this case, this is kind of like a two-part case. We had the original motion argued on the motion papers to vacate the judgment, which then went on to a hearing. First 2 points deal with in my brief, deal with the actual motion papers. I'm going to really skip over those 2 points, just address them extremely briefly, because it's really a question of sufficiency of those papers, which the court can look at those papers themselves. The papers didn't set forth a sworn denial of service, didn't set forth a reasonable excuse, didn't set forth defenses. So those papers were completely insufficient. And for that reason alone, on the papers, the motion should have been denied as a matter of law. The judge decided to have a hearing. We went on to the hearing. We get to the second 2 points. The court completely upended the law with its decision here. This is a case dealing with CPLR 308. The court, first of all, this is point 3 in my brief.
Mr. Jacobson?
Yes.
And you've waited here all day. I don't want to steal your thunder, but I've got a few questions for you. If you want to keep talking and then get back to my questions, I can wait. I certainly will respect that because you've been here, both have been here all day long. You're last to be called. So,
Your Honor, I love being last. This is not the first time that I'm last. It's always civil calendar is last, and I seem to always be last because, hey, we want to all get out of here quickly. So
you have to start doing criminal appeals and then you get first.
Ask away, Your Honor.
You know, you've been in front of this court a lot. I mean, we really make an effort to know the briefs, know the record. So I'm sure the panel's all teed up to go. But for my part, I'm not so sure that I entirely agree with the analysis that the Supreme Court on the conflict of interest issue. I've read all those cases. The first one was written by a very beloved judge down in New York City by Marty Evans. Well-written decision. There he recounts the conflict between the husband and wife vis-a-vis the jointly owned bank account that would be used to pay only the husband's debt. And under the law, the city of New York being the one seeking the money there would clearly be in a position to recognize that that's a conflict between husband and wife. And the other cases all seem to refer to like a protection order of which the plaintiff or whoever is seeking to enforce the default was aware. Here, there's no evidence that I see in the record that your client was aware of any purported conflict between Shane and the parents. So I'm not so sure I buy that analysis under that. That's maybe where you were first going. But putting all that aside, let's assume you're right on jurisdiction, just for the sake of argument. And this is where I'm struggling. Given the testimony at the hearing from at least the mother and the affidavits from the parents, it just strikes me as potentially just that for these parents who were deprived of any knowledge of this lawsuit. I mean, Shane even testified he took the mailing out of the mailbox, is how I read it. That he didn't inform them of the lawsuit, that they didn't know about it until their bank account got executed or something like that. So that all sounds kind of somewhat a reasonable excuse. I must say, respectfully, I didn't see any cases cited for that proposition in the brief about reasonable excuse being where the service is being hid. Sorry to go on, but that's what's on my brain. It's primarily reasonable excuse for the default. But you argue that there was ignorance of the law. That's not really their argument, but you don't really address this action of Shane hiding things from him. That's really what's troubling. That seems fair to vacate the default here because of the reasonable excuse. That's what's on my mind. Maybe I'm too late in the day here to hold back. Go ahead.
And Your Honor, that would have a different result. The reason that we're here so importantly is actually because the dismissal was based upon jurisdiction. Okay, so saying that there was a lack of jurisdiction. Okay, so that means that the lawsuit itself has to be thrown out. Now the statute of limitations may or may not be gone, and that's a very bad thing because this is now 4 years later after the whole case has really been started. Because and again, I'll even go back to what happened here. It's incredible to believe what they say. Okay. They still live with their son. They still live with their son to this day. And if your son had just exposed you to $220,000 worth of judgment, that's peculiar in itself. But this wasn't just hey, we served you here, we mailed it here. There was a dozen different proceedings, including them signing exemption forms, saying that their assets were exempt with their signatures on them. So they're well aware of after the fact. Now, we're not talking about the summons, which is obviously very important, but they buried their head in the sand. And when you get to the reasonable excuse, there's not only is there no case law cited, there's no facts cited really in the actual papers. Okay.
How about
their reasonable excuses were.
How about meritorious defense? I mean, they seem to say we didn't sign anything. We don't know anything. You know, we didn't co-sign it, didn't guarantee it. Are you okay? This is really reasonable excuse.
This,
right?
well, it's both. Okay, but you can't just summarily say that. They have Shane. Why isn't Shane submitting an affidavit? You have to put forth, you have to plead and prove your reasonable excuse. You have to plead and prove your, some proof beyond mere allegation. They have an allegation. We didn't take out the money. Okay. Everybody can say that.
You know the record, Bernard. I thought the parents had an affidavit that says, we didn't borrow this money. We didn't co-sign it. Our name's not on anything. How do we owe this? We don't owe this. And plaintiff in response says, I'm expected to come back. No, here's a guarantee, or your name's on the loan. You co-signed it. I don't know where that leaves us with that, but I agree with Justice Kern. This really comes down to reasonable excuse, and you're raising some good points that I hadn't thought of.
And back to reasonable excuse, they really raised in their papers and in this appeal, two, which was, we didn't know what the law is. Well, in order for that to be a reasonable excuse, you had to have known about the lawsuit. Okay. But we did.
Mr. James, case law you cited, in fact, we have a case that cites to the one you cite in your brief. If it was simply that they were trusting their son to take care of it, that's not a reasonable excuse. Right. I get that. But the question is the sort of the equities here. So I want to get back to the point you made. So you saying at this point your case is like with prejudice over?
It could be. There hasn't been a motion to dismiss, but I've been expecting a motion to dismiss, and probably as soon as this is over.
But I thought the case was dismissed for lack of jurisdiction, is what you just told me.
It was not. The judge didn't take that step and actually dismiss it. This case is still pending, and we're going through discovery on this case, even notwithstanding the fact that the judge ruled that it was jurisdictional.
Isn't there that section of the CPR that says if it does get dismissed, you have 6 months to go back at it or something like that?
That's not in this type of case.
It's been a while since I practiced.
You don't, not when it's jurisdiction. Jurisdiction is, however, potentially 306B might have also an interest of justice timeframe to reserve it. Now that they changed that statute, that's actually a pretty recent change that they changed 306B so that you can show interest of justice. But that's kind of the point. If the court were leaning towards something and it would be an interest of justice just vacating, which has its own elements to it, rather than 5015 or 317. Those are really not applicable, I don't think, just because of the elements that have not been pled or proved in this case. Interest of justice has totally different ones that, again, still haven't been pled or proved. But again, it's incredible, especially what happens during the lawsuit, before they get a judgment, that after the judgment, seizing bank accounts, claiming exemptions, money's gone, over $30,000. They don't challenge the judgment at all. Then months later, they decide to challenge the judgment when we start going after their actual real estate. But be that as it may, I see the court had at one point said that a process server must be certain which address one resides at before performing substitute service in a shared space. That is not in the law. That is not in the statute. 308 sub 2 merely says a person of reasonable age and discretion at their residence. That's who you have to serve, or a place of business, but in this case, a place of residence. That's what you have to do. The lower court put in this knowledge requirement. That process server now has to know that this is the house. Well, it's undisputed in this case that service was made at their residence. Both Shane, the only people that testified was the son, Shane, and the process server. They both testified that the process server is approaching the porch of the house. Shane comes down and 3 feet from the house, he hands him the papers. Within the curtilage, if you want to get into the legal mumbo jumbo, but it's undisputed that they're at their house. They served it. There's no requirement that you know that that the process server knows that that's their residence. It happens that even if he didn't know, which he did because he'd already looked at the other house, seen that it was gutted. But even if he didn't know, he happens to have given it to them at their residence, proper service. I think I've already addressed point 4 because Your Honor already asked the questions. As far as that, chemical bank decision and the distinction between that case and this case really is benefits and detriments. All of the cases that were relied upon by the court was about benefits and detriments. In that case, the wife had 0 liability, the husband had liability, and the money belonged to them both. If that was applied here, you would have to say, we weren't suing the parents. The parents didn't have liability, and he did have liability. But here we have joint and several liability. Shane's liability was not increased or decreased if by hiding it from the parents. Their liability was not increased or decreased. So this chemical bank case has no applicability. I think House really is the case that determines both, which is you can serve a co-defendant even outside the house. Okay, that was the House decision. And you can serve a co-defendant because the court's reasoning here would say anytime that there is not an absolute unity between the defendants, you can't serve a co-defendant. That would be every co-defendant because, hey, I'm going to hide it from this co-defendant, so they go after that co-defendant. That's not what the law is. The law is specifically, as enunciated in House, that you get that a co-defendant is absolutely a person of reasonable age and discretion. The lower court should be reversed. Thank you.
Thank you.
Afternoon, Your Honors, and may it please the court. My name is Allison Tuflero on behalf of the respondents, Guy and Carol Spoonley, and I'm coming from Fallscraft and Buffalo today. So this case boils down to the service of process issue here, really. The respondents were never properly served with the summons and complaint before the default judgment was entered against them. And regardless of whether or not they had notice of subsequent filings or anything else that happened, the garnishment afterwards, if there is no proper service of the summons and complaint from the get-go, then the court does not have personal jurisdiction over the case. So any judgment, order, whatever that is entered by the court without personal jurisdiction over the defendants is null and void as a matter of law. So an affidavit of service, of course, it provides a rebuttable presumption of proper service, and that rebuttable presumption can be rebutted by a sworn statement of denial of service by the defendants, which also, through the case law we've seen, which also lists the specific circumstances and facts surrounding the reason that they believe they were not properly served. So in this case,
Counselor, could I?
Yes.
I want to ask Justice Kern's question to you. In this case, how would the plaintiff here have had any advance notice of the conflict or the differing interests between the son and the parents when service was completed?
Well, this was something that was not available information to us at the time that we drafted the motion to vacate the default judgment, but we've since conducted depositions, and the plaintiff, Mr. Flattery, the initial plaintiff, lived across the street from the respondents. They know each other personally. He also was the employer of Shane Spoonley. Shane.
But are we adding it? I mean, are we adding another burden here that in order to complete substitute service, you have to somehow do some kind of due diligence to make sure there isn't an internal conflict between the, I mean, isn't that almost an impossible standard to complete substitute service?
Well, I think we're focusing on the conflict issue, which really has to do with a reasonable excuse for the default and the meritorious defense. Or sorry, no, that has to do with Shane's discretion to accept service on behalf of the defendants here. So the court, so my opponent has gone through the cases and the different courts analysis in different cases, stating that in certain circumstances, certain co-defendants have been deemed of suitable discretion in certain cases based on the facts there. But the thing that differentiates our case here is that Shane Spoonley had an adverse interest to the defendant or to the respondents, and that he stood to have his own debt repaid out of his parents' bank accounts and assets because he was insolvent. So it doesn't matter that there was joint and several liability here because the burden would have fallen and actually did fall. We don't have to speculate on his parents to satisfy the default judgment when it was entered against all three of them jointly and severally. Shane doesn't even have a bank account under his name. So, I mean, the lower court determined that in this particular circumstance, it's not just the fact that he has adverse interests. It's also the fact that he lied to the process server about his identity. When the process server initially attempted substitute service on Shane, he asked Shane if he was Shane Spoonley, and Shane said no. And then when asked what his name was, he said Michael Spoonley, and he identified himself as Shane Spoonley's brother. So the fact that he felt the need to lie about his identity to the process server was another factor that the court weighed in determining that he was not of suitable discretion in this particular circumstance to accept substitute service on behalf of his parents. And, then just the facts from there just speak for themselves. I mean, Shane admitted at the Travers hearing that he intentionally withheld the lawsuit from his parents, initially the existence of the lawsuit, and then he lied to them when when everything happened with the bank garnishment and they were trying to figure out what was going on. He lied to them and basically told him, oh, this has to do with, the money I owe to Mr. Flattery and I'm taking care of it. And the parents, I know it's not, ignorance of the law is not an excuse. And but they were not initially aware of that they were defendants in this lawsuit. And they also were just confused about the entire situation because their son, who doesn't have a bank account, was telling them that, they got wrapped up into this whole thing because Mr. Flattery was trying to get back the money that he owed to Mr. Flattery, and that he was taking care of it and he was going to get their money back and he was going to pay the money back to Mr. Flattery. And, it's not that he was telling them, oh, you're defendants in the lawsuit and I'm taking care of the lawsuit. He was telling them, they had never seen the summons and complaint. They didn't necessarily know that they were defendants in this lawsuit. He admitted that he intercepted the process that was mailed to their house and hid it from them, and then lied to them every step of the way for months on end, including after their bank account was garnished. He continuously just kept telling them that he was going to take care of it and pay back the money, and they didn't have to worry about it. It was at the point that their sheriff's sale was going to happen of a piece of their property that they decided to go to an attorney. They retained my firm.
Kind of get you to at least for me, my ultimate point. Did you find any cases, because I don't think you cited any, but I mean, I can't find any cases where a reasonable excuse for default would fit this fact pattern That is where a co-defendant was not told about the case by somebody else. I mean, that it strikes me as maybe there should be case law out there, but I can't find it. And it looks like you can't either. So if we don't have cases to hang our head on, how do we find reasonable excuse here?
Well, it's not actually required to show in a motion to vacate default judgment based on lack of personal jurisdiction because of insufficiency of service.
I'm beyond that. I'm on reasonable excuse for the default. I couldn't find any cases, nor do you cite any in your brief, showing that this fact pattern would be a basis for finding a reasonable excuse for default. That's my question.
Well, we don't cite any cases that specifically have, the same fact pattern as the one at issue here, but it is, a strange fact pattern. And
There's no cases saying that it is a reasonable excuse. There's no cases saying it's not. Sometimes there's just a case of first impression, and there might be a case coming out of here that says yes or no one way or another.
And, on that point, I will rest on my brief in the interest of getting out of here. Unless you have any other questions for me that I'm happy to answer.
Thank you.